Could you please tell me your client's name again and the case numbers, because it's not on my docket, I didn't write it down. Okay.
Kayla, K-A-Y-L-A-H, Tidwell, T-I-D-W-E-L-L, and the case numbers are 2021 CF 2675, 2022 CF 1536.
Oh, it's a motion for early termination?
It is.
Okay. And is the motion opposed by the state?
It is at this time, yes.
Yes, Your Honor.
Okay. Well, in that case, then let me go ahead and schedule Ms. Tidwell for May 20th. I also have the morning of May 22nd. I have some hearings scheduled on that day, but
May 20th is fine.
I think we can double book it. I also have Thursday, day after tomorrow, afternoon. I don't know if that's too soon.
I would have to get with Mr. Prophet to see if he is available,
Okay.
but I will do that.
Okay, so May 20th
At
is?
9 a.m.?
Yes.
Your Honor, I'm handling two cases for Cassie Reed. The first one is Fisher Koch, K-O-C-H, 24 CF 2072. The state and the defendant have signed a PTI agreement. It's going to be without a plea, so we just need a control date to make sure that that goes through.
All right, that would be June 9th. And that's simply to make sure that the agreement gets filed. And if so, then we could probably cancel that date.
Yes, ma'am.
But that's just to make sure that the agreement is in the court file.
Understood. And then William Hunter Gise, G-I-S-E, 24 CF 2192. Ms. Reed received the final restitution amount yesterday afternoon. This is going to be a PTI with a plea, and we just need a court date to come enter the plea.
Is May 24th, or I'm sorry, not May, April 24th, that's 2 days from now. Is that too soon?
I don't know, has the plea been signed?
I can send over the PTI today.
Let's set it for Thursday, and then if, I don't know where the client is, but I'll try to arrange that for Thursday at 1:30.
It would actually be around 2:30 or possibly at 9. Let me make sure I'm not going to give you the wrong date.
9 o'clock will start with you, and then 2:30 with Lacy.
Okay. You can have either 9 or 2:30 on Thursday.
2:30 on Thursday.
I can't promise you it'll be right at 2:30. It'll be after arraignments.
Understood.
So it could be a little while after that. But April 24th at approximately 2:30, and that would be for a plea.
Thank you.
Sure.
That's all
and
I have.
If you need to reschedule that, if that's not going to work, then we'll have to put it on probably May 20th.
Yes, ma'am. Thank
Okay.
you.
Sure, thank you.
Bye-bye.
Mr. Weinstock, is he present, or is he still outside? Okay. Mr. Swiatek? Still in the hallway? Mr. Gilbert? Still in the hallway? All right, Mr. Dyram? Also in the hallway? Okay, who's here? Mr. Patel, you're next.
We can do Jared Stevens' case, Judge. This is
Sure.
easier, one of the two.
Let me get my paperwork before you start. Okay, 21 CF 3196, motion, second amended motion to declare defendant indigent for costs.
Correct, Judge. Jay Patel and Tim Shaw on behalf of Jared Stevens were before the court on our second amended motion to declare Mr. Stevens indigent for cost. This is challenging because this is the first time that I've had to go through the JAC for cost, and so it's just been, it's not been as smooth as it could be. I have an email correspondence from the Assistant AG, Christian Lake, that he would like the court to review as his formal response. Ms. Sandler has reviewed this. May I approach?
Yes. Thank you so much.
Cody Sprouse on behalf of the state of Florida.
Christine Boss on behalf of the state.
All right,
Rachel Gaynor on behalf of the state, Your Honor.
all right.
Jessica Jardina on behalf of the state of Florida.
Michelle Sandler for the state of Florida.
All right, and Ms. Sandler, are you on Mr. Stevens' case?
This is my case, Your Honor.
Okay, wonderful, thank you. What's the sentence that I just named out? I also took into consideration the charge, and the charge is obviously very serious, and the length of time that your client's been incarcerated, which prevents him from working and earning income. Let me ask your client, I need to place him under oath and make sure that his application, it's sworn, but I just want to make sure that it's accurate. So, sir, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do. I do. Thank you, sir. You can put your hand down. I'm looking at your application for criminal indigent status. It's dated, I believe that's April 19th, 2024, but I can't quite make it out. I think that's what it says. Sir, has your financial situation improved since you submitted this application a year ago?
It hasn't.
I'm sorry.
It hasn't.
Okay. And is the information that you put on this application true and correct?
True.
Thank you. It says you have no income and no assets. Is that accurate, sir?
That's accurate.
I saw in the affidavit that your family has been paying for your attorneys. Are they able to help with the costs for the experts that your attorneys would like to hire?
It's possible, but I'm not sure with the communication.
Okay.
Judge, I can tell you, I've spoken to his mother and his sister. They can't even pay our fee, much less an expert.
I saw that there was still fees due, so. Okay. I will grant the motion. And I saw in the motion that, Mr. Patel, you had laid out the rate and the proposed cap. So please put all of that in the order, just like what the JAC wanted.
Yes, ma'am.
And I'll be happy to sign that.
Judge, I believe that we, two
Need-
Mondays ago, we set it today for kind of a status conference to see where we go. At this point, I think continuance is appropriate to the next pretrial, and then at the next pretrial, we should be in a position to schedule the stand your ground. I know that I've advised Dr. Berkland's office that we need to fast track this analysis and get where we need to go, and he said that he didn't have a problem with that. So I've got a call set up, hopefully in the next 2 days, to speak with him to get an update based upon the court's ruling.
How long did you need for your stand your ground hearing? You've told me and I didn't write it down.
Sure, it's going to be a full day.
A full day, okay. Have you already reached out to Amanda to try to get that reset?
Not yet.
Okay,
I figured based upon our conversation that we've had, that we'd look at using one of those trial dates, because we know that this hearing's gonna go. We just gotta get it scheduled.
and do you need those expert reports? Is that relevant to your
It is.
stand your ground?
Surely relevant.
Okay, so we have to do it after you get all of that?
Yes, that's why I insisted on Dr. Berkland's office to be able to fast track the review of all of this.
When you say fast track, do you have any idea what that means? Like, what's an estimate?
So he couldn't talk about the case until after the court grants the motion, so that's why I'm having a meeting with him. But I indicated to him, I told him that I want to be able to have the stand your ground hearing around that June, July timeframe. And so I need you to get your work done if you can do it. And he said that he'd be able to get it done. So I'm hoping to have something done from his office by the end of May.
Okay,
So we're working diligently.
okay. I'm just trying to figure out where on the calendar I need to be looking for time. Let me go ahead and ask the state, all of the state attorneys that are present. And I know this is way out and you don't have a crystal ball, but right now, do you know of any cases that you plan to try in June that would take an entire week or more? Because I'm probably going to have to give up one of our trial days in June for this hearing. But if you knew right now you've got a trial that's probably going to go and it's going to need a whole week, then that'll help me figure out when to schedule this hearing.
Your Honor, the only thing I could think of potentially would be maybe one of, or two of the FDLE cases, but I don't think those would just be a couple days long. It wouldn't take a whole week.
Okay.
Judge, can I ask you something?
Sure.
Are you busy the week of the 30th? I know there's a week between the trial weeks.
You mean June 30th?
Uh-huh.
I am the duty judge, so I'll be on call, but I can work around that. In fact, I wrote down some of those days.
Could we maybe settle on like July 2?
Let me look at it for a second, because I do have a few civil hearings scheduled that week, so let me just take a look. I'm also covering first appearances that week, so I couldn't start right at 9. How does Thursday, July 3rd look?
Fine by me.
Really? Okay, Mr. Shaw, how do you look for that day?
I'm open that day currently, depending on what happens. But I'll keep it voice.
Okay, so I have first appearances, and I also have potentially pretrial detentions. That would be at 12:30, and I'm also the duty judge, so I'll have to take a few breaks during the day to take care of those warrants and petitions that come in, and that's typically late in the afternoon when they really start piling up, so
Okay.
just to let you know.
And Your Honor, the state's available that day as well.
Great, okay. Then all day, July 3rd. That will be for the stand your ground hearing.
And Judge, do you have any availability on the 2nd? The only concern that I have is because you're so busy with other obligations, I really don't want this to then have to continue it like a month later. I don't mind breaking it up over a
Okay.
couple days, but I think that it's in the court's best interest and my client's best interest that you be able to make a decision, having heard the evidence.
I agree. So here's the situation for that week. I'm the duty judge all week, and I also have first appearances all week, so that prevents us from starting right at 9. On June 30th, I have a civil hearing at 11. On July 1st, I have another civil hearing at 11. And on July 2nd, civil hearing at 11. So what I could do on any of those days, if you want to move it up a little earlier, I would just have to take a break. We could take an early lunch or whatever you want to do, and I can handle the civil hearing at 11. So that's going to give you about an hour and a half in the morning once I finish first appearances until I have to take the civil hearing. Then we come back and then have the afternoon. Keep in mind, I'll have to take a few breaks to do warrants and petitions.
I think we just work through that. Judge, I think we just work through it.
Okay, so let me see what Ms. Sandler has that week. We might want to reserve a little bit of time on the day after, just in case.
That's right, yeah.
So let's see what works for Ms. Sandler.
July 2nd and 3rd, I can make work.
Okay, so July 2nd and 3rd. Let's try to get it done on the 2nd, and we'll use the 3rd as an overflow day if we don't quite finish. So why don't you plan to be here at 9? I'll just hope optimistically that the first appearances won't take too long that morning, but as soon as I finish the first appearances that day, then we'll start on your hearing. And I will have to break from 11 to 12 to take the civil hearing. I'll ask Amanda to contact them and see if we can move it, but no promises on that.
That's-
Plan on me taking a break from 11 to 12 and probably 30 minutes after that to have some quick lunch.
No problem, Judge.
Okay, and then you've got the whole day, but I will have to take some breaks in the afternoon to do the petitions and warrants.
We understand.
Okay, and
And we
then.
appreciate the court accommodating
Sure.
us.
And then the following day, if we don't finish, rather than keep people here late, we can come back and finish up after first appearances on the 3rd. Okay?
Very good.
Could you please prepare a notice of hearing?
Yes.
Okay. So are both attorneys planning to be present for that hearing?
Yes.
Okay. Would one of you be able to proceed if the other one, for whatever reason, was not available? Because I know we've had a lot of things come up and the hearings had to be rescheduled several times, but, you know, since it's so lengthy, it's hard. It's hard to find the time and to schedule it. I'd really like to go forward with this one.
We'll be fine.
Okay. I mean, barring some catastrophic event that, you know, neither of you are available,
We'll be fine.
or if
Yeah.
I'm not available, I'll get coverage.
Sure.
You'll have a judge here. But I just want to make sure that we can plan on going forward and get this matter heard. It's just hard for me to find full days.
I understand. No, we'll be good to go.
Okay. And Ms. Sandler, thank you for your flexibility on the dates as well. Okay, so Mr. Patel, yes, please just do a notice of hearing. Please send a courtesy copy of that to Amanda. Because
ma'am.
when things get filed, we don't usually know about it unless we go and look in the court file. But if you send her a courtesy copy, that will help her to block off the calendar.
Yes, ma'am.
Okay. Thank you.
Thank you, Judge.
Anything else I need to cover today?
Not for Mr. Stevens.
Okay, thank you.
And Your Honor, that concludes my business report. May I make excuse?
Yes, thank you.
Yeah. Next, Judge, Jay Patel and Tim Shaw on behalf of Cameron Sherenzia, 22 CF 87. We're before the court today on the defense's motion to compel. Has the court had the benefit of reviewing our motion and the state's response?
Yes, just 1 second, let me get that in front of me. All right, and this is under Mr. Shaw's name on the docket. This is 22 CF 87. And is Mr. Sherenzia present?
He's not, Judge.
Okay, just making sure. And Ms. Basso is present for the state?
Yes, ma'am.
Okay, great. I did review the motion to compel. I reviewed the state's response. And would you like to respond to the response?
Absolutely.
Okay.
So Judge, what I'm asking for is, it's not overly complicated, and I think that this is, well, no, I don't think. This is going to be an issue that you're going to deal with multiple cases on your docket, whether they're my cases or Mr. Cotton's cases or Ms. Merrifield's cases. We're all kind of in concert, and we've looked at this issue. I can tell you with 1,000% certainty that this is a change in policy from the state attorney's office. The reports that we've requested, we've received in Mr. Shaw and in our cases in the past. And so what's challenging is that the state's taking this position that they've complied with the rule. Now, in looking at the rule specifically states that they can't share the CSAM material. Keep this in mind. We don't want it, okay? What we're looking for is these tailored reports, and does the court have any familiarity with these images that they take from the seized devices?
What do you mean?
Okay, so.
What do you mean familiarity? You mean like metadata or the actual images?
The actual copy of the device.
I'm not quite
Okay,
sure.
that's
like,
okay.
What
So-
you, like the
I'll
the
explain.
code?
Sure.
Or the pictures?
So when they seize a device, sometimes they can use this program called Celebrite, in which their officers have gone through extensive training, and it's a very expensive tool that they use to copy the entire device. That's what's called an image. From that image, they then create reports. That's how they determine whether or not there's CSAM material on that device. If there's not, then they typically return the device. So in this case, they have taken an image of a device and a computer, right? And they've run it through the Celebrite system, and then they've subsequently charged my client with allegations that there's CSAM material on those two devices. So what we have asked for is, and keep this, the charge is not possession of child pornography. If you look at the jury instruction, possession means knowing possession, right? They have to know that they have it and that they continue to have it, right? So when you, as a practitioner, when you're trying to determine whether or not someone knowingly possesses an item, we have to look at the file attributes to see if that file was accessed. Was it a batch download? What's the time? If 100 files were downloaded within 1 second, that tells us something that he may or may not have seen it, right? So we're trying to determine whether or not our client has knowing possession on these two devices. And so what we've asked for is a report that they can run through their Celebrite, their program, and give it to us. I've actually spoken to Investigator Evans after a deposition a couple weeks ago, and I told him, I said, this is exactly what I'm looking for. And he said that they've made some changes, the state attorney's office has made some changes, and he goes, what you're asking for doesn't take but a few minutes. And so the rule specifically states that they're not supposed to share the CSAM material, and there's a host of reasons why. Re-victimizing victims, which is a huge issue.
I get that.
Lawyers, we don't want it. We don't want to be charged. Our experts have cautioned that if they put the image on their machine, that they could unknowingly possess it, right? These are the issues that we face. We're not at the point in this case where we need to go determine whether or not the image is actual CSAM material. We want to look at, we're at the point in our case where we need to determine if the files have been accessed and what they look like. And so that's why we've asked for this tailored report without the information, or rather without the CSAM material. I think that, I think it's a little disingenuous that the state's taking the position that we've done what we're supposed to do. Granted, the legislature they surely haven't kept up with technology and how, how they investigate CSAM cases now is surely different than, 10 years ago, 5 years ago, and 20 years ago. And so we're working within the confines of what we have. And so we believe that, that this court should order that the state give us this stuff. It's in their possession. The court has the ability under 3220, under 2 sections, under sanctions, and under subsection 3, that states that the court may prohibit the state from introducing into evidence any of the foregoing material not disclosed, so as to secure and maintain fairness in the just determination of this cause. The best way that I've been able to give an analogy to this is for us to have a fentanyl trafficking case. The state's going to test it, and they're going to say, nah, you're not entitled to any of the lab notes or anything like that. It's fentanyl. Take our word for it. But if you don't, you go hire an expert, you go test it yourself. That's not how we do drug cases. And again, these are tough cases with huge ramifications. Each image is a third-degree felony, and the score sheet blows up. All we want to be able to do is, at this point, determine from our investigative purposes whether or not he's knowingly possessed it, so we can file the appropriate motions and then go to trial if we need to.
Okay. Thank you. And Ms. Basso?
Judge Clark, as the court is aware, the state's position is we are in compliance with the rules of discovery. The rules of discovery do require us to make any and all evidence that we have available to the defense for review. Generally, it's available for copy, but of course, since this involves CSAM, it would not be, and the rules have specifically excluded that to reflect that child pornography does get special treatment. Your Honor, in this case, it is not the state's policy. Let's be clear there. The rules say you cannot share it. The federal rules say you cannot share it. The policy that we have discussed this with the sheriff's office, and it requires extra manpower. It requires extra time to analyze the data and then provide the reports. That's what they do for us. If the defense wishes to review the data, it is available. It has remained available from the beginning. The raw data is available. They have an absolute right to look at that. They can bring an expert in. That expert, if they're qualified, can then review that data, get any information that they need, and provide it to the defense so that they can adequately defend their client. The state is not required to process the data and provide it to the defense in the manner that they wish to have it. Specifically in this case, Mr. Patel is asking for what we would call a tailored copy of the Cellebrite report to excerpt all the images. First of all, there's always a chance we might miss one, and they could inadvertently get child pornography, so that is a danger in providing the full report. So we certainly don't want to do that. Additionally, ma'am, part of the change in not providing things comes actually from actions of Mr. Patel in prior cases. They have gone over there and asked for excerpts of evidence, screenshots, and parts of downloads, and then gone into court and represented that that is the evidence that we have based our case on. Basically saying this is all the evidence, the excerpts that they took. So again, that kind of brought that about. We are now in line with the federal rules where all the evidence is available. The defense is not being denied access to it. They can come over with a qualified expert and process it in any manner that they need to obtain the information that they need to defend their client. That is not the state's responsibility to prepare the defense's case. So by making the full evidence available to them, as is required, we believe we are in compliance with it. Mr. Terenzia is charged with 20 images. He has over 200. They can at any time come over and view those. We believe, based on the rules of discovery, we are in compliance. And there is no onus on the state to provide the evidence in a manner that the defense wishes to use it.
Thank you. Mr. Patel, do you wish to respond to that?
Yeah, Judge, it sounds like Ms. Basso appreciates that I was doing my job for my clients in the past. And that's what I'm trying to do now. They have an obligation under Brady, under Giglio, under the rules. The inability, and I think what's telling, and if the court rules against us, then we're going to have to file a discovery motion, and I'll subpoena Investigator Evans, and he can tell you, it takes 5 minutes for what we've requested. I certainly hate the argument that the government is now worried about money when it comes to somebody's constitutional rights to be able to defend themselves. And that's what's happening here. We simply, to say it's a tailored report, you can run several different reports. They just click boxes and then run a report. It's data. We're asking for one that specifically doesn't have the CP because that's what we're worried about. The suggestion that we would then, this policy then forces every criminal defendant that may not be indigent, and keep this in mind, there are plenty of people that aren't indigent that can't afford experts, right? And so what I'm hearing the state say is, well, you can get your own expert, so if you're indigent, the government can pay the cost, like Mr. Stevens, or if you're not, then you better go figure out some money to go hire an expert, which I think is inappropriate.
Whose ever phone just went off, turn it off right now. Do you intend to hire an expert in this case?
We have an expert for analysis. We have not, we would have to hire an expert, like Mr. Cotton was worried about his timing on his case, on getting a continuance, and so he didn't have, because of the court calendar, he didn't have the ability to file this motion to compel, so his client had to go hire another expert to go to the sheriff's office to run the reports. We don't have any intention to do that because I told Mr. Cotton, I think that that's a violation of the rule. The state should be providing that for us. And he goes, well, I'm stuck on time, so my client has the money, he's going to do it. We're not in that position. My client's father's paying what he can for us. He's not paying any, he hasn't paid us a dime.
So let me make sure I understood what you just said. You have an expert, but not the type of expert that can go look at the files at the sheriff's office?
Correct. The program that they use called Celebrite is a very expensive program that requires the individual trained on that program. It's traditionally a law enforcement program. Individuals can pay a hefty sum and go do a bunch of training to have a license to use Celebrite. That's what the state is now forcing us to do. And Judge, I'm having a difficult time when I read the rule, seeing that the state attorney is making the material reasonably available to the defendant and the defendant's attorney. And if the argument is, oh, they've used that against us in the past, that's what we're supposed to do. This is an adversarial system. We don't just take the state's word and believe it. Yeah.
So, Ms. Basso, the state has provided whatever reports that Mr. Patel is requesting. You've provided it in the past.
Ma'am, we have not provided those in the past. We don't give the reports to the defense with child pornography. It's not done. They are available for review. In the past, I know Mr. Patel has come over and looked at it, Mr. Shaw's come over, they brought another individual to review the reports. They've actually, the individuals in the lab have gone so far as to pull up the parts that they wanted to look at. So they are available in their entirety for them to review. But because of the content, it must be done at the sheriff's office. This is in line with, everyone is required to do this. So it is still, the entirety of the evidence is available to the defense.
Well, my question is the report that Mr. Patel is requesting, Mr. Patel, you'll have to help me
It's a
with the
Celebrite report, ma'am.
technical,
That's-
the Celebrite without the images. Is that what you're asking for?
Yes.
Okay. Has the state provided that report, Celebrite without the images, in other cases in the past to the defense?
No, ma'am.
Okay?
We do not, because of the child pornography, there's a policy that they do not get released. They
I'm
are
not asking
available-
the images.
No, ma'am, but we have not provided tailored copies either. We have provided, in the past, there's parts of it that they wanted. Now, this is to my knowledge. If I forgot one somewhere, you can give me that look. You can tell me if I forgot one. But, ma'am, there have been parts that Mr. Patel and his individuals have asked to get parts of them, downloads of different screenshots and stuff, and that's what I was referring to earlier. Then he came in and said this was the entirety of the evidence that was misrepresenting. So, now if there was something provided in the past that I've forgotten, I apologize to the court, but we do not provide them. And I have discussed this with the sheriff's office. We don't provide clean copies of Celebrite reports. That's what experts are for. The entirety of the data is available for the defense to review. It's unique because of the nature of what we're dealing with, child pornography. They get special rules. These cases have always had special rules in federal court and in state court. That is protected information. So we have not provided it, and to provide it in this case, a tailored copy, would go against what we believe we're in compliance with the rules of discovery. We have to make it available. It is available. All they have to do is make an appointment to come over and look at it.
Mr. Patel?
Perhaps Ms. Basso is forgetting.
I just
There-
said I might have.
There is a report. It was in the Jesse Hartzog case where they produced us a sanitized report of a Snapchat where they specifically excluded the images. So they have produced reports that are sanitized without the CP. I mean, Judge, when I filed this motion, I'm not asking the court, I'm not trying to hang the moon here. I'm trying to just ask what I know that I've received before. I know what I don't know, and I know what I know. And the file attribute, the Excel spreadsheet listing the file attributes, I've received that in a couple cases. I know that for a fact, because it's just an Excel spreadsheet. And we've reviewed that in Mr. Shaw's office with our expert.
Okay. And you've asked, well, I'm looking at your motion, you've asked for two different things. Number one is full exported PDF copy of the Celebrite report minus pictures. The second thing is full file attribute report for all 241 identified files. So you're saying that the full file attribute report, you've received that?
I've received it
in other cases?
Yes, I have.
Okay. And have you ever received a full exported PDF copy of the Celebrite report minus pictures in one of these cases?
Not a Celebrite one. It was a Snapchat one. But that's where I spoke to Investigator Evans, and he said, we can do it. It takes 5 minutes because we can just unclick the pictures and then run the report.
Well, what have you done in previous cases to get this information from the Celebrite report? I mean, So
Celebrite is just one program. So they don't, Shaw and I have had so many different types of CP cases, and so sometimes they use Celebrite, sometimes they don't. In every case in which we've asked for a report, we do a specific discovery request, the state complies. It's never been an issue until now.
Okay, but you have received the full file attribute report in similar cases previously?
Yes.
Is that accurate, Ms. Basso? The full file attribute report?
I don't know for sure, ma'am, honestly. I don't believe we normally do, and in this case, they're asking for 241 files, and he's only charged with 20. I'm happy to add more of them. We have identified 241 files, but there's only 20 charged.
Okay. And do you want to respond to the argument that the state has provided a sanitized report of a Snapchat in a different case?
That is the one I was referring to, actually, is
Okay.
the Jesse Hartzog case. Mr. Patel and others in his case had requested specifically just some shots, just part of it, the Snapchat. They were just basically screenshots, just part of it. That was excerpted for him out as a courtesy. Yes, you can have this part of it, we'll give you this part. It was done as a courtesy to save some time to keep the case moving forward. It was not exported from the full report, it was just that part of it out. Then Mr. Patel did come in and at depositions use those to try to make it sound that that was the only evidence that the investigator had relied on for their search warrant, and also went into court at a motion to suppress the search warrant and represented basically through the witness and then also in his arguments that that was the entirety of the evidence, while it was just a very small excerpt. So based on those misrepresentations, it was then determined we're not giving you excerpts anymore. We're not just going to take a part of it. You can have access to everything as is required, but you're not just getting some screenshots and then go back into court and say that was all there was. So frankly, that is the one I was referring to when Mr. Patel brought this on himself partially as far as getting any specific screenshots, because it got misrepresented in that case.
Okay.
But I go back to, and that Snapchat, that's not a separate report. That just was part of those chats that were in question for that particular motion and argument. But we did not give them a clean copy to celebrate. Again, they can come in and they can look at all the evidence, and their individuals they can run their own reports on it. They can do everything they need to represent their client. What we have provided previously have been forensic reports. It's basically just a write-up of what was found. That is generally provided upon request to the defense because it doesn't contain images, it doesn't contain the full download, but it does contain what the forensic analyst found. And that can be provided, that is provided routinely.
Okay.
But the actual Celebrat download is not.
So the state has never before provided a full exported PDF copy of a Celebrite report minus pictures to anyone in any case?
I can only say to my knowledge, ma'am.
Okay.
I'm not aware of one.
Okay. And Mr. Patel, you've not ever gotten that in any other case?
Not a Celebrite one. I asked for the Snapchat one because that was the basis of the search warrant and the arrest warrant.
Right. Okay.
It would make sense for me to ask for something smaller in scope than everything when I know that that's the issue, right? And that's what we're asking here.
Okay. And I'm circling back to the second thing you requested, full file attribute report for all of the files. You've received that in other cases?
Yes.
State has provided that in other cases?
I don't know, ma'am, that it's been full file attributes. I'm not going to say one way or the other. I know we've provided parts of them. I know that because Mr. Green was not qualified to do it himself, we provided it for him in some cases. But I don't know that it was all of them. And in this case, he's asking for all 241 that aren't even charged.
Well, I'm asking for 241 because the state loves to say, well, we're just giving you a break, but if you want to go to trial, then we can charge you with 241 more. So we might as well get prepared because that's what we're supposed to do as good lawyers, is advise our client.
Is the state objecting, you're objecting mainly to the Celebrite report?
Ma'am, we're objecting to any further manipulation of the evidence to be in line with what the defense wants. We basically believe the rules of discovery require full access to the evidence, which we have been and are willing to continue to provide. To tailor it any further, to provide any exports, we believe that goes beyond what is required of discovery, and quite frankly, they have the ability to get an expert to bring in and look at it. We're not required to tailor evidence.
Would it be tailoring to do the, forgive me, I am not a technological expert by any stretch of the imagination. The full file attribute report for all 241 files, is that, what is that? Is that manipulating? Do you have to
Ma'am,
delete stuff out of it?
That's
Or
a portion of the full report. That's basically, it's part of what's available in the raw data that they can review. So that would basically be a part, they're just basically asking for a part. They're asking for the attributes of those specific images. So that's a portion of it that we'd have to tailor and pull out for them.
Okay. I mean, how difficult is it to do that?
Ma'am, I guess the point is, we're not required to tailor evidence.
Okay.
We're required to make it available.
Do you have any case law?
Judge, I've looked. This is,
Okay,
this is pretty new stuff.
okay.
Trust me, I would love to give you a case that
I
says
would
I'm
love to
right.
have one. I would love to have a case where some other court has made a ruling on these issues, but I didn't see one that was cited by either side.
And what's frustrating for me is having spoken to Investigator Evans, he's told me that this is a very simple task. It doesn't take very long.
Ma'am, I'm
which-
going to object to Mr. Patel constantly referring to Investigator Evans. That's not exactly accurate.
It is accurate because I spoke to him.
But he's not here,
Exactly.
so, you know,
We can continue the case, Judge, and I could subpoena him if the court feels that we'll be in a better position there.
what I'm going to do is, unless you have some case law, some other judge that has ruled on these specific issues, something, some sort of authority for the court to rely on, some sort of precedent, then I'm going to deny your request.
Judge, is the rule not good enough?
The rule says that the state has to permit the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control, except that any property or material that portrays sexual performance by a child or constitutes child pornography may not be copied, photographed, duplicated, or otherwise reproduced, so long as the state attorney makes the property or material reasonably available to the defendant or the defendant's attorney. And it sounds like they're doing that.
Judge, you need an expert to get the stuff that they're asking for. They're forcing us to have an expert. That's patently unfair. That's not reasonable, that's not making it reasonably available.
Are you saying that if you were to get the things you're requesting, you would not need an expert to look at them? You will be able to look at them and
There are a significant amount of issues that Mr. Shaw and I can look at and then know if we need to file certain motions. That I know wholeheartedly. I don't need an expert for certain things in which I'm asking for.
can you not go to the state and look at that same thing at the state's office?
I think then so let's say for a motion to suppress, what I hear how it would work itself out is I would go to the sheriff's office, we would pull those reports, I'd then bring my computer, my client would have to come with me, Mr. Shaw would have to come, then we'd probably have to spend a significant amount of hours so I could draft my motion to suppress there to constantly refer back to the evidence. That doesn't make any sense. Moreover, it puts a cooling effect because all those rooms are recorded.
Ms. Basso?
Ma'am, if it would have to be done at the sheriff's office, it's been done that way in the past. We've made it available, basically the information is taken off the server, the raw data or whatever the report is taken off the sheriff's office server and put on a standalone computer. and put in a room with the defendant's attorney. Sometimes they have their expert, their individual there as well. And then they can then go through it and use it on that standalone computer and do everything that they need to do with it. So that way it's all contained. There's no danger of it actually being disseminated or copied or anything like that. Mr. Shaw has been there himself, Mr. Patel has been there themselves. I've been there as well, along with the investigator, while they were doing it. So it is available at any point. They can go to the sheriff's office and do that. We don't have it at our offices. We never have the CP in our offices.
Okay.
But it's on their server, it's available, and it can go on a standalone computer, and they can go stay in that room as long as they want to with it and work. And the rooms are, they may be recorded, but they're not recorded. I can tell you that's not an issue.
Okay, well, can there be assurances given that there will not be any recording if
Absolutely, ma'am.
the defendant and his attorneys and his expert go in there to view the evidence on the standalone computer?
Absolutely,
How
ma'am.
can they be assured that they would not be recorded?
Ma'am, it's not going to be done, period. We understand that they have the right to do that. That the sheriff's office understands they have the right to do that. The only safeguard that there would be is, prior to leaving, we'd make sure that there's been no copies made, obviously.
Okay.
That is a standard procedure with any expert. If they bring in equipment, it's just checked when they leave to make sure that there's been no copies taken. But certainly, they have a right to do what they need to do, and that's. And if we need to find a room that doesn't have a recording capability, I believe we can do that as well.
That's what I would require. Just
that
so
we
that
can do
there
that,
are
ma'am.
assurances on the side of the defense that even though they don't think they're being recorded, that there's not some accident or some automatic recording, so that they would have assurances of that.
We can do that, ma'am.
Okay. Mr. Patel, if you find some case law that supports your position, please file a motion for rehearing, and I will hear your argument and consider the case law.
Yes, ma'am.
But in the absence of that, I don't read the rule to require the state to create the reports as long as they make the evidence available for you to go in. I've ordered that it be set up for you in a room with no recording so that you don't have to worry about, you think you're not being recorded, but you accidentally are.
I'll follow an order.
Okay.
What it sounds like is denied in part, granted in part. Denied that they've complied with the rules, granted in that you're ordering them to have a unrecorded room available for the defense.
No, I didn't say denied that they're required to comply with the rules. They are complying with the
No,
rules.
I said denied
Okay.
because they've complied with the rules.
Yes, I misheard
Yeah.
you. Yes, they're complying with the rules. If they make this information available, you said if you got these reports, you wouldn't need an expert. There's things you can look at and determine if your client has accessed a certain file. Rather than them give you a report, they will make it available. You can go in there and look at whatever it is you're requesting, and you can make that same determination. I'm ordering that it be provided to you in a room that does not have recording technology, so that you don't have to worry. Obviously, if you want to take your client with you, or an expert, or staff, whatever you want to do, you can set that up at the sheriff's office.
Yes, ma'am.
Okay. Yes, if you will please prepare an order. Send it to Ms. Basso for her review first before you send it to me.
No, it's good.
Okay?
Judge, I believe we've, for purposes of the docket, Mr. Sharenzia's case was continued.
To June 9th.
Yeah, okay. Thank
Okay.
you, Judge. I have nothing further. May I
Sure.
be excused?
Well, let me just say, Mr. Chirenzia's case is over 3 years old. I know you need to go and look at all this information we've been talking about, but it's just been continued to June the 9th. So that's almost 2 months from now. Is there any reason that you would not be ready to go to trial on this case next cycle in June?
I don't know, Judge. What I can tell you is I'm going to be, Mr. Shaw and I are going to be working diligently to get there. I've got depositions in May, so I was hoping to get this information from this compel in advance of those depositions, so we should be tracking toward that.
Okay. The case is over 3 years old. It is time to resolve it. So you've got nearly 2 months. In fact, before the trial date, today is April 22nd. Jury selection on the first week is June 23rd. That's 2 months. The second week is July 7th, so that's an extra 2 weeks. If you went the second week, this case needs to be tried either June 23rd or July 7th. That's 2 months on top of more than 3 years.
And Judge,
So-
the court understands this was not our case from the very beginning, right?
Yes, but you have been on it for a while.
We have been on it for a
right?
while, but certainly not since 2022.
I know, but it's been a couple of years though, right?
A year and a
I
half.
mean, yeah, that's that. This is not a capital murder case. I understand the charges are very, very serious. I understand with these charges, your client will probably score prison. I get that. But more than 3 years is enough time to get ready for trial. It needs to go to trial on one of those dates, June 23rd or July 7th. So next cycle, you've got 2 months, a little bit more than 2 months actually, to finalize things and let's get it tried, okay?
Yes, ma'am.
All right, so that, no more continuances, this is it. All right. I should have asked Ms. Basso, but I think you've already said you're ready.
Yes, ma'am.
Okay, so it's going to be tried or resolved in whatever way it's going to be resolved during the June trial cycle. And pretrial conference is June 9th at 9 o'clock, like I already said, on a different day. Okay?
May we be excused?
Yes, thank you.
Thank you, Judge.
Thank you. Oh, Mr. Shaw, I think you have another one on the docket.
Jason Bartley, Your Honor.
Yes.
Spoken with, and it's a VOP, spoken with the state on that particular case. I think we're about to get it brought in. I'm just waiting on some information from Tallahassee, of course. If we can just have one final continuance, it'll be resolved on the next docket.
Okay, and that's 2020 CF 945, 2021 CF 148, and 2021 CF 3288. What is the state's response?
The state has no objection, Your Honor. There were technical and new law violations, and there's a suspended sentence hanging over the defendant's head. So
Okay.
Mr. Shaw can get caught up to speed. The state has no objection.
Okay, I believe that's May 20th at 9 o'clock.
Thank you, Judge.
Thank you. Mr. Weinstock?
I'm present, Your Honor.
Okay, thank you.
You know, I have two cases in front of you today. The first will be Quayshawn and Jenkins, and that will be a plea.
Okay, that is 23 CF 2706.
Yes, ma'am.
Wonderful, thank you.
May I, have to get my client to sign it down?
Yes.
Count the beer in there. Judge, be patient for a second.
Sorry?
Be patient for a second.
Sure. Thank you so much. Do we have a score sheet?
Your Honor, can I give it to Your Honor in just a few minutes?
Sure. Do you know what the score is?
Your Honor, it'll be around the lowest permissible of 41 months. But I am making adjustments to it to include the lesser included of what he's going to plead to, which is the possession of a firearm, actual possession, not with a discharge.
Okay. Mr. Weinstock, do you need to review that score sheet before we proceed with the plea?
Negative.
Okay. Mr. Jenkins, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir, and you can put your hand down if you'll just tell me your name, please.
Washington Jenkins.
Thank you.
Actually, Your Honor, they carry the same degree and offense level, so I do have it here.
Oh, great, okay. Yes, thank you. Thank you so much. This appears to be a downward departure. Is this the state's legitimate, uncoerced plea bargain?
Yes, Your Honor.
Okay. Mr. Jenkins, I swore you in a second ago. You're here in case 23 CF 2706. The charges are possession of a weapon or ammunition by a convicted felon, that's a second-degree felony, and aggravated assault by threat with a firearm, which is also a second-degree felony. Have you had a chance to talk to your lawyer about those charges and any possible defenses?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to have a trial and make the state prove these allegations beyond a reasonable doubt?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing on your agreement?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours that would affect your ability to understand what you're doing?
No, ma'am.
Are you suffering from any mental illness that would affect your ability to understand what's going on?
No, ma'am.
I do have a score sheet here. It shows 83.2 total sentence points, which is a lowest permissible prison sentence of 41.4 months. Are there any objections?
No, ma'am.
And Mr. Jenkins, like I said a minute ago when I asked the state, you actually score 41.4 months in state prison. Do you understand that?
Yes, ma'am.
According to the offer from the state, which you've accepted, and it's captured in this plea agreement that you signed, you're only being sentenced to 3 years Department of Corrections. Do you understand that?
Yes, ma'am.
The court finds a basis for the downward departure based on the state's legitimate, uncoerced plea bargain offered to the defense, which the defendant has accepted. I do find a sufficient factual basis for the plea based on my review of the arrest report. Mr. Jenkins, if you're not a U.S. citizen, do you understand the plea will subject you to deportation?
Yes, ma'am.
How do you plead to counts 1 and 2?
Guilty.
No contest.
Oh, no contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, you will be adjudicated guilty on both counts. You will be sentenced to 3 years state prison on each count, concurrent, with credit for time served. Let me find out what the court costs are.
It'll be 867.
867?
And then if he's court appointed, it'll be 100.
Mr. Weinstock, are you court appointed? Okay. The court costs are $867 plus a $150 cost of defense fee. That includes the application fee. Those will be reduced to, do you want them reduced to a lien or what?
When you get out, can you pay it?
How much is it?
About $1,000. When my client leaves the jail, he said he'll be able to pay it, say, within 6 months.
Okay, within 6 months after release?
Yes, ma'am.
Okay, sir, if you go see the clerk, they'll work out a payment plan with you. If you haven't gotten on a payment plan and you haven't paid these costs and fees within 6 months after you get out, they'll go against your license. You could lose your license.
Yes, ma'am.
Okay. Did I leave out any terms and conditions or anything else on the agreement that needs to be covered?
No, ma'am, but I want to emphasize this is credit for time served also.
Oh, yes.
Okay.
Sir, you get credit for time served, okay? You have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Mr. Jenkins, we'll step right over here.
Thank you, Mr. Weinstock, on that. And,
The next one I have, Your Honor, is Chandra Beard.
okay, just 1 second. All right, I'm sorry, Mr. Weinstock, go ahead.
This is approaching the Chandra Beard on case number 24CF1102, 24CF923. We have in front of you, Your Honor, a motion to modify bond and pretrial release conditions, fundamentally to allow her to attend Path of Grace. I have the managing director of Path of Grace here right now to testify as to what that program entails and how it can assist the court, how it can assist my client. Would you care to hear from him?
Probably so, but let me see what the state's position is. I'm not sure which.
Your Honor, the state is going to oppose any modification of bond at this time, based on the circumstances regarding these FDLE cases, the nature of how they came about, the fact that there were 3 overdoses, one that led to a death, which put law enforcement on radar for these individuals. I can't accurately reflect that Ms. Beard is definitely high up on the hierarchy of this criminal organization. you know, Your Honor is aware of the discovery issues and the deadline that is quickly approaching. I think this bond motion should, discovery is being transferred over to defense. We are still in the process of downloading that, but any modification of bond at this time, based on the gravity and the nature of these charges, would not be appropriate at this time. The state would object and request this court to leave the bonds as they are.
Well,
Okay.
if the prosecution doesn't want to modify the bond, she has not yet addressed the pretrial release, however. And we're asking the court to release her to the path of grace to participate in the recovery program while the instant cases are currently being reviewed right now.
In case 24 CF 923, Ms. Beard is charged with 2 counts of conspiracy to sell, manufacture, deliver, or possess with the intent to sell, manufacture, or deliver a controlled substance. Each of those is a third-degree felony. The allegations in count 1 are alleged to have occurred on April 7th, 2024. The allegations in count 2 are alleged to have occurred on April 17th, 2024. In case 24 CF 1102, Ms. Beard is charged with 1 count of racketeering. That's a first-degree felony. 1 count of conspiracy to traffic in amphetamine or methamphetamine, 200 grams or more. That is a second-degree felony. The allegations on that count are alleged to have occurred between April 1st and April 28th, 2024. Count 3 is conspiracy to traffic in fentanyl, 28 grams or more. The same dates are on that allegation. And then count 4 is unlawful use of a two-way communication device to facilitate the commission of a felony. Same dates, April 1st, 2024 through April 28th, 2024. That's a third-degree felony. Judge Ketchel had a pretrial detention hearing. It was back in June 2024, if I'm not mistaken. I know the order was entered on June 27th, 2024. He made certain findings on the record and in the order. He made findings that pretrial detention was justified. There was a substantial probability that the defendant committed the crime charged. The factual circumstances of the crime indicated a disregard for the safety of the community, and that there were no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. Those were the findings that are in his order. And he granted the motion for pretrial detention that the state filed and ordered that Ms. Beard be held on pretrial detention on the fentanyl trafficking charge. So,
Before you rule, may we approach?
sure.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Based on the very detailed findings that Judge Ketchel made that are contained in his order when he heard the pretrial detention motion last year, the court does not find there's been any change in circumstances. These are extremely serious charges. Judge Ketchel ordered pretrial detention. This court has no grounds to modify that order. So with all due respect, the motion to modify the bond and pretrial release conditions is denied.
All right, thank you, Your Honor. That's all I have. May I be excused?
Yes, yes, thank you.
Brenda, does she have a next court date?
Yes, let's make sure that
It's not in the case yet, but it's, let me check. I believe
June
it's
11th. June 11th will be Ms. Beard's next court date on both of her cases.
Yes, ma'am. And then this one's the one set at 8:30.
Oh, it's at 8:30, yes. Mr. Weinstock, it's at 8:30 on June 11th is her next court dates. That's when I'm doing all of the RICO cases to try to handle those at one time as a joint hearing. Okay?
May I approach for a second?
Yes, of course. Mr. Switek? Good morning.
I'm here representing Kyle Thumb.
Yes.
This case is listed under,
Okay. This is case 2020 CF 553.
the attorney of record is Dave Simmons, and I'm
Yes,
filling
thank
in
you.
for him today.
Thank you so much.
I have a plea agreement that I've explained back in the attorney-client room to Mr. Thumb, and he's going to execute it as soon as he gets out here.
Thank you.
And this is a modification, so it will not require a score sheet, Judge.
Okay. All right, the defendant is present. And we're here on, bless you, we're here on a violation of probation case. Good morning, sir. I'm Judge Clark. If you'll please raise your right hand, I'll swear you in. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. And if you could tell me your name.
My name is Kyle Thumb.
Thank you. Yes, thank you. Thank you so much.
Right. Mr. Thumb was unable to read the plea agreement through the screen in the interview room, but I did read to him the pertinent parts of it.
Okay. Thank you. So, Mr. Thumb, you're here on case 2020 CF 553. You're here on allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations that you violated your probation?
Yes, I have.
Do you understand that you're giving up your right to have a contested hearing and make the state prove those allegations?
I do, Your Honor.
Has anybody promised you anything other than what's showing on this agreement?
No.
And your attorney just represented that you weren't able to read the agreement through the glass in the attorney-client room. Do you need some time to read it there at the podium?
No, that's okay, Your Honor.
Okay, did your attorney read the agreement to you?
Yes, he did.
Okay. Do you have any questions about the agreement?
No, I do not.
Did you understand, I don't need to know what you and your attorney talked about, but did you understand the conversation?
Yes, I do.
Did you understand the parts of, or the plea agreement when your attorney read it to you?
Yes, I do.
Do you need any additional time to talk to your lawyer?
No, I do not. Thank you, Your Honor.
Sure. Is anybody threatening you to make you enter a plea today?
No.
Are you on any medication?
No, I'm not.
Any type of drugs, substances, alcohol?
No.
Are you admitting to the allegations that you violated your probation?
Yes, I am.
I accept your admission. I find it was freely and voluntarily entered and in accordance with the agreement. It says reinstate and then terminate probation?
Correct.
Okay. And sending court costs of $867 to a lien. That must be the original. Is that the original court cost?
Yes, ma'am, and I showed something on my side.
Oh, court costs have been paid. All right, and then it says a $30 drug test fee and cost of transportation, $499.20. Do you show where in the?
The transport has not been, it's not applied.
Okay, and then would there be a $100
Yes,
fee? There's an additional $100 violation of probation cost, so that will be assessed. I'm not sure what the $30 drug test fee is. That's probably something for probation, so that would be assessed. And then $499.20, that's the cost of transportation to Okaloosa County Sheriff's Office, I believe. And did I miss any of the terms and conditions?
No, Your Honor.
No, Your Honor.
Okay. All right, sir, is this the only thing holding you in jail?
Yes, it is.
Okay, then you should get out today. I don't know what time you'll get back up to the jail today, but let me ask probation. Does he need to report in the morning, or, let's see, it's only 10:41. I don't know what time he'll get out, though. Okay, not at all. Okay. Well, then, sir, good luck to you. Then you will get out today.
Thank you.
All right, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one. Thank you.
Your Honor, what is the disposition?
The disposition would be,
Is it an adjudication?
is he
That's a
previously?
withhold, it's maintaining the withhold from last time.
That's correct, it was a withhold, that's why we did the reinstate and terminate.
Okay, then it will remain that way. Thank you. Thank you.
Your Honor.
Okay, we are about to take a break, but I do have a gentleman on Zoom who is appearing from a facility, and he's been sitting on Zoom for a while, so I need to take that case out of order.
Nathaniel Drew Brown, I'm pretty sure, Your Honor. I appreciate the court handling it this way.
Yes, I know he's appearing from a place.
Phoenix House in Citra,
Exactly, and
Marion
he's been
County.
waiting for quite some time, so let me go ahead and, I don't know how much longer he'll be available. So this is case is 24 CF 387 and 24 CF 1219. Let me bring him in. I also have someone named Christina Simon. I'm not quite sure who that is.
I think that might be a Marion County probation officer, but I'm not sure.
Okay. Good morning, this is Judge Clark. Can those of you on Zoom hear me?
You can't hear him? She probably has.
Mr. Brown, are you with me? Mr. Brown, you're on mute. Okay, great, thank you. Mr. Brown, could you just unmute and tell me your name, please? Make sure I've got the right person. There you go. Mr. Brown? Mr. Brown, can you hear me?
I can hear you, yes, ma'am.
Okay. I'm not sure who Christina Simon is. Is that the person sitting next to you, or is that someone else?
I don't know who that is, ma'am.
No, I'm his counselor.
Okay, let's try that again. Mr. Brown, if you'll state your name, and ma'am, if you'll state your name after Mr. Brown, so we have a record of who all is present.
Nathaniel Drew Brown.
Okay?
I'm Christina Simon, his counselor.
Wonderful, thank you. I'm Judge Clark.
Hey,
Sir,
Judge Clark.
you filed, yes, sir, you filed a motion a while back, actually it was about a month ago, to withdraw your plea, and I set it for the first available date that I handle these types of motions, which was today. And it's my understanding at the time you filed your motion, you were still in jail, but now you're at Phoenix House, is that right?
Yes, ma'am, that's correct.
Okay, so.
Your Honor, could I speak for him
Go right ahead.
unless it's determined otherwise? Steve Medina for Nathaniel Drew Brown. I just wanted to briefly reference what I understand to be what transpired. Many months ago, on August 15, 2024, Nathaniel Drew Brown took a bars to bed Phoenix House deal. Excuse me. It was actually October 17, 2024, because there was a reinstatement and modified from the original August 15, 2024 plea. But on October 17, he reinstated and modified with bars to bed Phoenix House. He never got picked up. I do understand that basically the coordination is done between state probation and Phoenix House, and that Phoenix House more than once came with the van or however it is they transport, picked up other people, presumably could have picked up him, but because they didn't have the right paperwork from probation, they didn't get picked up. It was not his fault. It is not the public defender's fault either, but I do always, if I learn of a situation like this, point it out to our investigator, who then tries to fix it, try to get probation to send the paperwork or whatever. And we did that, in fact, with somebody else around December or January. We rectified it. Mr. Brown was very upset that he kept getting not picked up. I will represent to the court that he did his best to let me know, but because of once we get a closed file, I haven't routinely been seeing jail mails. I'm changing our procedure going forward that I'll get a physical copy, but if I had known about his situation, I would have done something. But I just feel bad for him, and we then, when I saw his pro se motion and I saw him at the jail, he was quite upset, understandably so. I immediately looked into it. We figured out where the ball got dropped, basically. And I'm not trying to be rude or anything, but it did get dropped. And so I went and met with him again, and I was hopeful that we could get basically a time served or something like that, because he basically did not score very much. I think it was actually didn't score at all because it was reduced. I'm not sure what the score was, but we then also reached out to state probation and I think to Phoenix House to say, please don't pick him up, because we set it for status hearing. We wanted him to be able to have his say and urge, basically an adjustment. I know that he may want to withdraw his plea, but I was hoping we could work things out in some way, but he needed to get before the court before he left. But unfortunately, we learned a couple weeks ago that he got picked up, and that was like salt to the wounds kind of situation. So that's about it, Judge.
Can I say something, Your Honor?
Yes, let me swear you in, sir, if you'll raise your right hand, okay? Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
Yeah, I do.
Thank you, sir. You can put your hand down. Go ahead.
At this point, I have 330 days jail credit, and it's not that I was waiting on a bed to come open. So within the last 2 weeks, probation had finished filing the paperwork, and that's why they had come and got me. So I wasn't, and that's all I got to say. I was just seeing if go ahead, Mr. Medina.
I just want to, Mr. Brown, you to make clear what it is you would want to happen at this point, because the state and or court in discretion may not have any problem with what's requesting, I don't know. But before you get into a situation of withdrawing your plea and potentially having your case, your VOP start again without a resolution, I just wanted to see if you could make it clear what it is that you wanted, because I don't know at this point.
Your Honor, I'm looking for the 330 days jail credit time served or a county sentence. At this point, I mean, I have lost it. When I came into this plea agreement, right, it's like now they're adding on 7 more months that I didn't agree to, and I think that's just unjust and probably unlawful at the same time. or a great reduction on the Phoenix house for sure, time-wise.
Does the state have a position, if I may inquire, Your Honor,
Yes, go ahead.
so that he can hear it on the record? Thank you.
Just looking at the plea agreement here, it does state that the probation would reinstate and modify under the special condition of successfully completing the 12-month residential program. The program at Phoenix House or Haven House is what it says here, is 12 months minimum.
But that's old, and I've already lost 7 months because of the probation not filling out my paperwork. So now I entered into that plea, but now they're saying, well, hey, this 7 months don't count. We're just gonna tack that on top. So now I got 330 days jail credit, and I'm looking to rectify this somehow, Your Honor.
Can the state give him a straight jail option?
I'm gonna see and look what he
Thank you.
scores.
Thank you. And it would have been a lot easier if he hadn't been transported. We would all been together and we wouldn't have to be doing this on the record like this, Judge. I appreciate the work Phoenix House does do. I don't mean to disparage the help that they provide to.
Your Honor, I'd also be okay with time served in 1 year probation, just to check in. I've got a year in the county jail, ma'am.
Okay, thank you. I'm just looking at something and giving the state time to respond.
Your Honor, while the state's looking, that my understanding procedurally is that because he still is under the probation jurisdiction of the court, that the court could modify if it felt it was appropriate. He's not in violation, but if we worked out an agreement, it certainly would be possible. I'm not even sure if the court couldn't modify it on its own, but
So that's for 2 years probation. I did a year in the county jail, and if that's not sufficient, another year on probation should be sufficient for both parties.
Your Honor, it looks like with his VOP points, his lowest permissible would be 13.2. But, you know, given all the discrepancies here that has happened, and him not getting to the treatment facility in a timely manner, to no fault of the state, a credit for time served offer would be acceptable to the state at this time.
Okay, I am looking, well, let me just ask this. Is that what the state is offering to do, or what?
If the plea is withdrawn, that would be a potential resolution the state would be available to, Your Honor.
Your Honor, may I?
But I do see this was a VOP, a new law. He scores prison.
Your Honor, if he was here, basically, I would suggest we could do a written agreement that would simply say that the probation was being terminated for credit for time served, it would be revoked and terminated, it would be a lowest permissible, it would be a legitimate on-course plea bargain, and it would take the place of the Bars to Bed Phoenix House deal that was approved by the court on October 17, 2024. And basically, if he'd have known this was going to happen this way, he would have been wanting that deal. So I think it's basically he's in about the same shoes as he would have been.
No, the state wouldn't have offered this had these circumstances not happened because he scores prison on a VOP. But given everything that has happened, the state is a little bit more amenable to that right now. But, you know, the main thing is this defendant wanted treatment and now all of a sudden doesn't want treatment, which is a little concerning as well to the state, the fact that he agreed to that. But,
Well,
you know, I think we're a little bit past that point. The state also doesn't get into jail credit. However, the state would agree to 1129 OCJ with whatever credit that could be assessed.
why don't we do this? Let's reset this hearing and let y'all work out a written agreement if that's what you're going to do. And then we'll address it at that time. So,
Can I come back to the court myself, Your Honor?
I have no way to get him from Citra.
Okay.
I have no idea how he should be transported at this point.
yeah, I don't know how to get you there
I'll
either.
take the Greyhound bus.
Where exactly are you located? Where,
I'm 4 hours from you.
okay.
It's in the Ocala area, Marion County, and I think it's near the town of Citra, C-I-T-R-A.
I think that Mr. Brown needs to stay where he is until we can have our next hearing, and then that gives you time. If you're going to reach an agreement, then that gives you time to do that, and Mr. Brown can sign that agreement. We can get Mr. Brown back on Zoom, and then there would be a formal agreement.
But didn't, Your Honor,
Yes.
Judge Clark, didn't the state attorney say she's willing to do time served?
I want it in writing. I don't have a score sheet. I can't find a score sheet in either of your court files. So
Yes, ma'am.
that needs to be in writing because
Yes,
you've
ma'am.
already been sentenced. So I'm not going to do anything on just what's happened verbally with ideas being passed back and forth today. There needs to be a specific written agreement.
I respect that.
Yeah, so
you
y'all
know,
get it in writing, what you decide, if you reach an agreement, and then, of course, the court will then make the appropriate inquiries of Mr. Brown and
Your Honor,
impose the agreement.
It probably won't take us long to negotiate. Is there any way that we could put him on for the Thursday jury review, even though it's not a jury review at 9 a.m.? That would give us
That's fine with the
48
state, Your Honor.
hours.
Is it too late to put him on, if he appears on Zoom, to put him on the docket for Thursday? Okay. Mr. Brown, we're going to set you for a hearing 2 days from now, so you don't have to wait a long
Thank you, Judge
time.
Clark.
And in the meantime, what's going to happen is Mr. Medina and Ms. Gaynor are going to work out some sort of written agreement to propose to you. Mr. Medina will be in contact with you about that, and then you'll have to get his signature on it.
Your Honor, during times of COVID, there are ways of basically doing it where I'll make sure that he is aware of the terms and conditions, and basically, it should be a simple matter to make sure he's fully advised and consent.
Well, you could get it in writing, you could email it to wherever he is. He could print it out, sign
Sure.
it, and they could email it back. And
Sure.
it wouldn't be a wet ink copy, but at least he will have had a paper copy, he will have read it, and he will have signed it, and then that would give me assurances.
We'll work something out.
Okay.
Judge.
Then why don't we set you, sir, at 9 o'clock Central Time? Now, I have several cases that morning, so I appreciate your patience today. You did wait quite some time, I know. You may have to wait Thursday morning as well, but getting you back in 2 days is about as fast as we can make it happen.
Thank you, Your Honor. I appreciate
Yes.
Sam's cooperation, too.
Okay, so Mr. Brown, it's the same Zoom link.
Okay.
2 days
Yes, ma'am.
from now, which is April 24th, 9 o'clock Central Time, and be prepared to wait until we can get to your case, but just log in just like you are right now, okay? Same Zoom.
Thank you, Your Honor.
Thank you so much,
Thank
Judge
you.
Clark.
Thank you.
I
See you.
understand. Thank you.
See you then.
Your
Okay.
Honor, I'm sorry to interrupt.
Oh, you're on it, okay.
Okay, we're going to take one more case, and then we've got to take a break because we have been sitting here for 2 hours, the clerk and I, without a break.
Thank you, Your Honor. I
Sure,
appreciate this will be
it's
very quick.
Andrea Wade?
Yes.
24 CF 1796.
Yes, Your Honor. This is a VOP. This is the first time the VOP is up. Ms. Wade would like to enter a denial. If we could set it for the next court date, there is a possibility my office will have to withdraw, but either way, the offer from the state is an incarceratory offer, so need time to discuss it with Ms. Wade.
Okay, and I'm not sure who's on this case for the state.
That's me, Your Honor.
Okay, I'm noting there is a new law offense, 25 MM 513, and we will go ahead and set the case for May 20th at 9 o'clock.
Thank you, Your Honor.
Sure.
Ms. Wade, if you'll step out this way.
I issued a warrant for the VOP based on the new law. Sorry?
I would have liked to know that earlier, just given her medical condition. I was trying to get her out of court. That's why we called the case now.
Yeah, well, this new law occurred 3 weeks after she pled, so. All right, we're going to take a 10-minute break, and Mr. Catalinic, I know you, I'm not sure where you are on the list, but there is a witness on Zoom for your hearing. I told her to show up at 11, so she's already in the waiting room and going to have to take your case next, okay? When we come back from the break.
All rise, please.
What does Catalina have now?
Bond here.
With you?
Okay. Up $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Bonnie Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Dixon?
Yes, Your Honor. Kirby Lynn Dixon is my first one, 23 CF 816. It's a motion to reinstate bond.
Okay, just one second.
This was the case, Your Honor, that we, okay.
Yes, I just have to find my paperwork, and I do have the pretrial officer on Zoom.
Yes, Your Honor.
And yes, this is Kirby Dixon, 23 CF 816. We're here on defendant's motion to reinstate or set bond. Are you still requesting a furlough? I think that was
No,
part of the
Your
motion.
Honor.
Okay, no.
He passed.
Sorry. Okay. All right, and Mr. Dixon is present. Good morning, sir. All right, Mr. Catalinic, let me see who's appearing. Oh, it's Mr. Sprouse for the state.
Yes, Your Honor.
Okay, and I believe, Mr. Catalinic, you have filed a limited appearance just for bond purposes. Is that right?
That is correct.
Okay. Okay, so how would you like to proceed?
Yes, Your Honor. This is basically about his bond he had a $72,500 bond, Your Honor, and he has been continuously incarcerated since January 15, and the reason his bond got revoked, Your Honor, is because he had a GPS monitor and it malfunctioned, and that's why, obviously, the state's not saying that it malfunctioned. And that's why we wanted to hear the pretrial officer to what he has to say. But regardless enough, Your Honor, he's always communicated with pretrial services while the monitor misfunctioned.
Okay.
He called in every week is what I'm trying to say.
All right.
And it wasn't because of a new charge, obviously.
Okay. So, State, do you want to respond at this time, or do you want me to go ahead and get the...
I don't need to respond at this time. I'll waive. I would just call Officer, hopefully I don't butcher her last name. I think it's LeQuay.
Okay. She is on Zoom. Officer LeQuay, can you hear me? And you're on mute. Oh, there we go.
I apologize, Judge. Let me adjust my volume 1 second.
No problem. And we cannot see you also.
Yes, ma'am. I am working on that.
Okay.
She can have to see her swear in.
I'll swear her in just a sec.
I apologize, Judge. I'm on my private computer and I am not able to get the camera working at this time.
Okay.
We don't have a problem with that, Your Honor.
Okay.
She's fine.
Okay. Any objection?
No objection.
Okay. All right, so, Officer, I am going to swear you in, and the attorneys have stipulated that it's okay for you to testify without us being able to see you, as long as we can hear you, which we can. So first of all, if you will raise your right hand and let me swear you in.
Yes, ma'am, I am.
All right, thank you. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
Yes, I do.
Thank you, and if you'll state your name loudly for us, please.
Officer Tiffany LeQuay with Okaloosa County Pretrial Services.
Thank you. All right, Mr. Sprouse, if you could get near a microphone and whenever you're ready.
Good morning, Officer LeQuay. How are you today?
I'm good.
Thank you for coming today. Where do you work at?
Okaloosa County Pretrial Services.
And how long have you worked there?
I have worked there for 9 years, going on 10.
Okay. And do you, on pretrial, as your normal duties for pretrial services, do you supervise releasees?
Yes, sir.
Okay. Are you familiar with Kirby Dixon?
Yes, sir.
How are you familiar with Kirby Dixon?
He was on my caseload from May 24th of 2023 until I filed his bond revocation. Well, actually, he maintained contact with me even after the bond revocation. So he maintained contact with me until he was reincarcerated in January of this year.
Okay. And when did you file that bond revocation? Did you file that with the clerk of court?
Yes, sir. That was filed on May 22nd of 2024.
Okay. And what was the reason for the bond revocation?
The cause for the bond revocation was that the GPS device did die and completely disconnect. Mr. Dixon did advise that he had temporarily lost his charging cord, but that he had found it after the fact. But at that point, the device had disconnected to the point we could not get it to reconnect. He was instructed to report into our office. However, he expressed extreme financial issues as well as not having transportation. He lived in Mississippi and was unable to return in a timely manner for us to troubleshoot the device and get a new device on him.
Okay. So was he unable to comply with pretrial release?
He was unable to comply with the GPS portion of his release, yes.
Okay. And you have had contact with him and told him how to become in compliance with pretrial services, correct?
Yes, sir.
And to your knowledge, he's refused to do that, correct?
He expressed he was unable to report in a timely manner to get that addressed, yes.
Okay. That's all I have, Your Honor.
Any questions?
Yes, Your Honor. Just briefly, officer, was the malfunction of the GPS monitor definitely Mr. Dixon's fault or not? Can you say that for sure?
It was due to a lack of the device being charged, so yes, I would contribute that to his negligence as far as losing the charging cord and not being able to adequately charge it.
But he didn't tamper with it, in other words, try to take it off or anything like that, did he?
No, sir, not that I am aware of. Once we lost connection with the device, I don't know what happened. But he maintained weekly contact with me up until he was reincarcerated.
Your Honor, and based on that, I don't have any other questions.
Okay. Anything further, Mr. Sprouse?
No, Your Honor.
I have a question. And how long was he given to come to report in to try to fix the device?
He was advised on May 7th of 2024, and the bond was revoked on May 22nd of 2024.
Okay. Does either attorney want to follow up on that testimony?
No, Your Honor, we don't have
Okay.
anything to say about that. It looks like it wasn't his fault, Your Honor. There may have been charging problems, but he always maintained contact. His goal was never to abscond from pretrial services, and he wasn't on the state, he doesn't have a car, he doesn't have any transportation. I don't even think he has a license.
Well, forgive me for stating the obvious, but if I were to grant the motion, how's he going to get back to court?
My mom.
Okay.
My mom.
Okay, so you'll be able to come back to court from Mississippi?
Yes, ma'am. I promise you I will.
Okay.
Your Honor, if you look in the court file, there's a lot of waivers have been filed for Mr. Dixon's appearance. This is a very old case, and also a very serious case as well. We're trying to bring this in for a landing, but it has been postponed.
The case is 2 years old, so how close are we to getting it resolved?
Depositions have just been rescheduled. We've already had depositions.
Okay. So I don't have my notes from when we were in court on the 16th. I don't remember if I said last continuance on that day or not.
I was not here the 16th, Your Honor. However, it's dependent upon the depositions. The state's ready.
When are the depositions set?
That slips my mind on when the depositions are set. Maybe defense
Sorry to
counsel
interrupt.
knows.
I have been the attorney assigned on this case
Oh, sorry.
for quite a while. We had to reschedule depositions for March 17th because 2 of the deputies had been served and just didn't show up to the first round of depositions, so I rescheduled them. I had to cancel those when my office had to withdraw.
Right.
So I'm not sure if those depositions have been rescheduled. If my office does get reassigned, I would like to conduct those.
Okay.
I apologize.
So, sir, there's going to be a time you're going to have to come back to court. The fact that you were on the GPS and then when it disconnected, you were told to come back over here to try to get it fixed, and the pretrial officer gave you a period of about 2 weeks, it looks like, and you didn't come. That's when she submitted the affidavit to revoke the bond. That's a little worrisome about your ability to come back to court when we need you to come back. Okay. And Mr. Catalinic, no matter what I do on this motion, what is your role going forward? Are you going to be continuing to represent Mr. Dixon, or you're strictly here for the bond?
I do not think I will be representing him, Your Honor. Based on after this motion is over, I'm asking the court to allow me to withdraw.
Okay. And then I'll reappoint the public defender's office?
Yes, Your Honor. I think that's appropriate.
Okay. And I believe there was a problem with the application for indigency
Yes, Your Honor.
status, which needs to be fixed. I don't know if it already got fixed.
I gave it to him. Did you take care of it?
I feel that I sent it back.
Okay, good, because that would have to be fixed before I can reappoint the public defender's office. I mean, I can provisionally appoint them, but it does need to be fixed. Officer LaQuay, other than the issue in May when the GPS disconnected and then Mr. Dixon didn't return to have it fixed within that period of time of about 2 weeks, was he otherwise compliant?
Yes, ma'am. He's maintained compliance with every condition with exception of being able to return to get that GPS resolved. And when he was picked up during extradition, his family also maintained contact with me, updated me on his movements and status. So I've had exceptional communication verbally with both him and his family.
Okay, and then it looks like Mr. Dixon was arrested, was it approximately December or January when you were arrested on the warrant?
January 15th is what I have.
Okay. I don't know when you were arrested in Mississippi and then brought. So like about that time? Okay. So what I'm getting at is you didn't have the GPS on, or well, not working, from May until roughly December or January, but you were continuing to check in, and I don't want you to necessarily respond. I'll ask the officer that. Is that right?
Yes.
Okay.
That is correct.
And are you aware, officer, of him picking up any new charges?
I do not have any knowledge of any new charges that he's picked up.
Okay. I am going to grant your motion and reinstate pretrial services. You will get a new GPS. You must keep it charged. I cannot say that enough. If you fail to charge it or lose the cord or for whatever reason there's a violation of the GPS monitoring requirement, then another warrant's going to be issued. I'm not going to be as sympathetic to the situation or look as kindly upon such a motion to reinstate it for a second time if the same thing happens again, or if there's some other violation, okay? So I will grant the motion. You must have a GPS applied before you're released, and I don't know what you need to do, but you got to keep that thing charged. Do you understand? Okay, you'll need to keep in contact with Officer LaQuay. It'll be the same terms and conditions as previous. So I'm reinstating whatever bond conditions you previously had.
Your Honor, is that a monetary bond?
Well, was there, let me see what there was.
There was, Your Honor, it was a $72,500 bond last time.
Well, I don't know what the bondsman's position on that would be.
Yes, Your Honor.
But, let me just look for a second. Yes, it was all cash or professional bonds, and I see the amounts that were set. I'll read them out. It looks like it was $15,000 on count 1, which, by the way, in my philosophy is a very reasonable bond for that charge. Typically, I would set a much higher bond on that charge. Same thing with count 2, it was $15,000 cash or professional. Count 3 looks like $10,000 cash or professional. Count 4 was $5,000 cash or professional. Count 5 was $2,500 cash or professional. And count 6 was $2,500 cash or professional. I'm just reading that off of the clerk's site. The court would reinstate the bonds in that amount. That's what they were before. I'll reinstate it.
Yes, Your Honor.
So I don't know what you need to work out with the bondsman. I don't know if you'll have to pay another premium to the bondsman or not. I don't know. But whatever the terms and conditions that you were under previously, those would be reimposed.
Okay.
Okay. All right. So let's figure out when Mr. Dixon's next court date is. That would be, I don't think we've.
No, ma'am, today was also set for pretrial conference.
Okay, it's pretrial conference today as well. So, Mr. Catalinic, are you moving to withdraw?
Yes, Your Honor, I would like to.
I am granting that motion, provided you send me an order.
I will.
I have a fill-in-the-blank one, but it would be nice if I could list out. In fact, I can give you my blank one if you want to handwrite all of the terms and conditions that he previously had.
Yes, Your Honor.
And just hand it back to me. I signed it.
I will send it back today.
You can hand it back to me before you leave. Just fill it all in.
Yes, Your Honor.
And then hand it back to me, and then I'll enter it today.
Yes, Your Honor. Thank you.
Sure, if you could just fill in all those amounts and all the pretrial services and terms and conditions and whatnot, and let the state look at it.
Yes, Your Honor.
And then I am granting your motion to withdraw. I'm reappointing the Office of the Public Defender. So next we will have the pretrial. And
Thank you.
sure, if you don't mind, just fill that out.
Say that again. You have to pay the money.
So if you could just fill that order out and get it back to me so that I can turn it into the clerk.
Yes, Your Honor,
Since
I will
it's
take care of
already-
that. I have one more case.
Oh, yes, okay, thank you. Well, let me take care of Mr. Dixon first on his pretrial. Mr. Dixon, wait just 1 minute. I'm reappointing the PD.
Yes, Your Honor.
This is our pretrial, and I know the charges are serious. You need to reset depositions.
Yes, please.
Okay, so I will go ahead and continue the case, and it will be June 9th. June 9th at 9 o'clock is pretrial, and I know Ms. Farkas will go ahead and get those depots reset.
Yes.
Okay? Thank you. Thank you, sir. Officer LaQuay, does he need to check in before he leaves to go back to Mississippi, or will you go see him at the jail, or what?
We will see him at the jail when we hook him back up on his GPS, and I will actually give him an extra charging cord to take with him. So he'll have 2 charging cords.
Excellent. Thank you so much. Thank you, sir.
Thank you.
Thank you.
Your Honor, that's a plea. May I approach?
Yes. Thank you very much.
That's the lowest.
All right, this is case 23 CF 1816, Alexander Buena.
And I read everything to him, Your Honor, back there, so he understands all of his rights.
Okay.
May I approach again?
Yes. Good morning, Mr. Buena. If you could please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name, please.
Alexander Michael Buena.
Thank you. You're here on allegations that you violated your probation. And, sir, have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, sir.
Did you discuss the plea agreement with your lawyer?
Yes, sir.
Did either you read the agreement or did someone read it to you?
Yes.
Do you understand the agreement?
Yes.
Is this your signature on the last page? Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations? Is anyone forcing you or threatening you to make you enter an admission today?
No.
Has anybody promised you anything other than what is showing on your agreement?
No.
Are you on any medication, drugs, alcohol, or anything like that?
No.
Have you had enough time to talk to your lawyer?
Yes, sir.
Are you admitting to the allegations that you violated your probation? I accept your admission. I find it was freely and voluntarily entered. Is this a revoke and terminate?
Your Honor, I believe it's a revoke and terminate.
Okay.
Yes.
And
60 days in the county jail. He has 2 counts of a VOP. They're both original misdemeanors.
okay, and was there previously an adjudication of guilt on those misdemeanors? I suspect there was.
He was guilty on the misdemeanors.
Okay.
Yes, he was.
Okay. All right, sir, in accordance with your agreement, then if you have not been previously adjudicated guilty on the underlying charges you are now, the misdemeanors or whatever it was you pled to, and actually those charges look like resisting an officer without violence and leaving the scene of an accident without giving information with more than $50 in damage. It looks like what those charges are. And your probation is revoked and terminated, and you are sentenced to 60 days in the Okaloosa County Jail on each count, concurrent with credit for time served. In addition, whatever fees, costs, and fines were already imposed, if you haven't paid them, those still remain outstanding. There will be a $100 additional violation of probation fee and cost of transportation reimbursement to Okaloosa County Sheriff's Office in the amount of $58.05. And do you want those reduced to a lien, or
Yes, Your Honor.
does he want a certain amount of time to pay, or?
We reduce it to a civil lien?
Yes.
In case, Your Honor, because I think he has a hold for
Oh.
Leon.
Okay. Well, then all outstanding fees, fines, and costs will go to a lien. So you'll have to pay that off before you get your driver's license reinstated. This is going to suspend your license, okay? Sir, you have 30 days to appeal the disposition order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you. Thank you, Mr. Catalinic.
Thank you, Your Honor. So
Thank you. Oh, don't forget that order.
Yes, Your Honor.
Okay, thank you.
Thank you. I have it ready in my approach.
Yes, thank you.
Mr. Strauss,
Perfect. Thank you. Let me just. Okay, thank you. Mr. Gilbert.
Morning, Your Honor.
Good morning. Thank you for your patience. It has been a long morning. I appreciate your patience.
Two cases, both inmates. The first is Chester Cooper. And in both of these, I have pleas. They're aware of them, but they haven't been able to sign them.
Okay.
Physical limitations.
24 CF 1213, Chester Cooper Jr.
Yes, Your Honor, and also 25 CF 586.
Yes.
And may I approach? Please?
Yes, thank you. Okay.
Okay. It's everything we discussed.
All right, thank you. Perfect, thanks.
So, Your Honor, in 24 CF 1213, the defendant admits the VOP. He's going to be reinstated and adjudicated. And then in 25 CF 596, counts 2 and 3 are going to be dropped. In count 1, he's going to be adjudicated guilty. And so 1 year probation concurrent with 24 CF 1213.
I'm sorry, can you repeat? I heard a different case number that's not on the docket. Can you repeat that one, please?
So I might have said 596. I believe it's 586.
It's 25 CF 586, that's the new law, and then 24 CF 1213 is the VOP, if I'm not mistaken.
That's what I have here.
And then can you please restate the sentence?
Sure. In 24 CF 1213, admits VOP, is reinstated and adjudicated. In 25 CF 586, counts 2 and 3 are dropped. Count 1 is adjudication guilty. 1 year probation concurrent with 24 CF 1213. There's a 1 year driver's license suspension, and there's no objection on the state's part to a hardship license being issued.
All right, Mr. Cooper, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you'll just state your name, please.
Chester Cooper.
Thank you. Are you Chester Cooper Jr.?
Yes, ma'am.
Okay, just making sure. Sir, in case 24 CF 1213, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am.
And do you understand that by entering into an admission of those allegations that you're giving up your right to have a contested hearing, at which time the state would have to prove the allegations?
Yes, ma'am.
Is anybody forcing you or threatening you to enter an admission on the violation of probation?
No, ma'am.
Okay, are you freely and voluntarily admitting that you violated your probation?
Yes, ma'am. I'm just ready to go see my kids.
Okay. Has anybody promised you anything other than what's showing on your agreement?
No, ma'am. At first, there was something different, but we come to a different agreement.
Okay, so I've been handed a plea and sentencing agreement. It does include both cases, the violation of probation case that I just mentioned, and also the new case, 25 CF 586. Did you have a chance to read the agreement?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Is this your signature at the top of the last page?
Yes, ma'am, it is.
Did you discuss the agreement with your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Do you need any more time to talk to your lawyer about the agreement or anything else that we're doing here today?
No, ma'am.
In case 25 CF 586, you're charged with 1 count of fleeing and eluding, failing to stop for law enforcement. That is a third-degree felony. 1 count of, I'm going to have to look this one up, is it using marijuana in a vehicle?
Yes, Your Honor. It's
Okay.
medicinal, but that was dropped.
Okay, that is a misdemeanor, and 1 count of resisting an officer without violence, and that's also a misdemeanor. So, did you have a chance to talk to your lawyer about those charges?
Yes, ma'am.
Did you discuss your options in the case, like defenses you might have and ways you might have of working out the case?
Yes, ma'am.
Yes. Okay. I don't believe an information has been filed.
Your Honor, it would have been filed this morning. I did sign it late last night and put it on my assistant's desk this morning, so it will, if it's not already filed, it will be filed today for sure. I would imagine, though, it's already filed this morning.
And do you know if the counts are remaining the same order
Yes,
and
it's,
everything?
yes, I changed it on the plea agreement to my information. Count 1 is the fleeing and eluding, and the misdemeanors are count 2 and 3 that are being dismissed.
Yes, the resisting is count 2 according to the plea agreement, and the use of marijuana in a vehicle is count 3 according to the plea agreement. Count 1 is the felony charge, fleeing and eluding.
Thank you.
Yes, absolutely. Thank you for bringing that up. Sir, I think I've probably already asked you this, but I want to make sure. Is anybody forcing you to enter the plea today? Is anybody threatening you?
No, ma'am.
Has anybody promised you anything other than what is written on this agreement?
No, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions? Have you had any drugs? Well, first of all, I need you to answer out loud to that last one. Did he
Yes,
answer
ma'am.
everything? Okay. Have you had any drugs, alcohol, medicine, anything like that in the last 24 hours?
No, ma'am.
Are you suffering from any mental illness that affects your ability to understand what you're doing?
No, ma'am.
I have a score sheet that shows 32.4 total sentence points. Any objections? Is there any DNA? Okay. I do find a sufficient factual basis based on my review of the arrest report. I also reviewed the violation of probation affidavit as well. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. In case 24 CF 1213, are you admitting to all of the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. And in case 25 CF 586, how do you plead to counts 1, 2, and 3?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In case 24 CF 1213, you will be adjudicated guilty of the underlying charge, which is possession of a controlled substance without a prescription. And you will be reinstated to probation under the original terms and conditions. In case 25 CF 596, on count 1, that is the fleeing and eluding count, you will be adjudicated guilty. You will be placed on probation for a period of 1 year, concurrent with case 24 CF 1213. That means at the same time. Under the same terms and conditions, there are some additional terms and conditions. 1 year driver's license suspension. I believe that's required by a statute. And adjudication in the 2024 case on that charge would also result in the same. And there's nothing I can do about that. That's required by the statute. The state has no objection to you obtaining a hardship license. The court would have no objection either if you qualify. I'm not in charge of Department of Highway Safety and Motor Vehicles. I can't tell you if you're going to qualify or not. You have to apply and go through their process. But there is no objection to you getting one as long as you qualify for it. Okay? It's my understanding you fill out some forms and then you have a hearing with a hearing officer with the Department of Highway Safety and Motor Vehicles, and then they'll make a determination if you qualify or not. Okay? I cannot order them to give you one. So, did I leave out any terms or conditions? Court costs, let me address those. On the 24 cases, $100. Yes, on the 2024 case, that's the one that you were on probation for. There's an additional cost of $100 cost of prosecution, in addition to whatever fines, fees, court costs were previously imposed when you were placed on probation. In the new case, 25 CF 586, let me see what those would be. 548? $548 in court costs. And does the state have an announcement on counts 2 and 3?
Your Honor, the state will be null crossing counts 2 and 3 in exchange for a plea to the other counts.
Okay. Did I leave out anything else or anything else I need to cover? All right. Sir, is this the only thing holding you in jail?
Yes, ma'am.
All right, you should get out today. I don't know if you'll get back to the jail and get out in time to report to probation today. So let me see what probation wants you to do.
Close at 5, you get released prior to that, and make it 4 p.m. If not, make it by 0 tomorrow.
Okay. So, sir, you need to, if you can't make it there today, you need to be there before 9 o'clock tomorrow to check in. If you fail to report, that would be a violation. Do you understand?
Yes, ma'am.
Okay, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
All right, thank you.
Thank you.
Next case, Your Honor, Sean Florence, 22 CF 2607. This is also a VOP.
Okay.
Any questions? any questions?
Yes, thank you. Thank you so much.
At this time, Mr. Florence would like to admit to the VOP. His probation will be revoked and terminated. He is to be sentenced to 5 months at OCJ. He still has some DUI things to accomplish, and then his monetary would go to collections.
Okay. All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do. Thank you, sir. You can put your hand down if you'll just tell me your name. Thank you. You're here in case 22 CF 2607, and you're here for allegations that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss with your lawyer your options, including how you might fight the case?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
And is this your signature at the bottom of page 3?
Yes, ma'am.
Do you understand the rights that you're giving up by entering a plea?
Yes, ma'am.
Is anybody forcing you or threatening you to make you enter a plea?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you on any drugs, medicine, alcohol, any type of substance?
No, ma'am.
Have you had enough time to talk to your lawyer about your decision to admit the allegations? You have? Okay. Are you satisfied with his services?
Yes, ma'am.
Are you admitting to the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered in accordance with your agreement. If there's not already an adjudication of guilt on the underlying offenses, which are DUI, third violation, or more within 10 years, I'm having a hard time reading that abbreviation.
It's outside. That's what
Outside.
he originally pled to. That's why it's a misdemeanor.
Gotcha, okay. Third or more violation, but not within 10 years.
That's correct.
Okay. And driving while licensed suspended with prior convictions?
Yes.
Okay. If there's not already an adjudication of guilt on those, there will be now. And in accordance with your agreement, probation is revoked and terminated, and you are sentenced to 5 months in the Okaloosa County Jail on each count, concurrent with credit for time served. And all the non-monetary conditions of your probation will be D6. That means it's going to your license. You have to get those taken care of before you can get your license reinstated or any type of limited license. All the monetary obligations will go to collections. In addition, there's a $100 VOP cost of prosecution fee that'll be imposed as well. It'll go to collections. Did I leave out any terms, conditions, or anything?
That's the state's agreement.
Okay. Is this the only thing holding you in jail?
Yes, ma'am.
Okay. And I don't know how much credit you have. They'll figure that out at the jail. But good luck to you, sir. You have 30 days to appeal the judgment and sentence of the court. And if you can't afford a lawyer, I'll appoint one for you. Thank you, sir.
Thank you, Your Honor. That's all I have.
Thank you. Next on the list is Mr. Dyram. Thank you.
On the docket, Senator Barron, he's an inmate. I'm also covering for Mr. Flowers, if I can do his cases first.
Okay, go
Mr.
ahead.
Flowers has Burgess 24 CF 1981. I believe a PTI has been made as an offer. So if he can place Burgess on May 20th docket for a control date.
All right, State.
No objection, Your Honor. This should fall off.
Okay. So May 20th is just a control date? Is that just to see if the agreement gets filed?
Correct,
or
Your Honor.
Okay.
And then Mr. Flowers also has, I believe it's Mr. Downey, 23 CF 2743. He is back in the hospital, Judge. I believe Mr. Flowers informed the court he had his lung removed recently. Mr. Downey did. So he's in the hospital, and Mr. Flowers has asked to place him on the June 9 docket.
What's the state's position?
That's without objection. Mr. Flowers has been in contact with me about this case. We do have a agreement in principle, however, the logistics with the defendant being in and out of the hospital makes things difficult.
Understood. Okay, well, I understand Mr. Downey, his case number, by the way, is 23 CF 2743. I understand he's got some serious medical conditions. I'm also noting the case has been continued 7 times, and his arrest date is December 11th, 2023. So this needs to be the last continuance. I usually say something like, unless somebody's in the hospital. In this case,
Yeah,
that's
I
the
understand, Your Honor.
case.
I will let Mr. Flowers.
But we need to bring it in for a landing because the case is getting quite old.
Yes,
So
That'll be on June 9th, Your Honor.
June 9th at 9 o'clock, pretrial conference. This will be the last one.
Thank you, ma'am.
Thank you very
I
much.
have Mr. Barron, Cedric Barron in 24 CF 928. Your Honor, if we can set Mr. Barron on 520 with subs.
Okay, would that be for a contested VOP?
I think that's what we want to do, right? I know you wanted to issue a sub, is that for the hearing, or just see if you put those up?
Yeah, I was not moving to set it for a hearing at this time. The state's intention is the victim and I have been playing phone tag for about 2 to 3 weeks. I still have not been able to actually physically talk to her. She has called my office back. I am getting a little concerned with our contact, Your Honor, so my intention was to subpoena her to court on May 20th so that I can make actual physical contact with her and get a definitive answer on her position in this case. So not for an evidentiary hearing, but for me to subpoena the victim.
Okay. And I'm noting there's a new law, 25 CF 418, and I did not write down when that is set, but.
That is set on 6/9, Judge.
Okay.
And it's the victim in the new law case, Your Honor.
Gotcha. Thank you. All right, so why don't we set both cases for May 20th for status?
That's fine, Your Honor.
That'll work, Your Honor.
Okay, and we'll go ahead and, do you want me to go ahead and put it on the June 11th docket?
June 9 or June 11?
Well, it depends on a person's incarceration status.
Okay.
So I can put the cases on June 9th, but then if Mr. Barron is still incarcerated, we'll just move it to the 11th.
Understood.
So
Thank you, Your Honor.
would you like me to put it on the 9th?
Yes, ma'am.
Okay, so status would be May 20th, and that would be what, status of negotiations, possible plea?
To see if the alleged victim is willing to move forward.
Okay. And then pretrial is going to be June 9th at 9 o'clock. Again, if Mr. Barron is still incarcerated, we'll move it to the 11th.
Yes, ma'am.
Okay.
Thank you, Your Honor. Have a good
Thank
day.
you, thank you. Then that would be on both cases that we put on pretrial and status.
Thank you, Your Honor.
Thank you. Okay, that ends my list, and I do see additional attorneys present. So whoever was here next, Mr. Madden.
John Madden here on behalf of Catherine Day. This is 24 CF 2172.
All right, just one second. All right. Got it.
Just waiting for her to come out.
And you're here on a bond motion, or wait, no.
And we're set
I don't
on a
think
later
that's-
date for that particular motion.
Okay. I think I just made a note that there was one in the file.
Well, I'll repeat this when she comes out, but we received a new offer from the state. We've also got our bond motion pending, so all I was looking to do today was get this case moved to the date the bond hearing's already set for either a bond hearing or a potential resolution.
Okay, let me see when that is.
We're hoping to get her out one way or the other.
I believe it's the 20th, May 20th.
May 20th.
That sounds right, Your Honor.
Okay.
And the continuance is without objection.
So So as I was telling Your Honor, we did receive a new offer this morning from the State Attorney's Office. We also have our bond motion pending, so we'd like to just keep this case set for May 20th for that bond motion, and then I'm going to go discuss the new offer with Ms. Day here shortly in the next few days, and then see how it goes on the 20th.
Sounds good. All right, May 20th at 9 o'clock. All right, thank you.
Thank you, ma'am.
Mhm.
Good afternoon, Your Honor.
Good afternoon, Mr. Williams. How are you?
Charles Williams. I'm fine. I've got Mr. Bridges, Broderick Bridges, State of Florida versus Broderick Bridges. That's 19 CF 2270 with Ms. Gaynor for the state.
All right.
And
He will-
as soon as we have a VOP plea agreement for you, and as soon as my client comes out here where he can sign it, I'll pass it up to you.
Wonderful, thank you.
If I could pass it up to you, Judge?
Yes, thank you. Thank you so much. All right. All right, sir, if you will raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. Could you tell me your name?
Broderick Rayon Bridges.
Thank you. You're hearing case 19 CF 2270. You're here on allegations that you violated your probation.
Yes, ma'am.
Have you had a chance to talk about those allegations with your lawyer?
I have.
Do you understand that you have the right to have a contested hearing and make the state prove those allegations, and that by entering into a plea agreement, you're giving up that right?
Yes, ma'am.
Did you read and sign the plea agreement?
Yes, ma'am.
Is this your signature on the back?
Yes, ma'am.
Do you need any additional time to talk to your lawyer before I move forward?
No, ma'am.
Are you satisfied with his services?
I am.
All right. Is anybody forcing you or threatening you to make you enter an admission today?
No, ma'am.
Has anybody promised you anything other than what's showing on your agreement?
No, ma'am.
Are you on any drugs, medicine, alcohol, or any type of substance?
I'm not.
Do I have a score sheet? I can look and see if there's one in the file from before.
Oh, wait. This is Bridges, Broderick. Different Bridges. Your Honor, I can get one to you.
Okay.
I don't have one right now. I have one for another Bridges, not for Broderick.
See. I might be able to find one in the court file and then. I don't see one in the court file.
Your Honor, I do have one here.
Okay.
I will just have to go grab it from the printer, but I do see his total sentencing points are 36.4 is his total sentencing points, Your Honor. His lowest permissible is he does not score.
Okay. I also see the sheriff's office is requesting reimbursement for transportation. That was filed on December 19th, 2024. The amount is $450.15. They had to go get Mr. Bridges from Mississippi. So the court will be imposing that cost. Okay. Any objection to that cost? Okay. All right, sir, are you admitting to the allegations that you violated your probation?
I am.
I accept your admission. I find it was freely and voluntarily entered. It looks like you were already adjudicated guilty of the 2 underlying charges. One of the original charges was null prost, but there were 2 that you're on probation for that you've already been adjudicated guilty of. I am revoking and terminating your probation and sentencing you to 150, that's 150 days in the Okaloosa County Jail on each count, concurrent with credit for time served. All monetary obligations will go to collections. There's an additional $100 cost of prosecution fee. And I already mentioned the $450.15 reimbursement to the sheriff's office for transportation. So in addition to whatever previously imposed costs and fees and fines, those additional costs will be imposed. All of it will go to collections. Did I leave out any of the terms or conditions? Court appointed. Yes, you're court appointed as well, right? So I need to impose $150 cost of defense. That includes the application fee. And that will go to collections as well as the other financial obligations. Did I leave out anything?
I don't believe so, Your Honor. You did say revoke and terminate probation.
Yes, revoke and terminate. And sir, I have no idea how much credit you have, but I'm sure the jail knows. So you'll get credit for time served, and both counts, the sentence runs concurrently at the same time. So good luck to you, sir. You have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Thank you. Thank you.
Thank you, Your Honor.
Thank
That concludes
you.
my business. See you next time.
See you next time. Thank you, Mr. Williams. And Ms. Gaynor, if you could just get me a score sheet on that at some point whenever you get a chance, I'll get it filed.
Yes, Your Honor.
Okay, Mr. Harper, I know that you're here and we have a lot of cases on your docket. I don't think I'm going to be able to get through them before lunch. It's already, oh, you only, yes, you do. Okay, let's go ahead and take those. Sorry, Mr. Harper, I thought you had more.
Not this time, Judge.
Okay.
Judge, this is Desmond Cook, number 28 on the docket. Is this
All right.
what you want to do? To resolve the cases? Yep. Just sign and date. Judge, he's before the court on 24 CF 2220. Judge, he's going to admit the violation of probation. This will be a modification and reinstatement. We are asking to maintain the withhold. The reason for this is the first violation on his very first charge. So we're asking to modify and reinstate, maintain the withhold 45 days in the Okaloosa County Jail. He does have that amount of time in, credit for all time served, and reinstate to complete the original terms and condition and assess all applicable court costs. Since this is a modification and reinstatement, there is no score sheet.
Okay. Thank you so much. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Desmond Cook Jr.
Thank you. You're here in case 24 CF 2220 on allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the back?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing and make the state prove the allegations against you?
Yes, ma'am.
Is anybody pressuring you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing on your agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Are you on any drugs, alcohol, medicine, or anything like that?
No, ma'am.
Are you admitting the allegations that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. And in accordance with your agreement, the court will maintain your withhold adjudication of guilt. And you are being reinstated to probation under the original terms and conditions, and there is a modification. As an additional condition, you must spend 45 days in the county jail on each count with credit for time served, and those will be concurrent. All other original terms and conditions are reimposed. And court costs would be $100 and $150. Okay. The court costs are $100 cost of prosecution on a violation of probation case and $150 cost of defense. That includes the application fee. That's in addition to any costs or fees or fines that were previously assessed when you originally pled. Did I leave out anything, Mr. Harper?
No, ma'am.
State, did I leave out anything?
No, Your Honor.
Okay, thank you. Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. I think it was said that you already have enough credit. I'm not in charge of credit, but if you have, or whenever you get out, you will need to report to probation. If you get out in time to make it there before 4 o'clock on whenever you get out, then you need to go that day. If you can't get there by 4 o'clock, then you need to be there before 9 o'clock the next morning. Okay?
Yes, ma'am.
All right.
Your Honor, if I may point out for both probation and the court's awareness, he does have misdemeanor court with me tomorrow morning at 9 o'clock. So just so that you're aware, he'll probably show up in court. We'll probably resolve that matter and then probably immediately report to probation thereafter.
In light of that, then if you don't get out in time to report to probation today, then you must go as soon as you're done with court tomorrow. Okay?
Yes, ma'am.
All right. So forget the 9 o'clock. Just go right straight from court tomorrow to probation. Okay? Thank you. Good luck to you.
Your Honor, the next case I have is Andrew Atkins, number 27 on the docket. He's present and approaching before the court on 23 CF 1748.
Okay.
Judge, one of the bases for the violations of probation is a misdemeanor charge that is currently set for trial. He's got jury review on May the 7th, so I would ask for a date after. If the court wants to set an evidentiary hearing, that's fine, but to be frank, we will resolve this VOP regardless of the disposition of the misdemeanor case. That we'll resolve this case on whatever date. So if May the 20th is fine, we'll get to a conclusion.
Your
on
Honor, in
that.
light that it's set for trial, the state does not object to a continuance because, of course, based on that outcome, I agree with Mr. Harper, this will be resolved one way or the other.
Okay. So we will set the case for May 20th at 9 o'clock. And sir, you appear to be out on bond on your violation of probation allegations. So I'm directing probation. If there are any further violations, please send me a warrant.
Yes, sir.
Thank you.
And Judge, I noticed that Yolanda Cooper, number 29 on the docket, I'm listed as counsel of record, but this was a pro se motion.
Right,
modification. Okay.
I X'd you off, so yes, you're not attorney of record on Ms. Cooper.
Thank you, Judge. That's all I
Sure.
have today.
Thank you, Mr. Harper. What I'm going to do, we're about to break for lunch, but I know there are some people in the audience that don't have an attorney. You're here on pro se motions. I'm going to try to resolve those as quickly as I can. So I'm going to call you your names and come on up to the podium. And by that, I mean people who do not have an attorney right now. So do I have Yolanda Cooper present? Yes, ma'am. Come on up. I'm Judge Clark. It's nice to see you, ma'am.
Me too.
Okay, Ms. Cooper, you're here on 2 cases. I think only one of them's on the docket because your request only got filed in one, but I'm going to treat it as filed in both.
Okay, thank you.
Yes, your case numbers are 22 CF 1943 and 22 CF 1193. And you're on probation in both of those cases, and you filed a request to terminate your probation early, if I'm reading this correctly.
Yes, ma'am.
All right, let me swear you in. If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. Does the state object to the early termination?
Your Honor, the state did confirm with probation that all of her requirements are complete. Probation has no objection, and neither does the state.
Great. I was hoping to hear that because I did review your case. I saw you had paid all of your court costs from what I could tell. I saw that you have not had any violations, and you've been on probation since September of 2022,
Yes, ma'am.
and you have had no violations. You have done everything we've asked you to do,
Yes, ma'am.
and you've been a model probationer from what I can see. And of course, I'll defer to probation on that, but
She's done everything for officers, but I named her, so.
that's wonderful.
Thank you.
Thank you for being such a wonderful probationer. I'm granting your request and
Thank you.
terminating your probation in both of your cases.
Thank you.
And good luck to you, ma'am. You'll get an order. Let's make sure that the clerk has the right address to mail things to.
Okay.
Just one second. Are you okay with her announcing the
Yeah,
address,
that's
or do you want to? Okay. Of termination, well, it might be provided by probation, I'm not sure, but I want to make sure we have the correct address online.
Yes, the order of termination would be created by her officer, and you would have the correct address on file with these records.
Would y'all provide that to her after I sign it?
I can, I'll just have to give it off to Robert real quick.
Okay, thank you. Good luck, ma'am. Thank you. You're terminated on your probation. Good luck. Anyone else who does not have a lawyer? Okay, sir in the blue shirt. Can you tell me your name, please?
Michael Van Lanningham.
Okay, let me find you on my docket, okay?
What's his last name?
Van Lanningham.
Thank you.
Do you see Mr. Van Lanningham on the
Your Honor, if I may.
Yes.
So I represented Mr. Van Lanningham in the underlying case. I see on CCIS that he does have a court date today. For whatever reason, he's not on my docket. Our office was not reassigned on the VOP, but it is a VOP. And I did speak with probation about it just as a friend of the court and let Mr. Van Lanningham know where the VOP was at.
Okay,
So I think that probation can probably speak to
let me,
what they're asking for, but just
Yeah.
wanted to.
so he's not on your docket either?
No, I don't know why he wasn't, but on CCIS, it does come up that he has a court date.
Number 26.
Ah, thank you. Thank you. Found it. I flipped right past that. The case number is 21 CF 598, and you are here on allegations that you violated your probation. You have the right to have a lawyer represent you. If you can't afford one, I'll appoint one.
Yes, ma'am.
Would you like me to appoint one?
No, ma'am. No, I'm not worried about it.
You don't want a lawyer to represent you on this matter?
No, ma'am. I violated. I didn't pay my monies in time.
Okay. There are, well, that's not the only allegation. Let me read them to you, and then I'm going to ask you the question again about if you want a lawyer, okay?
The other one was dropped, I believe, Ms. Clark.
Sir, you're being recorded, by the way, and there is a table full of prosecutors listening to everything you
Okay.
say, so I'm encouraging you not to talk about any of the facts. Okay, there was a violation of probation affidavit filed on February 12th, and the allegations are, number one is there was a new law offense alleged of battery domestic violence on or about November 18th, 2024. Before you say anything, I'm aware that there was a no pros filed in that case, which factored into my decision to set a bond in your case, which I am not known to do very often in a
Yes.
violation of probation case.
Thank you for that.
Allegation number two is financial. It was failing to pay the cost of supervision for probation every month, and you were alleged to be $240 in arrears as of February 5th. Then count three was failing to make court cost payments, and you were $1,983 in arrears as of February 5th. Those were the three allegations in the amended affidavit. I don't see any updates after that. I'll ask you again if you would like a lawyer to represent you in this matter.
I was just looking to get this finished today, kind of. I don't know if that's a.
I'm not sure what the state.
Your Honor, Ms. Farkas had forwarded me an email from the probation officer, Mr. Profit, and it looks like since the underlying, well, it's not the only violation, there's also the monetary obligations, but the new law violation was dismissed by the state and county court. So it would look like the only outstanding terms are the monetary obligations, and the state would offer to just have that go to a civil lien and have the probation terminated.
Okay.
Could I maybe have some time to pay it before I went to a civil lien?
If Your Honor would like to set a control date for next court date, if he pays it off by then, the state can just dismiss at
Well-
that point, if it's done.
I mean, it can go ahead and be turned, I mean, if I'm gonna have to have another court date, I'd rather just be put to a civil lien.
Okay. I mean, it's a sizable amount. You can see the clerk to work out a payment plan. Is that something you'd be interested in doing? Or,
As long as it doesn't require me to have another court date, I'm fine with it.
looks like you were placed on probation for 6 months. That was in September of 2024.
Yes, ma'am, that was my extension to have time to get my DUI class done.
Right. So do you understand if the fines and costs go to a civil lien, then that's going to affect your driver's license?
Yeah, I have to
You're
pay
gonna
it
have
for.
to pay it off.
Yes, ma'am. And I'm in the middle of getting my hardship, so I will have to pay it off.
Okay. What's the state's position?
Your Honor, the state would ask that the probation terminate and the monetary obligation go to civil lien. That's the state's offer.
Is that what you're wanting to do,
Yes.
sir? All right, the court will do so. So your probation will be terminated. All monetary obligations will be reduced to a civil lien. And let me check with probation to make sure those amounts that are in the affidavit are still good.
This is the VOP.
It's $240 in cost of supervision as of February 5th. Is that still good?
According to Officer Profit, that would be correct.
That is right?
Yes, ma'am.
Okay, and then the court costs, I can check with the clerk. I see a total of $1,983 still owing, is that right?
Yes, ma'am.
Okay. Would there be a $100 VOP fee? Okay, there's an additional $100 violation of probation fee that's imposed as of today. So let me actually place you under oath. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. State your name one more time.
Michael Colbert, Landingham.
All right, in case 21 CF 598, I think we've already covered this ground, but I want to make sure I get it on the record under oath.
Yes, ma'am.
Sir, I've offered you an attorney. You said you're declining, is that
Yes,
right?
ma'am.
Okay. Are you admitting to the allegations, the financial violations that are alleged? Okay. The court finds that you're making a free and voluntary admission. As per your request, I'm going to terminate your probation and find that you, well, what findings does the court need to make, either probation or state? Do I need to find successful completion except for these monetary obligations, or just terminate it, or what?
Successful termination due to outstanding obligations.
Okay, then the court so finds that, and so it'll be terminated, the monetary amounts that I just mentioned, plus the additional $100 cost of prosecution for this VOP. That'll all go to a lien, so you'll have to take care of it before you can get your license or a hardship license or anything.
Yes, ma'am.
Okay.
Thank you, Ms. Judge Clark.
You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one. Good luck.
Thank you so very much,
Thank
ma'am.
you. All right. Let's see, do I have another person who does not have an attorney? Yes, sir. Can you tell me your name?
My name is Michael Bailey, Your Honor.
Oh, yes, sir. Okay.
Oh, yes. That's true.
Bailey with a B, not a D.
Okay, that's case 21 CF 495, and I have your paperwork handy. And you're here on a motion that you filed. You wanted to modify your probation to reduce the cost of supervision to a lien. Is that right?
Yes, ma'am. I'm not looking to avoid what I owe the court or whatever. Since I've actually written you that, I've actually paid almost $1,000 towards it. The reason I'm asking for this is because I'm financially just pulled in every direction. I had $3,000 in child support, which is paid off now.
Wow, that's fantastic. So let me see what the state's position is. Let me make sure I'm right. The sole request in your motion is to get your probation fees and cost of supervision just converted to a lien, and you wanted time to work out a payment plan with the clerk. That's it, right? Was that the only thing you were requesting?
Yes, ma'am, and I'd also like to note that on my probation, every single requirement has been completed except my financial obligations, minus what I've already paid on it in the past month.
Okay. So let me see what the state's position is about converting the cost of supervision to a lien.
Your Honor, the state's not gonna have any objection to that. I'm not sure if it's even possible at this point to maybe even get the cost of supervision waived for the remainder time. But the state would have no objection to that either.
What's probation's position?
Waive cost of supervision, Your Honor.
Would that mean the arrearages as well?
Yes, Your Honor.
Even better. Probation has just waived your cost of supervision, even the part you still owe.
Okay,
So they've-
thank you very
they
much, Your
have-
Honor.
Yes, sir. So that is now, you don't have to pay that, and that's removed as a requirement of your probation. Continue to abide by the terms and conditions, and at least that'll take some pressure off of you. All right?
Yes, ma'am, thank you so much.
Thank you. And let's make sure we have a good address for you. You did give your email address in your motion as Michael A. Bailey 333?
Correct, at gmail.com.
Okay, wonderful. Thank you, sir, and good luck to you. All right?
Thank you, Your Honor.
So continue to report as you're required to do, but at least this takes care of the financial supervision.
Yes, ma'am.
Thank
Thank
you.
you.
All right. Do I have anyone else here who does not have a lawyer? Okay, it is now 12:37. We are going to have to take a lunch break for about an hour, and then we'll come back and resume. Oh, I'm sorry, Mr. Nopes, I see you sitting there.
I think mine will be quick.
Okay, let's take Mr. Nopes, and then we are definitely going to break for lunch.
Christopher Ballou,
Okay, he's got 3 cases.
he does, Your Honor. We've already covered the plea agreement. He just needs to sign it.
Okay. And Mr. Ballou is 23 CF 2001, 23 CF 2029, and 24 CF 2666. And he is present.
I may approach, Your Honor.
Yes. Thank you so much. Thank you. All right, sir, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. If you'll just state your name for me.
Christopher James Ballou.
Thank you. Sir, you're here on the following charges. In case 23 CF 2001, you are here on 1 count of possession of a controlled substance without a prescription, that's a 3rd-degree felony, and 1 count of possession of drug paraphernalia, which is a 1st-degree misdemeanor. In case 23 CF 2029, you're here on 1 count of vehicle theft, that's a 3rd-degree felony, and 1 count of false ID given to law enforcement, which is a 1st-degree misdemeanor. In 24 CF 2666, you are here on 1 count of possession of a weapon or ammunition by a convicted felon, which is a 2nd-degree felony. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Yes, ma'am.
All right. Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is this your signature at the top of the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to have a trial and make the state prove the charges?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Is anybody forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours that would affect your ability to understand what you're doing?
No, ma'am.
I have a score sheet that shows 43.6 total sentence points. Any objections?
No objection.
Okay. Any DNA in any of the cases?
Not that I'm aware of.
All right. I do find a sufficient factual basis based on my review of the arrest reports and all of the cases. Sir, do you understand that if you are not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right. In case 23 CF 2001, it looks like you're pleading to a lesser included offense on count 1, which is possession of paraphernalia. That's the same charge as count 2. So in that case, how do you plead to 2 counts of possession of drug paraphernalia, which is a first-degree misdemeanor?
No contest.
No contest.
All right, I accept your plea. In that case, I find it was freely and voluntarily entered. And in case 23 CF 2029, how do you plead to counts 1 and 2?
No contest.
I accept your plea. On both of those counts, I find it was freely and voluntarily entered. Does the state have an announcement on 24 CF 2666?
Your Honor, the state will be null processing in exchange for a plea to the other counts.
All right, sir. So the state has just dismissed one of your cases in exchange for your plea. And in accordance with your plea agreement, the sentence, is this going to be on the felony case or?
Judge, I think it needs to be on 23 CF 2029, because the misdemeanor should be time served.
Okay, and it probably says that on here. I'm just looking
I
through.
don't know if I was, that's what I was glancing at, to be honest with you. I don't think it does say that, Judge.
Okay, let me write that down. Is that the state's agreement as well?
Yes, Your Honor.
Okay, in case 23 CF 2001, that's 2 counts of possession of drug paraphernalia. Both are first-degree misdemeanors. And the sentence on each of those is time served. And let me get the costs on that case. And I think Mr. Mopes is probably court-appointed.
I was appointed on that case, both of those cases.
Okay, so that would be $270 in court costs and $150 cost of defense. Let me write that on here somewhere. In case 23 CF 2029, on count 1, you will be sentenced to, well, there's an adjudication of guilt on all charges. So count 1, that's grand theft auto, you'll be sentenced to probation for 2 years with the following special conditions. You must enter into Phoenix House and complete that program successfully. Is this a bars to bed? Yes, I see that now. Bars to bed. So you have to remain in jail until Phoenix House comes and gets you. And also, you must complete a substance abuse evaluation and treatment. I think Phoenix House will take care of that. Yes. You'll have to do 24 hours of community service work. You may not have any contact with Ian Holding. And let me see what the costs are. 515? 100, okay. So in case 23 CF 2029, the costs are $515 plus $100 defense fee. And on count 2, in that case, it's just a sentence of time served. And did I leave out any of the terms and conditions?
No, ma'am, it wasn't part of my agreement with the state, but he asked me to ask you if you would waive the cost of supervision while he's in Phoenix House.
I will see what the state and probation have to say about that.
The state has no objection. I do want to clarify the no contact with the victim. My co-counsel just informed me that Ian Holdings is actually Enterprise Rental Company.
Oh.
So I just want to clarify, no contact with Enterprise.
Thank you. The way it's written, I thought it was a person, so.
Well, I did too, Judge.
Okay, so no contact with Enterprise Rent-A-Car. Let me write that on here somewhere.
No, that's the LLC EAN Holdings Enterprise Alamo National.
Boom.
I think both. Is it?
It'd be both, Your Honor.
It's both. Yeah, I think it's one and the same, or the parent company or something like that.
Pseudonym
Yeah.
or fictitious name.
Yeah.
But
And
it's not.
let me ask probation about Mr. Ballou's request for waiver of cost of supervision while he's in Phoenix House? Okay, that's granted, sir. Yes. I'll write that on here as well.
At least that's at the office. That'll be quick.
Any other terms, conditions, or anything I need to cover?
I think that's it, Judge.
Okay, so Mr. Ballou, I just want to bring up with you, you're very, very close. You're on the cusp of scoring prison. I know you will take this very seriously. Everyone in this courtroom wants you to succeed. We really do. And I just need to make you aware that if there are any violations, you're likely going to score prison, okay? Please take this seriously. Phoenix House can help you. I'm excited for you to go there, and everyone in here wants you to do well there, okay? Good luck to you. Yes. You have 30 days to appeal. If you cannot afford a lawyer, I will appoint one for you. Sincerely, good luck to you.
Thank you.
Thank you.
Judge, the next plea I have is Samantha Jo Hill,
Okay.
and then I'll back up. I don't know what's going on in the other case.
Okay, this is case 24 CF 1202. And this is a motion to withdraw habeas, I believe.
Judge, actually, we're going to enter a plea, so we would,
Okay.
I guess, we withdraw our motion to set aside plea or to withdraw cases. I mean,
Yes. Thank you so much. All right, ma'am, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do. Thank you, ma'am. You can put your hand down if you'll just state your name, please. Thank you. Mr. Nopes, I had to write on the agreement the $50,000 fine. I'm required to assess that.
Yes, ma'am, I put it up in the column.
Oh, yes, okay, and I see a check mark by it. I just wanted to make sure. Okay, thank you. All right, Ms. Hill, you're here in case 24 CF 1202 on one count of trafficking in fentanyl, 4 grams or more, but less than 14 grams. That's a first-degree felony. It carries a mandatory minimum sentence of 7 years, Department of Corrections, and a mandatory minimum fine of $50,000. The maximum sentence on that charge would be 30 years. Count 2 is possession of a controlled substance without a prescription. That's a third-degree felony. The maximum sentence on that charge would be 5 years state prison. Maximum fine would be $5,000. And count 3 is possession of drug paraphernalia, which is a first-degree misdemeanor. The maximum sentence on that charge would be up to a year in jail and up to a $1,000 fine. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses you might have? Did you discuss the plea agreement with your lawyer? Did you read and sign the agreement? Is that your signature at the top of the last page? Do you understand the rights that you give up when you enter a plea? You understand that you are giving up your right to plead not guilty and have a trial by jury? You understand you're giving up your right to have the court appoint a lawyer for you if you can't afford one, to have a lawyer defend you at a trial? Do you understand you're giving up your right to remain silent and not incriminate yourself? Do you understand you're giving up the right to have the state prove that you are guilty beyond a reasonable doubt? Do you understand you're giving up the right to confront witnesses against you and cross-examine those witnesses? Do you understand you're giving up your right to defend yourself by calling witnesses and presenting evidence? And do you understand you're giving up your right to appeal the conviction and sentence to a higher court? Is anyone forcing you or threatening you to make you enter a plea today? Has anyone promised you anything other than what's showing on the agreement? Are you entering the plea freely and voluntarily? Are you satisfied with the services of your lawyer? Did he answer all of your questions? Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours? Are you suffering from any mental illness that affects your ability to understand what's going on? I have a score sheet that shows 65.9 total sentence points, and the lowest permissible prison sentence is 28.425 months, according to the score sheet. Are there any objections?
No, ma'am.
All right. And again, I note that count 1 carries a mandatory minimum sentence of 7 years. I'm required to impose that. Is there any DNA?
None that I'm aware of.
I do find a sufficient factual basis based on my review of the arrest report. Ma'am, if you're not a U.S. citizen, do you understand the plea will subject you to deportation?
Yes,
All right. How do you plead to counts 1, 2, and 3?
no contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, there will be an adjudication of guilt on all 3 counts. As to count 1, the sentence is 7 years Department of Corrections, state prison, with 7 years being a minimum mandatory sentence. The court is required to impose it. And a $50,000 fine, that's 50,000, 50,000. I'm required to impose that as well. The statute requires it. As to count 2, I don't see count 2 on the agreement. What is count 2? What's the agreement as to count 2?
I didn't, yeah. I mean, I guess you can't do 7 years Department of Corrections, but
I can do the, whatever y'all agree on, but
Run it concurrent.
Run it concurrently.
Yeah,
how long?
just do the year, 2 years.
Okay. Just do 12.1.
okay. So would that be, I guess that wouldn't be a downward departure then.
Well, actually, look at the score sheet. What score sheet?
Here you go.
So she scores minimum would have been 28.425, so we can say.
You could do that and run it concurrent.
Yes, I will do that. So on count 2, it's just the score, and it's going to be concurrent. 28.425 months on count 2, which is the score sheet, lowest permissible sentence. And let me write it on here. That will be state prison concurrent with count 1.
Right.
Okay. So at the same time, not back to back, okay? And you'll get credit for time served on count 2, but I don't know if she gets, does she get credits? Okay, she gets credit on all of them then, just not gain, is it not gain time on count 1?
Well, honestly, Judge, they say that you do day for day, but it's my understanding the Department of Corrections has interpreted the statute, and now they are giving you gain time.
Whatever the Department of Corrections does.
The court's aware, Mr. Medina and I did some research on this topic the other day. I
I would advise not saying anything about day-to-day, simply say that it is a minimum mandatory sentence. The DOC is entitled to give incentive credit at their discretion, and kind of leave it at that.
Okay, well, whatever DOC does, that I don't control them, so that's what they do. But you will get credit for time served on all counts. They will run concurrently. Okay, so the count 2 is the guideline sentence of 28.425 months. Count 3 is just, that's the misdemeanor. It's just credit for time served, and let me find out what the costs are.
515 plus the public assistance fee.
And is there a surcharge on the fine?
Yes, ma'am, 2,500.
Okay. Okay, the costs are $515 plus $150 court-appointed legal assistance fee. That includes the application fee. Plus, there is a required $2,500 surcharge on the mandatory fine. Again, that's required by statute. There's nothing I can do about it. Did I leave off anything?
No, Your Honor.
I believe that's correct, Your Honor.
Okay. Did I cover everything that I need to cover?
Just not a
Oh, how do you want the, do you want all of the financial reduced to a lien?
Yes, please.
Okay, we'll reduce it to a lien. Thank you. So, ma'am, you have 30 days to appeal the judgment sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you.
Judge, there's another case on the docket. I'm going to call it Justin Hammett.
Okay.
Judge, I was looking through the clerk docket, and it looks like he hasn't shown up the last 2 times or 3 times.
Let me take a
And you
look.
finally issued a capias, and he got arrested on that March 18th of 25. And then it shows that they released him from the county jail on 3/28 of 25. But the only thing I can tell you is I do see that there's a Walton County hold. So I don't know if Walton come and picked him up, but the VOP over here is still here, it's still alive.
Let me see what we have.
I do not see an arrest report showing that he was served.
Really?
Yes, sir.
He may have been just arrested on an out-of-county warrant or something. I'm not sure. And then I guess our capias is still outstanding? I'm not sure. Okay, so our capias is still outstanding. So I guess I just need to set him on, just wait till he gets picked up. Yeah, I mean, typically. We'll just wait till he gets picked up, Mr. Nopes.
So I guess what they did is that even though they picked him up, it looks like they may have picked him up from the Walton County, and then, but they didn't serve our capias. That's crazy.
I guess when he gets done in Walton, he'll get served with ours and he'll be back.
Probably, maybe that's what they plan to do.
So whenever that happens, he'll be put back on the docket.
Okay.
So, all right, we are going to, I think that is,
That's all I got.
all right. Thank you, Mr. Nopes.
Thank you, Judge. Y'all have a great day.
Thank you. We are going to break for lunch. We have been sitting here without lunch, and it's 1 o'clock. So I know we're supposed to start back up at probably 1:30, but it's going to be more like 2. Okay, so we're in recess until 2 o'clock, and I'm going to sign this to give to you. So,
All right, hold on, right here.
Or subsequent?
Well, I entered an order revoking her bond on March 18th because there was an amended affidavit filed that allegedly more violations had occurred while she was out on the VOP bond, but that hasn't been served. So do you have any legal basis to object to the court issuing a capias for today?
Well, if she doesn't have notice of today,
That's what I'm wondering.
It seems that it's inappropriate to enter capias for today, but it also seems redundant because the RRB orders her arrest anyway, I presume, so I don't think it's needed anyway.
So
I would
I'm just
ask
going
that
to
the
leave
court not enter it.
my order revoking bond. There's a capias outstanding, so she's going to be picked up on that anyway. All right, we'll just wait for her to get rearrested, and then we'll set her for a court date. Okay?
And next is Bouchard Thomas. Mr. Bouchard is,
Yes, 23.
61 on the docket.
23 CF 1882. And it appears this is a sentencing from a failed PTI, pretrial intervention, and it looks like it's been continued a few times. So are we ready to proceed today?
I think that we need to have a, yes, I think that we would be well served to put Mr. Bouchard under oath and let him provide the baseline information about what he's done. I think he's done almost everything, and then he may have an explanation for the one missing part.
Okay.
I don't think we necessarily need to have a full-blown sentencing hearing. If he can do that, we may not have to.
Governor, can I chime in for a second? I remember Mr. Bouchard, I remember I was giving him time to pay off the restitution and court costs and fines. I did just confirm with probation that he did do that. So based on that, Your Honor, the state's going to find him in substantial compliance of the PTI and no process case at this time.
All right, that's fantastic. The state just dismissed your case. So you're done. Congratulations.
Thank you.
Mhm.
So
Thank
that
you.
basically was substantial compliance with the original PTI, is that it was, or with the?
He had owed still some restitution and fines, and we continued him a couple times so he could pay those.
But I'm just asking, I don't think it was a VOP, was it? I think
No, it was just a PTI recall.
PTI recall, so
Yeah.
basically the case is closed.
Exactly. The state just dismissed it. All right.
Lastly is, well, if Mr. Archer comes back, I'll let the court know. So, but that was it for the morning, to the best of my knowledge, Your Honor.
Oh, Mr. Gates, do you have anybody out of custody? Okay. So in light of that, let's take is it Mr. Bridges with the officer that's been here all
Yes, he's an
day?
inmate, we'll need to get him out.
Okay.
Juan Bridges.
Well, I'm going to take the victim first.
Oh, do you need a minute or?
No, Your Honor,
Oh,
it's
okay.
actually the victim and the lieutenant is here. I'm going to call my victim first, so.
Okay, fantastic, thank you. This is Mr. Daquan Bridges, 24 CF 2637, and he'll be out momentarily.
What are the numbers or the
We're here on defendant's first motion in limine.
Do you want to?
No, it's, I think it'd be better if we sat down. That's okay. Your Honor, he may need a moment to whisper to me because I wasn't able to see him this morning because he's just not. Okay. Your Honor, may I have just a moment? Ready to go on the
Okay, that's 24 CF 2637, Daquan Bridges. We're here on defendant's first motion in limine.
Your Honor, I'm just getting something to ride on.
Sure, no problem.
Your Honor, I think the court, C. Medina for Daquan, T. Bridges, and 24 CF 2637. I think the court is aware of our motion in limine. And so I won't need to do any preliminary argument. I'll just stand on the motion, at least initially, if that's okay with the court, and then we can proceed with the, I think the state wants to put on some sort of evidence on one or both. I'm not sure which ground, but maybe if the state wouldn't mind trying to give us a picture on what presentation it was intending to move forward with.
It'll be mainly on ground one. Paragraph one of your motion.
I'm sorry?
Paragraph one of your motion
Okay.
is what my evidence will be addressing.
Okay. And I would, I guess, invoke the rule.
Okay. I think my lieutenant's outside, Ms. Connor's here, but she'll be called first.
Okay.
Okay, so you did say the other witness is outside, or?
Yes, Your Honor.
Okay, all right. So however the attorneys wish to proceed.
Your Honor, the state would call Ms. Hannah Connor.
Okay.
Sure. Thank you.
I'm not sure whose docket this
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. I do. Thank you. Just have a seat. Whenever you're ready, Ms. Gaynor.
Thank you, Your Honor. Hi, Ms. Connor. Hey. Can you please state your name for the record?
Hannah Connor.
And what do you do for a living, Ms. Connor?
I'm a line cook at Alfie's Family Restaurant and Catering.
And do you remember the events that occurred on November 14th in 2024?
Yes, ma'am.
I don't want to do a whole recap of that day because we're not here for that. I just kind of want to highlight of the events that occurred when you got into the car. Can you explain what happened then?
Yes, ma'am. I was sitting in the driver's side seat of my vehicle attempting to leave my apartment after a verbal argument with Daquan. And whenever I was trying to back out of my parking spot, he was standing behind my car in an attempt to prevent me from leaving. And so I put my car back in park and was kind of arguing with him through the window, trying to convince him to let me to leave. And he had pushed down my rear driver's side window, which was already like broken from like the motor failing. And so it just had wedges in it, and he forced my window down and jumped into my car and came up between my two front seats and had he had struck me in the face. Excuse me. And through all the commotion of us arguing and I was trying to get him off me, I had like a little taser in my driver's side door, and I had taken it out and it has an off and on switch on the bottom that you have to turn on before you can like push the slide up to actually use it. So whenever I was getting it turned on, like he had realized that I had the taser and was trying to get it away from me, and I was able to get it turned on into where like I could attempted to tase him with it, and he had bitten me in the face while I was trying to tase him with it, and after he had bitten me, I attempted to tase him in his left side, I believe, but the taser, like, it was not a very good one. So it was like a slider. So as soon as I like full pressure tased him with it, it turned back off. And then once I realized that it wasn't going to work to get him off me, I just started screaming for help as loud as I could, trying to get one of my neighbors to come outside. And that's when he had finally like stopped biting me and let me go, and he jumped out the passenger door and I jumped out the driver door, and I just ran across the parking lot and called for the police.
Ms. Connor, before you tased him, did he have you in a headlock? Or his arm around the top of your shoulders,
Yes,
around
ma'am.
your neck?
Yes, ma'am.
That was before you tased him?
Yes, ma'am.
And this taser, you didn't require any kind of special training or anything? This was just spot over the counter type of
Yes.
taser? If I showed you a picture of this taser, would you be able to recognize it?
Yes, ma'am.
Your Honor, may I approach the witness?
Yes.
I just want to make sure it's, so it's like a composite or something?
Yes.
Thank you.
May I approach, Your Honor?
Yes.
Ms. Connor, do you recognize those two photos?
Yes, ma'am.
What is that?
That is the exact taser that I had used in an attempt to defend myself.
That is the exact taser you used?
Yeah, that was the brand and the color and everything.
So that's a true and accurate representation of the taser used that day?
Yes, ma'am.
Your Honor, at this time, the state would like to admit composite Exhibit 1.
Could I, what,
Yes.
could I see the exhibit?
Good afternoon, Ms. Connor. You stated that this was the exact taser that was used by you, is that correct?
Well, not like the exact physical actual one that I had, but that's the same brand, make, model, everything.
Because, for instance, that's not your hand on the second page, right?
No,
That's
sir.
some hand model, Sam, or something, with a taser that you are saying is the same model as yours? Is that what it is?
Brand and everything, yes, sir.
Okay. And where is your taser?
Shortly after the incident between me and Daquan, I had gotten rid of it because it was not an effective taser. With him being in custody, I didn't feel the need to have it physically.
And how do you know that this is the exact same taser as the one that you got rid of?
Because I can see it, and I had that taser for about a year previously, and I had picked it out myself for instances such as this.
I'm sorry for cutting you off. That was
Sorry.
rude. I apologize. I know this is hard for you to be doing this. Were you, did you buy it online or did you buy it in the store? I apologize.
It was a self-defense store, yes.
Okay. But this is like off Amazon or something?
Yes, the self-defense store orders them in bulk from Amazon, and then they put the keychains together themselves and resell them.
Okay. Was yours a brand new one or was it resold?
It was brand new from the store. It came in its original packaging.
Came in its original packaging?
Yes.
No further questions, Judge.
All right. Any objection to State's Exhibit 1?
No.
State's Exhibit 1 is admitted.
And you didn't, I think I already asked this, but you didn't have to have any special training to use this?
No, ma'am.
After you tased him, what did he do then?
He was still biting me. I don't even think that I actually like tased him for half a second. And he had continued to bite me in the face until I started screaming as loud as I could, and that's whenever he let me go.
So you don't believe actual contact was even made with the taser?
I'm not 100% sure, but...
Your Honor, I have no further questions at this time.
Thank you. Mr. Medina?
Have you ever tased anyone with this taser before?
No, sir.
Have you ever practiced tase yourself or objects or anything?
No, sir.
So it was the first time you had ever deployed the taser?
Yes, sir.
but you did deploy it, correct?
Yes, sir.
And did it make a noise?
Yes, sir.
What kind of noise did it make?
It was just like a sound. It was something
And
quick.
you don't know how that would have felt to yourself, right?
No, sir.
And how many, you said like a half a second of tasing maybe?
If that.
Okay, was that how much time you think was in contact with his skin or the total that you deployed it?
In contact with him.
Okay. So how long did it go zzz, or whatever it is it makes?
It had immediately stopped as soon as I connected with him because the way the slider works, when I put the pressure, it slid back in and turned back off.
And you have no knowledge of how that would have felt to him during that half a second or so that he was being tased, right?
No, sir.
Okay, thank you. No further questions.
Ms. Gaynor?
Can you redirect, Your Honor? Did this taser shoot out like any darts or probes?
No, ma'am.
It was just a skin to touch type of taser?
Yes, ma'am.
And how many prongs were on it? On the end of it, do you remember?
It didn't really have prongs. It was more so just like it looked like little metal bumps almost, and then the current just went between those two metal things.
Yeah, how many of the metal bumps were there?
Oh, 2 of them.
2 of them, okay. And then the current ran through between the 2?
Yes.
Okay. I have no further questions, Your Honor. And may I tender this to the clerk?
Yes. And may this witness be released?
Yes, Your Honor. These are the statements expected.
All right. Thank you, ma'am.
You're all right. I would prefer to keep invoking the rule. And I know she's the alleged victim in the case, but I think there's an exception can be made when it could be prejudicial, and I would ask that the alleged victim step out.
State?
Your Honor, I believe she has a right to listen to the hearings. Her testimony is also already finished.
I believe under Marcy's law, she has a right to be present. I'm not aware of any legal authority that would.
I'm sorry, Judge. I think that there is a provision for where it's in the interest of justice as an exception. I'm not going to belabor it, but I do think it's in there. So I've preserved the issue. Thank you.
Okay, I'm overruling that request, and I'm going to permit Ms. Connor, who is the victim in the case, to remain.
Thank you, Your Honor.
All right, State, next witness.
Your Honor, the State would call Lieutenant Topolsky.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat.
Good afternoon, Lieutenant.
Good afternoon.
Can you state your name for the record, please?
Travis Topolsky.
And what do you do for a living?
I work at the Okaloosa County Sheriff's Office in the Patrol Division.
How long have you been with the Okaloosa County Sheriff's Office?
12 years.
Did you have any law enforcement experience before that?
No, ma'am.
And what are your duties as a patrol deputy?
I supervise 2 shifts whose primary function is to respond to calls for service for the citizens, and in the absence of calls for service, maintain their administrative task load and find proactive contacts that need to be made to preserve the peace and protect the public.
And what kind of training have you completed to be a deputy, a lieutenant?
Well, there's the academy, which is over 600 hours. Then there's a list of annual training requirements that have to occur. And then I have taken an interest in my own career and gone to additional training, hundreds of hours. I have several instructor high liability trainings, one of which is a taser instructor since 2016.
So you've been a taser instructor since 2016?
Yes, ma'am. However, my certification expired in August of last year.
Now, as your experience with a TASER instructor, can you give me some of the things you learn when you are becoming a TASER instructor?
So Axon will have a master TASER instructor come out to teach the class. It's a 2-day class. And they'll teach a variety of things. Anything about the current models that they have available for use, the capabilities and limitations, the type of cartridges that each one uses, the minimum recommended distance based on a proper probe spread, the desired effect of a TASER, how to employ it in 2 different fashions, one being with the dart deployment, which is going to give you the best result possible of a neuromuscular incapacitation, the other one being a drive stun, which is more of a pain compliance that only affects a very small muscle group. They'll tell you about how to remove the probes, the sensitive areas of the body that could be struck by the probes, and then that would require a medical professional to remove. They talk about the desired impact locations, how to troubleshoot if you miss a dart and you only have one dart connected, and how you can solve that problem without deploying a second set of darts. I mean, it's a pretty intense course.
You mentioned something called neuromuscular incapacitation. Can you explain to us what that means?
Yes, ma'am. So when the TASER's deployed in the recommended fashion, there are 2 darts that come out which are connected to the TASER and transmit the electrical impulse into the person's body, right? When those darts, they actually penetrate the skin. They're small, they kind of look like a straight fish hook. They stick into the skin and they actually penetrate into the muscle, and they deliver electrical charge, which then forces the muscles to contract rapidly, multiple times per second, which then renders the person being struck by the TASER usually the inability to control those muscles. If you have approximately 6 to 8 inches of spread between 2 darts or more, you are to a large muscle area, you are likely to get neuromuscular incapacitation, which is generally the inability to function, right? So if you get hit, the most desired location is in the back, right? One above the waist and one below the waist, with at least 6 to 8 inches between the 2. That is hitting such a large muscle group that the chance that that person is able to effectively control their body is significantly reduced, thereby making it easier to apprehend a person who is giving you active resistance.
Okay, so if, you deploy the darts and it's a good, I guess, spread, you said it would cause an involuntary response, or they would have no control over their body at that point?
Most of which, yes. Okay. It's not 100%, but they're not going to have any control over any muscle group associated with anywhere near where the TASER is. So
so it's got to be near where the darts are at for those muscles to basically have that response.
So we've seen there are rare examples where a person can still have control of their hands, right, while the darts are deployed in their back and upper thigh. So it's not abnormal. Most people have no control. They frequently will just fall straight to the ground and they're unable to control anything.
So the rare chance is that they possibly could have that, but that's not normal.
Correct. And it's usually associated with something like an improper connection, like one of the darts didn't penetrate the skin, got caught in clothing, or maybe struck a belt, right?
Now, the tasers you're referring to, those are your agency issue tasers that actually penetrate the skin, is that correct?
Correct.
Okay. Are you, in your training and experience, are you familiar with other, possibly over-the-counter stun guns or like topical type of tasers?
I have not gone to any other manufacturer to have an instructor certification on any other form of electronic control device, right? TASER is a specific name brand of an electronic weapon. I have not received any certifications in anything else.
If I were to show you a taser that could be bought over the counter, would you be able to identify that and say whether that could cause, neuromuscular incapacitation?
Yes, there's only one way to achieve neuromuscular incapacitation, and that's with a 6 to 8 inch spread with penetration of the skin. If you don't have that, you are not going to get neuromuscular incapacitation. Ergo, you are not going to get a person who is not able to control their body.
Your Honor, may I approach the clerk and obtain Exhibit 1?
Yes.
May I approach the witness, Your Honor?
Yes.
Lieutenant Polsky, can you look at both of those photos? Can you tell, based on the photos, whether that is a taser that can penetrate the skin?
This does not appear to have any dart firing capability.
And you're confident to say that based on your training and experience?
Yes, ma'am. You can see the two metal probes at the top where the arc would switch between. They don't appear to have any type of prongs. Usually dart firing stun guns have some type of encasement because they also have aphids in them, right, which is it has the serial number for that specific dart set on it to say that this dart was deployed, right? None of those things are consistent here. A different manufacturer could have a different way of doing it, but this just doesn't appear to be.
But the one you're looking at there doesn't appear that it.
Correct.
Okay. And does that appear just to be a skin-to-touch type of taser? Can you tell that based by looking at it?
It does appear to be just a typical drive stun style taser, yes.
And you've stated that unless it penetrates the skin, neuromuscular incapacitation is not even possible.
Skin penetration in addition to at least 6 to 8 inches
And how many,
between those two.
How many inches do you think, based on that photo, are in between those two metal probes?
Based on the size of a standard human hand, it's probably 1 inch to 1.5 inches between those two terminals.
So the fact that the probes aren't 6 to 8 inches and it's incapable of penetrating the skin, it's not possible for, if someone were to be tased by that, it's not possible they would suffer neuromuscular incapacitation. Is that true?
Highly unlikely.
Your Honor, may I have just 1 minute to confer with co-counsel?
Sure.
What is a drive stun?
So the taser that we are issued, right, it has metal posts inside of the face of the terminal, and it also has ports where you plug in two cartridges. Okay, so it can be used in 2 different fashions. It has a drive stun application, and it has the dart firing application. The drive stun, all 4 darts remain inside their cartridges, inside the device, and then you touch the end of the taser to the person's body, and you activate the arc switch rather than pulling the trigger to deploy a set of darts. That will then create an arc of electricity that go across the face of the taser, which is about 1 inch, 1.5 inches. And then there's an electrical stimulation to the skin. It touches the surface. Sometimes you can see signature marks where there's like slight burning of the skin if there's a lot of on and off. And that's because the electricity is going across the surface of the skin rather than penetrating through the muscle. You are generally just going to get pain compliance from that. It's about the equivalent of getting shocked by putting your finger in a light socket. The natural response is generally to pull away from the pain unless you have that portion of the body immobilized.
And I'm going to move away just a little bit from the taser. I'm going to move you to the events on November 14th, 2024. Were you called to the scene regarding a possible aggravated battery?
Yes, ma'am.
Do you remember, as far as the facts regarding the taser and those facts? I don't want to get into everything because this isn't trial. I don't need to air out everything. But did you speak with the victim or the defendant on scene that day?
I did not speak with the victim. I was there in a supervisory role.
Okay.
My deputies talked to the victim, and they told me what she had said.
Okay.
I overheard the majority of what the defendant said. The defendant's testimony was that he was tased, and as a reaction, he bit the victim on the eyebrow.
Do you find that plausible?
I find it very, very hard to believe.
Why?
They were sitting in a vehicle with a center console between the two of them. If the first contact was him getting tased, his natural biological response would be to distance himself from said tasing. However, instead he closed the distance with and then bit her on the eyebrow, which doesn't make sense. The victim's testimony was that the defendant put her in a headlock, at which point she tased him, and then he bit her on the eyebrow, which does make sense.
I have no further questions, Your Honor.
All right, cross.
I'm sorry, did you say that the defendant used the word neuromuscular incapacitation at
No.
any point?
No, sir.
Okay, so who used that term?
I did.
Did you use that term with the defendant?
Yes, sir.
So you asked him questions using the term neuromuscular incapacitation?
I believe I was explaining to him how a taser functions. I was not asking him about neuromuscular incapacitation rather than replying to his story.
Did you define it for him?
I basically described it.
So when you put your finger in a light socket when you're a kid, maybe you're holding a butter knife or something like that, you're saying that's more like a drive stun experience?
It's similar.
Okay, and I mean, in fact, you did some drive stun and the other kind too. Did you experience neuromuscular incapacitation during your training?
I did, yes, sir.
Okay, and you also experienced what it feels like to be drive stunned?
Correct.
Okay, how does it feel to be drive stunned?
It feels like an electric shock going through a small localized portion of your body.
Okay, and
similar to a light socket.
And how does that affect a person?
They pull away.
They pull away. And if your statement is that as an expert that no neuromuscular incapacitation could not have taken place.
First of all, I am not a subject matter expert.
Okay.
I'm merely a taser instructor. I just want to clarify that. But yes, that is my assessment.
Okay. So when somebody has a shock, your position is that the only way one goes in reaction to a shock is back from the point of the impulse?
From a drive stun or sticking your finger in a light socket, yeah, the equivalent of putting your hand on a hot stove, yes.
Okay.
The natural response is to pull away from it.
Where was Mr. Bridges stunned or shocked?
I believe you said it was in his torso.
Okay. So if he was in close proximity to her and he was stunned in his torso, your position would be that his torso would have gone back.
Agreed.
And basic physics is if his torso would go back, his mouth would go forward, correct?
Yes.
Okay. So there's nothing inconsistent with the torso going back and the head of Bridges going forward in relation to the drive stun experience that he experienced, right?
Well, it depends on where specifically the heads were located inside the car, but we've got about a 3 to 5 foot gap to accommodate for if we're sitting in the driver's seat and the passenger seat and there's a center console between the two. So to go from a drive stun when a person is seated comfortably in one seat to a person who's seated comfortably in another seat, as the defendant's testimony says that was the first thing that occurred, there's still a large distance that has to be covered. So in order, in your idea of him being tased and leaning forward, I would agree, right? A torso shot, you hinge at the waist, correct. But based on sitting in the car, it's not reasonable to believe that he's going to close that far of a distance and then also have his head high enough to bite somebody in the eyebrow.
So what you're really doing is you're critiquing the overall testimony, and you're saying if he was over in the passenger seat, that his forward movement of his head that you concede could have occurred, it couldn't have gone like 3 or 4 feet.
How high is how much distance from?
I don't know, you tell me.
The waist to the mouth?
How far do you say that he could go? His mouth could go forward?
As a reaction or
Yes,
as a lunge
reaction.
toward a person?
As a reaction. You don't know?
The distance from hip to face.
How far, with your view of the facts, how far was she from him when she tased him?
I don't know the answer to that question.
So if
Yeah.
she was a foot.
According to his
If she
testimony.
was a foot away, that might have been within
Your
the,
Honor, objection, speculation.
this is cross-examination. So if she was a foot away and not 3 or 4 feet away, she very well could have been within close proximity to his head when it came forward, correct?
Absolutely.
Okay, so no further questions, thank you.
All right, redirect.
In your opinion, is it likely if someone gets a drive stun from 3 to 4 feet away, that they would be able to then lunge forward and bite someone on the eye?
No.
Is that a reasonable response after an over-the-counter type of tase drive stun?
You mean the bite to the eyebrow?
Yes.
No,
Is
that
that
would
a
be,
reasonable response, given the circumstances in this case?
correct.
It's not a reasonable response?
Not reasonable.
No further questions, Your Honor.
Thank you. May the witness be released.
Yes, Your Honor.
Could you spell your last name so that our court reporter can be sure to get it right?
Yes, ma'am. TOPOLSKI.
Thank you very
My
much.
pleasure.
You're free to go, sir. Any further testimony that the state wishes to present?
No, Your Honor.
All right, defense?
Yes, I'll just make argument.
Oh, okay. All right. I didn't know if you wanted to present
No.
any evidence.
No.
Okay.
Just make argument.
Okay.
And by the way, Your Honor, just so we don't forget, is the state conceding paragraph 2 of the defendant's first motion in limine? We haven't discussed that, but I just don't want to forget.
No, the state's,
Or do we need to come back to that? I just want to make sure we don't forget it. Okay.
of course, Your Honor, we can't, this is kind of a character type of paragraph, I believe. The defendant does have a past conviction of battery. I am working on getting those certified records right now. I'm not 100% sure if the victim is the same victim in that prior conviction. Of course, in that instance, that would be able to come in, but any other, of course, bad acts or anything like that, of course, the state is aware and will let the victim know that, of course, cannot be brought up. I know there was prior domestic injunction cases and things like that. We understand that is not able to be brought in under testimony.
Well, we're looking at a trial that might take place in a week or two. And so to the extent the state might have given notice of another act, we're not going to be within 10 days notice. So I would ask that paragraph 2 be granted. There has been no notice pursuant to 90.404D. It would not be appropriate to just be speculating that the state could do something at some point in time unless the state's seeking a continuance. It's not going to be fair or legal to introduce alleged domestic violence or other wrongful conduct by defendant involving the alleged victim or any other person. So I would ask that paragraph 2 be granted.
Your Honor, I did just receive, looking in this case, we do have a certified copy. I will be filing it right this second. The notice of intent to trial and certified records. Thankfully, we have 2 weeks in your trial week to be able to work with.
Okay, just 1 second.
Does that involve the alleged victim or some other person?
I'm not sure.
Does that involve alleged biting or some other form of contact?
It's a prior battery conviction.
Are you meaning you're offering that? Or you would be
But that would
offering?
just be for impeachment or sentencing purposes if the defendant were to testify,
Oh, okay.
not to be brought up by any witness of that prior conviction whatsoever, Your Honor, no.
So you're not trying to use it as part of the direct case, you're just trying to use it as evidence of a what? A felony or a misdemeanor of dishonesty? Because those are the only two types of convictions that you can cross-examine him about. If he fails to accurately state the number thereof, which I'm sure he'd be accurate.
If he tries to say he's never been convicted of a battery, the state has a certified record to then impeach at that point. That would be the purpose of his prior battery ever being brought into trial.
Well, it would not be an appropriate question for me, as part of the defendant's case, to ask him if he's ever been convicted of a battery. That's not the way it would work. We would ask him we would get a stipulation on how many felony or crimes of dishonesty this would never come into play. We would never be getting into whether something was domestic violence or not. That would be very prejudicial.
What would be the purpose of the state needing to bring in that conviction? I'm just trying to envision.
Your Honor, or if their question was phrased as, have you ever been violent before? Have you ever been aggressive before? Something of impeachment purposes. That'd be the only reason. That's if the defendant took the stand to address that. And if you were to lie and say, no, I've never battered somebody, I would have the conviction to then use at that point.
You mean if he opens the door by saying, I'm a peaceful person, I've never done anything.
Correct, Your Honor.
You would have to open the door for that to attempt to be brought in.
Correct, Your Honor.
Okay. Mr. Medina, do you wish to respond to that?
Well, I don't think that's four squares responsive to our paragraph 2 of our motion, which I'm I'm asking that the state be prohibited from introducing, referencing, or claiming evidence of other criminal offenses, etc. But if the court wants to add a caveat, unless the defendant opens the door, well, of course, if we open the door and make a statement that opens him up to cross-examination, that would change the premise of the situation.
And that is the state's position.
So as to paragraph 2 of the motion, then it sounds like there's an agreement between both sides that, but I don't want to put words in anybody's mouth, but.
It sounds like we're okay.
Yeah, the only way that the state would, sounds like, be bringing in or attempting to bring in any prior violent acts or wrongful conduct would be if the defendant opens the door and they could then attempt to impeach him. That's what I'm hearing the state say.
Okay.
So, doesn't sound like the state's wanting to bring in anything like that in their case in chief.
Correct, Your Honor.
Okay. Well, it sounds like paragraph 2 is not an issue. Of course, if, Mr. Bridges opens the door, then they'll be allowed to explore those subjects.
Thank you, Your Honor.
Sure.
So I'm sorry for that diversion. Back to paragraph 1. Your Honor, I don't think it will be appropriate for Lieutenant Topolsky to get into speculation about how truthful Mr. Bridges is or was in terms of anything. That's for the jury to decide. So basically what Lieutenant Topolsky has done is summarize his version of what he thinks the post-Miranda statements of the defendant were, or what his testimony might be at trial. And based on this possible 3 to 5 foot distance, that incapacitation, given that it could not have occurred, that, I don't know, that they're basically, if Lieutenant Topolsky is going to limit his testimony to testifying about what neuroincapacitation is, and that neuroincapacitation could not have occurred with the use of a drive stun apparatus, which I think arguably he could, based on his testimony today. But to go beyond that and to be characterizing the evidence and basically suggesting that there's no way that the stun experience of the drive stun, of the tasing into the side, could not have caused or contributed to, I'm using the term from the incident report, clamping down on the alleged eyebrow. We don't know where people were, other than that's going to be something the jury is going to find out about. And if he wants to talk about a term that he used in interfacing with the defendant about neuromuscular incapacitation, I think he probably should be allowed to testify on that limited term. But I don't think he should be able to characterize the location of the defendant and the veracity of the situation, or talk about how it couldn't cause or contribute to the clamping down on the alleged victim's eyebrow, or the movement of the head, the proximity of the head to the eyebrow, or anything having to do with the actual facts of the case as they may be developed at the jury, because that's really going to be for the jury to decide. But if he wants to say you couldn't have neuroincapacitation, I don't know how that's going to be relevant, but I don't think we're going to be claiming neuromuscular incapacitation. So I'm not sure how it's going to come in the state's direct case. It was a term that he used. Apparently, that there's no, anyway. I think there's probably, in other words, some room for slicing the apple in two on paragraph 1. So.
Okay, so what are you asking the court to decide?
I'm asking the court to not let Lieutenant Topolsky or anybody else with the state or its witnesses to introduce reference or claiming that the victim's taser, the alleged victim taser, would not cause or contribute to the defendant's alleged clamping down on the victim's eyebrow, on the alleged victim's eyebrow.
Okay.
So it's not. I'm going to move on from the neuromuscular incapacitation point to the talking about how they should not be able to say that the defendant could not have had a clamping down reaction based on being drive stunned. There's no factual or expert basis for that. Thank you.
Okay, so wait a minute, let me make sure I understand.
Okay.
Because there was testimony about the defendant's location in the car. There was testimony about, if he's tased in the torso, then his torso would go back and his head might go forward. And there was some testimony about what the lieutenant thought about the credibility of some of the statements. Tell me exactly what you're wanting.
Okay, let me also state that I do need to expand it, given the nature of what Lieutenant Topolsky, and this is a motion limine issue that's more expansive in the sense that basically I think Lieutenant Topolsky and the state would concede that the only way the drive stun could have made contact with him is if the victim was pretty close to him. So the idea that there wouldn't be basically that Lieutenant Topolsky should not also be allowed to testify as to the location of either party in the vehicle because he wasn't there. He should not be able to speculate. Nobody should be able to speculate as to the location of the parties. That is a fact issue for the jury to get into. And in relation to that, he also should not be able to, nor should the state be able to introduce reference or claim in any other way that the taser could not cause or contribute to clamping down on the alleged eyebrow, because that is going to be something for the jury to consider as to what might have happened.
All right, Ms. Gaynor?
Your Honor, from the state's perspective, the state believes that basically all of the testimony that we heard today would be relevant and admissible at trial, which is basically the burden here is admissibility. Lieutenant Topolsky and any deputy on scene goes to the scene. Majority of the time, they are not present when the offense happens, but they are there to assess the facts, to get statements, and to make a determination after getting all sides of the story. That's exactly what Lieutenant Topolsky testified to today. He was there on scene after, of course, the offense happened. He heard the defendant's own statements. He used his training experience in assessing all sides of the story to then conclude that it was not reasonable for someone to then clamp down and bite on someone's eyebrow from the other side of the car after being stunned. Again, I do agree with the defense that this would be a question for the jury, which is exactly why this should be denied, because this should be, all of the testimony we heard today should be given to the jury, to the trier fact, and they can believe, whatever they want to believe at that point once they hear, the state and the defense's case in chief. That's the whole purpose of the jury. That is what the state is wishing, is for Lieutenant Topolsky basically to be able to provide this same exact testimony he provided today to the jury, and the jury can go and discern whether it is reasonable or not for someone to clamp down on someone's eyebrow. But based on his training and experience, and in his opinion, being on scene investigating this horrific incident, he should be able to give his opinion of assessing the facts and listening to the defendant's stories and seeing the car. So that is the state's position. The state would request this court deny paragraph 1 and the defendant's motion in limine. Your Honor, also, he testified to his training experience. He's an instructor. He's able to give, these explanations of all the different type of tasers, stun guns, the effects, limitations of these. He was, the proper foundation was laid and will also be made in trial.
Okay, and Mr. Medina?
Well, he has no special experience or training in the dry stun experience, in the sense of saying that there could not be a impact of being stunned on clamping down. He has no special knowledge or training on that. And that's what the statement is made, is that there could not have been any relationship to the clamping down on the eyebrow. That's a totally much more expansive thing that he cannot testify to than simply him saying there could be neuromuscular incapacitation, which is a very limited part of the potential issues here. And he shouldn't be able to speculate about and try to draw a picture of that something could have happened, when it's going to be for the jury to hear all the facts. And then he has no special knowledge about what happens when, I go put my butter knife in the socket. He has no special knowledge there. He conceded that the head could go forward. He has no training experience to offer on the issues of, broadly speaking, clamping down on an eyebrow. The only thing he's qualified to talk about is neuromuscular incapacitation, period. Thank you.
All right, I'm going to have to take this under advisement and go and review the testimony. I took a lot of notes. And I will have to issue a ruling. I think paragraph 2 of the motion, though, is resolved like we stated a little while ago. It's paragraph 1 that I'm going to have to take under advisement and consider further.
Thank you.
Sure. So I have the case listed as plea or trial. I'm assuming we're proceeding forward with trial, correct?
I have concerns about that. As the court is well aware, I've been in court 4 out of the last 5 working days, all day in court. I have not been able to meet since pre-trial with Mr. Bridges, and I'm going to need to. He's handed me several pages of notes. I need to spend some time with him. That being in court all day prohibits. And so this is only the second pre-trial. I'm not waiving the right to at least hold out the need to move to continue. I know the court doesn't have to grant my motion, but I'm not going to represent to the court, because I don't think I can in good faith say that there's under no circumstances would I move to continue at jury review, because I'm worried about, given the magnitude of my responsibilities beyond this defendant, giving enough face time with him between now and jury review. I'm just simply not going to be able to work 24 hours a day as much as I would like to.
State.
Your Honor, the state and its witnesses are ready for trial.
Mr. Medina, do you think you would be ready the second week?
Probably, Judge.
Okay.
It's just, like I said, between now and Thursday, I can't, it's hard to me to envision that how I'm going to possibly be able to spend 3 or 4 hours with him going over some things. And, but Your Honor is correct that if we do the second week, that depending on if I'm having trials the first week, I really don't know what else going on other trials. Assuming they don't involve me, that would probably help, Judge.
All right, so I'm just looking at your other cases on the docket, and I think that was the only one that I had noted as a possible trial this cycle, but I could be mistaken.
I appreciate Your Honor knowing my docket better than I do. I apologize. Right now, it's all over.
I know what you mean by that.
Your Honor, there is one, Mr. Broxson. He is set for review on Thursday. He's also set for plea or trial. That is Mr. Medina's client.
Oops.
That's the Phoenix House issue. We're trying to get him expedited, or Mr.
That's
Medina's
right.
office is trying to get him expedited in.
That's right. He wasn't on today's docket, but we
Yes.
saw him yesterday. So there's Mr. Broxson is another possibility, Mr. Medina.
As far as the state lists go, as far as what I've got written down for trial, those are the 2 that I have for Mr. Medina possible.
And we're hoping Broxton will go away. That's a rather special situation. We're checking again with Phoenix House today and hoping that'll come through.
Well, why don't we set Mr. Bridges for jury review, which is 2 days from now, April 24th. And Mr. Broxson has set that day too, so you'll have a better idea of where that case stands, and we will figure out when we're going to try what, if needed.
Thank you, Your Honor.
Sure. So I will be working on the motion in limine, and I'm hoping to have you, I can't promise you that I'm going to have a ruling by Thursday morning, based on the fact we're going to be in court for the rest of the day today. but I will be working on it, and I know you need an answer prior to trial.
Thank you, Your Honor.
Sure, thank you. All right, thank you, Mr. Bridges.
May I have just a moment with him before he goes back?
Sure, sure. Okay, we need to take the Brazil case. Are you ready for that, Mr. Medina?
Yes.
21 CF 3134.
Just let me, Your Honor, pull
Sure.
this file out. Thank you. Your Honor, can I have your indulgence and walk
Sure.
back to my computer for a minute?
Of course.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week.
That'll give you time, and that way I can give court staff a break.
Thank you.
Okay, we'll be in recess for about 5 to 10 minutes.
All right, please.
normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 cars, motorcycles, and trucking crashes. My mission was to help the victim. Now, as an injury attorney, I can do even more to help active victims. Hi, I'm attorney Floyd Brown. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Ken, I think you're still on.
I think this music's playing. Oh. I have my court in recess graphic up on the screen. Go check it out. I think it is. I'm pretty sure I muted it.
Hi, I'm Wanda Roberts. For the last
Perfect,
20
Sharon.
years, I've been helping the residents
You're fine.
of
The
Northwest
video's
Florida buy and sell their properties. My office is just one
Yeah, you
block
can hear
south
it.
of the courthouse in historic downtown Crestview.
It's muted.
Give us a
No,
call
it's still
at
muted.
850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton.
I got it muted.
If you or anyone you know has been accused of a crime, give us a
Maybe
call.
another camera. Hang on. Okay.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
I can still kind of hear it. I can still hear it a little bit. Yeah, I can hear you, Ken.
It's off, right?
No.
What are you hearing? You're hearing music.
No, I hear you.
that's not music.
TJ is also watching in the back, and he said he can still hear it.
All right, we are here on case 21 CF 3134. And sir, if you'll state your name, please.
Robert Brazil.
Thank you. We're here for sentencing. Mr. Medina, did you receive the pre-sentence investigation?
Yes, Your Honor.
Any objections or corrections?
Not at this time, Your Honor.
Okay. State, did you also review the PSI?
Yes, Your Honor.
Any objections or corrections from the state?
No, Your Honor.
Okay. And just to clarify, I know at one time, back in February, I believe we were here on all 3 cases, but it appears that the violation was only filed in 1. Is that right?
Right, Your Honor, there's not technically, could not be in violation status as to the other 2 cases, because those amounts do not come due. Well, one of them didn't have any amounts anyway, but then the most recent one, it was specifically written to not come due until this one was resolved.
Okay. And the case we're here on is 21 CF 3134. Does the state have a recommendation?
Your Honor, I believe our main goal here is to make these victims whole. That is the state's objective. That is the victim's wishes. You know, I think a period of probation needs to be reinstated again, possibly a short time of incarceration to make this defendant realize that this court is serious, the state is serious, and he needs to comply and do what he can to pay back these thousands of dollars to these victims. That is the state's prerogative, is to make this victim whole, and that is the state's recommendation.
Does the state have a score sheet?
Yes, Your Honor. You want to see it first, Mr. Medina?
Yes, you don't mind.
It's just got the 1 case on there.
No objection to the score sheet. May I approach with it?
Yes.
Or
There is.
you want to?
No, there's one quick correction. I've got to add the 6 points for the technical violation. Well,
It's got to.
actually, it does.
It's got to already.
Yep.
Yeah. May I
Apologize.
approach, Judge?
Yes, thank you.
Thank you.
Thank you very much. Okay. So I have a score sheet that shows 33.6 total sentence points, and I believe you stated no objections. Is that right?
Correct.
Okay. So Mr. Brazil does not score prison. So I know there's a recommendation for that in the pre-sentence investigation.
Your Honor, respectfully, I thought it just simply said period of incarceration. I didn't think it said DOC.
It does recommend a period of incarceration, but then it goes on to say the latest sentencing score sheet from docket 23 CF 2507, that's one of the other cases, not the one we're here on today, indicates 50.3 total sentence points. I mean, that would score prison, but that's not the score sheet that
Right, that's
is in
just
front
not
of me.
operative, right?
Right, that's not the score sheet in front of me.
Thank you.
And the recommendation in the PSI was for a guideline sentence, incarceration based on a guideline sentence, but on the current guidelines for this case, the defendant does not score prison.
Yes.
I believe that we have, is it Miss Lee is present? She is the victim in the case. And does the state wish for Miss Lee to address the court?
Your Honor, I know Ms. Lee's position regarding this. She's also got an illicit infection where it's hard for her to talk right now. Ms. Lee, please stop me if I'm misrepresenting. Ms. Lee's main goal is to have her money paid back.
Okay. And I remember the testimony. I also took detailed notes and have those with me, but I remember the testimony as well. Okay. What is the defense's position?
The defense's position is that we would concur with the both the procedural idea of reinstatement, and we also concur in the substantive objective of the state to make the victim whole. Mr. Brazil can testify, if the court will allow it, to what he can do and is doing to make the victim whole. And with respect to the state's mentioning of a possibility of a short time of incarceration, Mr. Brazil would definitely want to address that because that we think would be highly counterproductive, but I'll let him testify. And there is also the issue that I know the court has highlighted and will want us to discuss of whether he has to be, or whether the court should exercise its discretion to convict him at this time. But I do think that if we are reinstating and if he can make the victim whole, I would beg the court to not make him a convicted felon. There's it's a reinstatement if the court goes that way, and with a reinstatement there's not a revocation by definition, and I don't think that it's necessary for the court to adjudicate him as a felon. And I would ask the court to listen to his testimony on the facts as he wants to explain them as it relates to that.
Okay. Do you, of course, I'm going to give Mr. Brazil a chance to speak. Do you want him sworn?
I would ask that he be sworn, and I know it's, because it might be more than a few minutes of testimony. I don't want to have him extremely limited. Can he sit in the chair, Your Honor?
Sure,
Okay.
if he wishes.
Okay, thank you. Go ahead.
Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Just have a seat.
Mr. Brazil, I know you first off, what is your name?
My name is Robert Allen Brazil.
Okay, and you previously testified, we're not going to go over old grounds, but where are you living now? What is your current address? And is it the same address as you had when we were before the court back on March 19th?
Yes, sir. It's 296 Oakdale Avenue West, Crestview, Florida, 32536.
And is that an apartment or a house?
It's an apartment, 415.
And
just a studio apartment.
And you share that with your wife?
Yes, sir.
Okay, and just for the record, again, what is your wife's name?
Sandra Hoffman Brazil.
Okay, and I would just caution wife, please do not in any way try to communicate to him while he testifies, okay? All right. And vice versa, don't you try to communicate to her,
Yes,
okay?
sir.
Now, I know you've got a lot on your heart. I don't want to coach you up or limit you. Would you please tell the court what you would respectfully ask the court to consider in making the court's sentencing decision with respect to this case?
Well, first and foremost, I would like to apologize to Your Honor for the last time I was here testifying when questioned about if I could work overtime. And my statement in response was no. It wasn't because I don't want to, it's because my current job at that time would not allow overtime as my current job now. However, my current job now, I lost the last job because they were under the understanding that I was going to be convicted a felon, so they let me go. So I found a new job working at the airport in Crestview now in a restricted area as building maintenance, building and grounds maintenance. Solid job with 40 hours guaranteed every week. With that being said, my paydays are the 1st and the 15th of every month, as the military is. My first paycheck is this May 1st, which I've already been working since last Monday on this job. I'm with a great crew of people. My manager and owner is well aware of my situation and are willing to help wherever they can. They also know my heart in this situation. I would respectfully ask that I not lose this job over any type of incarceration. My plan is, with my increased compensation from the VA of my disability as of May 1st, I was awarded that this past month as of May 1st between my paycheck and my disability compensation. I'm going to make a significant payment from here on out towards my restitution. Along with that, since the last hearing, me and my wife have taken steps as far as our storage unit of $250 a month to downsize that, to mail her daughter's stuff to her that we've been holding on to that we don't need. So there are other things that we're doing, and being as how with my new job, I'm working so close to home, I'm not spending near as much in fuel, so that's a reduced expense as well. There's just been several things that we're trying to do all we can to resolve this. I'm sorry to Miss Sherry Lee for it taking so long. If it was up to me, I would have resolved it years ago. With my VA benefits, I haven't spoke to anyone at the VA, but as a convicted felon, it could be possible I lose all my benefits and everything that I've worked hard for. That's really all I have to say.
What is your VA benefit that you said as of this month it's going to be, or is?
It was 10% disability due to seizure disorder, which I've had throughout the years. It increased to 50% disability due to my lower spine, inability of movement.
So what is that?
My range of motion.
I'm sorry, sir. What is that going to equate to, the 50% VA benefit?
It's $1,100 a month instead of $170 now.
What is your paycheck going to be May 1st? What is your gross and what are your anticipating after taxes?
I just started this job. I'm $21.60 an hour right now. They stated to me, I don't have a calculator in front of me, and I have to calculate that in a month's time. They stated to me after my 90 days that I could potentially increase to 24. So I guess the baseline for all this is that really good things are coming, things are turning around. If I am to be incarcerated, my wife would probably end up homeless because I'm the only one that pays for everything. I'm the only one working. That she's been fighting for a disability. Hopefully by October this year, we'll be able to hear something from that, and that will also be another resolve for her, as well as our whole family.
A couple of follow-ups. You mentioned downsizing of the storage unit. Can you expand on what you meant? Did you actually downsize, and what is the monthly fee of the smaller unit?
We're doing that by the end of this month. We had to wait for from having 2 5x15s, we're going to downsize to 1 10x10. We had to wait for it to come available. We've been in contact with the storage unit facility multiple times this month.
So what's that going to be, 10 by 10?
It's a payment of, I believe, $250 to $253 would be knocked down to $170. I mean, it's just a little bit, but everything is helpful.
What about your wife's? I'm not sure if it's your wife's or yours, but aren't you expecting some big payment this fall?
My wife, if she receives if all goes well and she receives her back pay for Social Security in the past 4 years of her fighting for her disability, then they will have to back pay her for the past 4 years.
What are you anticipating that payment might be?
That's approximately it's somewhere around, after attorney's fees, somewhere around $40,000, but I don't expect my wife to use all of her back pay for my situations.
So it's possible that there could be a full payment this fall? Payment
Yes.
in full for Ms. Lee?
Right.
And maybe even
Yes.
for, what do you owe to the other, I think one of the other cases, what do you owe in the
I
other?
believe it's $22,000. So my objective has been, also I've been working in contact with Penny, who is a consolidation loan company, income-based. Been talking with them, exploring some avenues. But aside from that, just doing all we can to hopefully by fall of this year, rectify any debts that we have together as a married couple individually, to ultimately by next year have everything closed out, beginning of next year, if not sooner, to have everything closed out and be closer to my mother that's 91 that really needs some help and has blood cancer.
Let me go back to a couple things. You're no longer wanting to basically give up efforts to try to pay back. There was a time when you were asking for your restitution with respect to Ms. Lee and the other party in the 2023 case, I think it is. You were hoping they would all go to lien and you were going to give up. But that's no longer your position, is that correct?
Yes, sir. My position is to resolve this for everyone. I'm tired. It's been 3 years. It's been three and a half years, and me and my wife have been through enough with our health and everything else. I'm just exhausted. So, but I'm not giving up. I'm not going to quit. I'm going to keep fighting, and I'm going to keep going forward, and I'm going to exhaust every avenue I can to resolve this for her.
Is there anything else that you want to address the court before you're opened up for cross-examination or questions from the court as the court sees fit? Is there anything else you want to say initially? No further questions, Your Honor.
All right, Ms. Gaynor.
I have no questions, Your Honor.
All right. Mr. Medina, well, first of all, is your client done testifying?
Yes, he's excused.
Okay. Thank you, yes.
May he come back and stand by me, Your Honor?
Absolutely, yes.
Thank you, Your Honor. I apologize.
Oh,
Didn't
no,
mean to
that's
leave him up there.
No, I didn't know if you might want to ask him anything else.
No.
So, what are you proposing, Mr. Medina?
Your Honor, I'm definitely proposing that he be reinstated and that he pay Ms. Lee back, as well as when Ms. Lee's paid back, the other individual, who I believe is Mr. Martin Pringle, in the 20, correct me if I'm wrong, but I think it's 222455, but I may be mistaken. The idea of some additional modifications, I certainly hope that there is not a jail sentence imposed, because I think that would jeopardize not only their housing, but this new job that he has at the airport. So I would ask that the reinstatement and modification not involve an additional or a term of jail. However, if the court did feel that jail needs to be at the forefront of Mr. Brazil's mind as a stimulating factor, I think the court could consider a suspended jail sentence that would be hanging over his head and hopefully stimulate fulsome efforts to make the victim whole, because I do understand where the state's coming from, and probably I think that there's probably a concern that, well, if we don't do anything to change things, how do we know we're going to get somewhere where we need to be? I'm sorry to ramble on, but where I'm honestly having a hard time knowing what to say about involves the current restitutions of $500 a month. He has not made those restitution payments in the past. It really hasn't been a topic of discussion here today, but may I just inquire of my client?
Yes, because I am wondering the same.
Okay. Mr. Brazil, going forward, based on your solid job and your payday, is $500 a month something you can do?
I could do 350 or 400, but 5 is like kind of over the top. I want to get this paid off as fast as anybody.
So, Your Honor, I think one of the issues has been in the past that, I as an advocate for him, negotiate the best I can. He makes an agreement. I don't want to have there be any misunderstanding going forward, but Mr. Brazil, if you were to have a $350 a monthly payment, what would you do to ensure that was made?
Every time that I get my check on the 1st and the 15th, and especially on the 1st with the increase in my disability compensation from the VA of $1,100, I can easily take care of these debts that I have, whereas before my income was much less. So now I'm at a little bit more stability financially to be able to handle this. And I know I haven't done it in the past, and it's because of the 500 payment is why I couldn't afford it at that time, but now I've worked hard to gain this, so now I can do it. I can't, 500 is still a bit much, but if that's what the court requires, then that's what I'll do.
Your Honor, I really don't have anything more to argue, but I do want to try to answer any questions or ideas that the court has. I apologize. The only thing that strikes me is trying to reach some sort of a potential punitive reminder is a suspended sentence. I would hope that it be a jail sentence and not a prison sentence. But I think that another measure that the court could do, because the court has continuing broad jurisdiction within the conscience of the court to look at this, would be require quarterly reports under oath by Mr. Brazil to the court, in addition to the report that's filed with probation, so that basically he's filing an affidavit of showing that he paid the $350 every quarter or something, whatever the amount is, a quarterly report to the court. While unusual, might be a worthy way of going about that.
So I'm not entirely clear on I heard Mr. Brazil say he can do 350 or 400, but 500 is over the top, but then it sounded like he can pay 500. I'm not quite clear on that. I know that the increase in the VA, it was $170 per month. Now it's going to be $1,100. That's a significant increase. The new job, the income is very similar as the previous job. I think, sir, you were earning $22.50 an hour, and now you're earning slightly less than that, but
It's really due to the increase in VA compensation that's
Okay.
really going to help out. And also after my 90 days at my job, which I love this job because it's been really good, but they said I could be put up to $24 an hour, so.
okay.
I think, may I, Judge?
Yes.
With respect to whether it's 500 or 350 or 400, I think it's fair to say a serious consideration of the court is the fact that there's not substantial compliance, if not 100% compliance. And whatever amount that is imposed, I think that the court has the right to expect and demand that it be met, to come hell or high water. And
Exactly.
So whatever it is, it's just got to be the first thing off the payroll, even before rent. But I apologize for my rambling, Judge.
No, I appreciate that. So
It will be the primary payment. I don't want to come back here again, and I don't want another VOP.
that is good to hear. Nobody wants you to have another VOP. The court wants the payments to be made.
Yes, ma'am, and
So the victims want the payments to be made. So I'm just doing some math. It looks like, and let me clear this with probation if this is accurate. I'm looking at the PSI and I'm relying on that. And it says that the balance to Ms. Lee is $7,497.95. Is that accurate?
Stand by, Your Honor.
Sure.
I know originally With respect, Your Honor, this VOP the probation was extended by Judge Ketchel, which is good. I mean, that just gives me more time to pay the money to the victims. But I'm hoping to have everything resolved by this fall, early winter.
Would appear that is correct, Your Honor.
Okay. Thank you.
May I, Judge?
Sure, go ahead.
The scheduled termination date, and this may be accurate, is February 22, 2027. So that's a year and a half off. I didn't used to always be as bad as I am with math right now, but one thing that the court might consider is not only a monthly payment, but basically make it clear to him that there's going to be a balloon payment of whatever the residual is that will come due at the scheduled termination date, so that he not only knows it's not only chipping away at whatever the monthly amount is, but that there's going to be a balloon payment, and so that further stimulates his focus.
Is the probation in all three cases ending at the same time? I know that the restitution was staggered, but...
Originally, Your Honor, was my understanding that both the two cases, the third one, there was no restitution. The two cases were ending at the same time. So after Ms. Lee was paid off in full, then the payments continued to Mr. Martin Pringle.
Okay.
And then it was court caused, and therefore...
But I was just thinking at the, sorry, Judge, how many months, I'm sorry, Judge.
No, I've been doing the math.
Trying to look at those, if it's $500 with what we've got left, if he would meet it as to Ms. Lee, and if not, as to Ms. Lee, that there would be a balloon payment. I didn't mean to suggest that it be as to Pringle, which is another $20-something thousand and potentially has more jurisdiction because it's a newer case.
At the rate of $500 per month, it looks like the balance owing to Ms. Lee could be paid off in about 15 months. That's if no payments are missed. Now, the amount owing in the other case it looks like it's $23,628. You divide that amount by 500, it comes out to a little over 47 months. So basically 4 years. Just paying off that one.
I'm sorry, Judge, I think the Pringle case, is that the 23-2507 case? I'm sorry, I don't have my other files.
I believe it is.
Because
yes.
if
Yes,
that has, just not sure if that had two felonies that he pled out to, or one. I'm sorry, Judge, I don't know why I don't have all the files, but if he has, is it just one? Okay.
It looks like it's a second-degree felony on each case.
Second-degree felony on each case, so there's plenty. Is that, I think that's correct, but I'm sorry, Judge.
No, that's, let me take a look. I'm looking at 222455 right now, so let me see what that one is. I know that's not.
Oh, that is correct. Now, I found it, I did have a copy of the plea and sentence agreement. So the 23 CF 2507 involved one misdemeanor that was count 2, but grand theft, 20,000 to 100,000, that is a 15-year second degree. So the point I'm making, Your Honor, is that there's plenty of jurisdiction to continue for the 44, 47 payments. I don't see any problem with continuing the probation if he doesn't get it all paid off in both cases on February 27th, to have him affirmatively come before the court and request an extension, obviously in consultation with probation. But what I was simply saying is, as to Ms. Lee, is it seemed to be a reasonable period of time to get Ms. Lee substantially paid back, and Your Honor's calculation fully paid back. So that is a reasonable milestone, that when he's done with probation, Ms. Lee's taken care of, and then there'll have to be an extension as to Pringle.
Okay.
And Your Honor, I know from other experience, there are times when people have to pay restitution for more than a decade. So these things, now we don't want that for the victim's point of view, but sometimes a diligent defendant has to keep paying a long time, and it just doesn't go to collections. So.
The court's priority is to make sure that the victims are made whole. And however long that takes, with me paying close and careful attention and applying whatever resources the court has to make that happen, I intend to do. So, sir, I'm happy that you have a new job. If you're a convicted felon, how does that affect your job?
I'll end up losing my job and my VA benefits. Everything will go away. I'll have to reapply for VA and everything, and that's a lengthy process. I can do this. I can do this now. I'm getting $1,100 more a month, plus whatever else I can pull in.
Okay. Is there anything else you'd like to present to the court or say?
No, that I just apologize that it took so long. I apologize that I didn't have the funds before. I don't know. Work was not great last year at all.
I'm not going to rehash our hearing last month, but let me ask this. Has there, Mr. Medina, I'm going to ask you, has anything been paid since our last hearing last month?
Would you explain that to the court, what has been paid since the last hearing, which was March 19th?
It wasn't a whole lot, Your Honor, to be honest, because I lost that one job when my manager at Maranatha Construction found out that somehow thought that I was going to be a convicted felon, so he called me in early one day and let me go. So I immediately got this other job working for the airport, but I had been paying 20, 30, whatever I could. I mean, as much as I can, aside from keeping a roof over my head and not living on the street.
Okay, so you're telling me that you can make it happen to pay $500 a month, but I know you just got this new job, but what have you paid since you were in front of me a month ago?
I think $50 or so. I've spent a lot of money job hunting and stuff and gas, but Again, my benefit increase went up from 170 to 1,100 starting this month, coming up.
Are you going to get any back pay on that?
I don't know. They probably will send me some back pay. No, most of the time the VA does back pay. I know it was a regularly quick resolve, so it probably won't be a whole lot of back pay, but it should be a couple hundred.
A couple hundred, or, I mean, this is a significant increase, almost $1,000 a month increase.
Well, it depends on, the way it was explained to me, it depends on how fast they can resolve, how fast you can be seen by an examiner.
Okay.
I mean, it was increased within a month. My spine and my range of motion is not what it used to be.
Okay. Yes, Mr. Medina?
I don't know if the court feels this is feasible or helpful, but back to my quarterly report idea is that as part of a quarterly report, he could not only evidence under oath that he paid the whatever it is monthly amount, but he could also report on the status of his VA monthly benefits, his regular job benefits, and any back pay associated with the VA. Now, the court could also consider, because it's a family unit, whether his wife, with respect to her, she's VA too, right? Or is it Social Security?
No, she's been fighting for her
That's
Social
Social Security disability. She's not VA. But the court could also have him report on the status of her Social Security benefits, including back pay. So I'm not giving up on that idea.
Your Honor, I will inform the court. Probation just showed me an email from his probation officer as of 4:09, which it is right now. He has not made any payments since January of 2025.
Do you have proof of payment, sir, of the, whatever it is that you paid?
They switched two apps, Your Honor. They went from one app to another app that I had to download.
Is that a yes or a no?
I made payments, Your Honor. I don't know when it shows up in their system, but I assure you, this come May 1st, I could easily drop, if it pleases the court, to drop $1,000.
Let me back up. You said that you had made some payments recently, since I last saw you a month ago. How much did you pay, and do you have proof of payment? Because your probation officer hasn't received anything.
My app is updating right now, Your Honor, with JPay.
Your Honor, we haven't used JPay in roughly 2 years. We've been using CorrectPay. We instruct everyone who is sort of.
You're right. You're right.
Thank you. So did you make those payments through Correct Pay?
I might have did them through JPay, Your Honor. I'm not, I gotta look and see in both apps. That might be the mix-up, and I apologize for that. That's my fault.
Mr. Medina, I'm trying to figure out if I have been lied to during
No,
this
ma'am.
hearing.
No, ma'am. That's not me.
Okay.
No, ma'am. And just to reassure that the courts that it,
Your Honor, could we have a,
Yeah.
I,
All right.
I just want to,
Can the attorneys approach?
yes,
Thank you.
thank you.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Okay.
Background Bacon
Thank you for
Cafe
the
is 2
information
blocks
that
from the
I
courthouse.
received from the attorneys. Here's what the court's going to do. My goal is, as I stated earlier, is to make sure that the victims are made whole. And if that were not the priority, the court may have a different view on what would be an appropriate sentence. In fact, I would. But with the overriding goal of making the victims whole, which means, sir, that you keep your job and the ability to make these payments, then I'm going to work it so that you can maintain your withhold adjudication, because I don't want you to lose your job. Because once you lose your job, you cannot pay Miss Lee and Mr. Pringle. So I am reinstating your probation with the following modification. As a special condition of your probation, I am imposing a suspended jail sentence of 11 months and 29 days. What that means is it's suspended over you. You're not having to serve it right now, and if you comply with your probation, you will not have to serve it. But if you violate your probation, you will be serving 11 months and 29 days. That's the maximum possible jail sentence I can give you when you don't score prison, unless I make a lot of extra findings. So you will spend 11 months and 29 days in the county jail if you violate. That means if you miss a payment to Miss Lee. I'm also modifying the amount of the payments. I'm trying to make it easier for you to comply somewhat. So I'm reducing the payments to $400 a month. Because I think that might make it slightly easier for you to make the payments. And at that rate, you'll have Miss Lee paid off in about 19 months at the rate of $400 per month. Then you need to continue paying towards Mr. Pringle. You're probably going to run out of time if you don't make some substantially larger payments towards all this. So you'll probably come back before me, before your probation terminates, and we may have to revisit things again.
I think it's,
yeah.
Your Honor, I think it's very likely, I just want him to know that you can't just wait for it to run out. It's super likely, highly probable that you'll need to move for an extension of your probation a significant number of years to get Mr. Pringle paid off.
Yes. The goal is, at this rate, Miss Lee will be paid off in full in about 19 months at the rate of $400 a month. Sir, if you violate your probation, you will be spending 11 months and 29 days in jail. Do you understand that?
Yes, ma'am.
And at that point, I'm going to likely adjudicate you as a felon.
Yes,
Do you
ma'am.
understand that?
Yes,
you have a
ma'am.
lot of incentive to make these payments, and there are a lot of consequences if you don't. So, yes, Ms. Gaynor?
Your Honor, I just want to make sure the condition, it will still be imposed of no contact with Ms. Cheryl Lee as well.
Yes, that will remain. And also, I am going to require you, sir, to file a monthly report with the court confirming you have made the payment. And probation, what day of the month is the payment due?
Generally, it's by the end of the month. So if they have a minimum payment, it needs to be paid by.
Okay, so by the...
I would say, Your Honor, maybe by the 10th of the month following, confirming that the payment was made by the end of the month previous. Basically, the monthly report for the prior month would be due by the 10th of the succeeding month.
State, how does that sound?
Your Honor, that would be fine. Let's see.
Okay, so by the 10th, you need to file a statement with the court. It can be something written, handwritten, with your case number on it, signed, that verifies under penalties of perjury that you have made the payment in full to Ms. Lee. You'll pay it through correct pay or whatever instructions probation gives you. I want to see a report every month that you've made the payment.
Yes, ma'am.
probation. If there is any violation, please send me an affidavit and a warrant, and I will be happy to sign that. Well, I won't be happy to, but I will sign it. And then hopefully this will get Ms. Lee paid, and then we will see where we go from there. There are additional costs, and
Your
that
Honor,
would, yes.
I'm not sure where we were on the cost of supervision, but given the priority, would probation support waiving of the cost of supervision so that, maybe that had already been done? But maybe the court doesn't want to consider that.
No, I mean, if that will help Mr. Brazil pay the victims, then, well, let me see what probation has to say.
Of course, if the money's able to get to the victims, we'd be willing to waive it.
Okay, so as long as the restitution payment is made, then the court would, I don't ever like to waive anything for probation, but.
So we can only waive it in-house, but obviously if he has proof of disability, which he states he does, so we would be able to waive it in-house. So we have no objection.
Okay, thank you.
Thank you.
So, Mr. Brazil, that saves you about $40 a month right there that you can apply towards the victims. So $400 a month. Will you be able to make that payment? Let's see, today is April 22nd. Are you able to make the payment by April 30th?
Not the 30th, on the 1st, ma'am.
Your Honor,
If I can make it on the 1st, when I get my paycheck in, it might be a benefit on the 1st of every month.
Okay, well then maybe instead of the last day of the month, you make the payments on the 1st.
I'm worried about that there be a 24-hour problem or whatever. There can't really be any excuse. We can't. So could the payment be due on the 5th of every month and the report by the 10th?
Sounds great. All right.
Okay. So that gives you 4 days to clear your check and get it to whatever the program is with working with probation, and then you'll have 5 more days. If it's by no later than the 5th, 5 more days to do the report.
So by May 5th, you need to have paid $400 through correct pay or whatever it is that you have to make that payment. And then you need to file something in writing. You can write it on a piece of notebook paper as long as your signature is on it, the date and the case number stating that you have made that payment in full, $400 on whatever date it was, under penalties of perjury. I want to look in your file and see those reports every month.
You will, ma'am.
Okay. If you do that, you make your monthly payments, and you don't have any other violations, then you will likely never see the inside of a jail cell on this case. But if you violate, if I impose a suspended sentence and there's a violation, I am going to impose the sentence. So be aware, all right?
Yes, ma'am.
Okay, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, and I'm sure Ms. Lee will be happy to receive a payment on or about, if not before, May 5th.
And Your Honor, just to be very careful too, is that in addition to the no contact with the victims, is that I think it's appropriate to restate that existing obligations are reinstated.
Well, yes, all
in
of
case
the...
there are any others.
I mean, I've reinstated under the same terms and conditions and just modified a couple of them. I
So
modified the amount
Yes.
of the payment. I added the special condition of the 11 months, 29 days suspended, and the date of payment, the due date, and this monthly report. That's another special condition.
So except as otherwise altered, existing obligations are reinstated.
Yes, and then there's $100 cost of prosecution for the VOP and a $150 cost of defense fee, if I'm not mistaken.
Yes, Your Honor.
Yes,
And
those
that-
are imposed, those are by
Yes.
statute, I can't fix that.
Thank
I
you, Your
can't do
Honor.
anything about it. So, thank you, sir, and good luck to you.
Thank you, ma'am.
Yes, sir. All right,
Thank you, Your Honor.
thank you. Okay, I've got the score sheet. Let me- Here is. Yes. Thank you to everybody for your patience. It has been a long day, I know. Ms. Farkas?
Yes.
Who would you like to call?
I think that we're going to start with my female client and then just run through the rest of everybody. So this is
Go right ahead.
Samantha Frazier, 24 CF 2301 and 24 CF 2007. The state and the defense have reached a plea agreement. I've gone over it with her. I'm just going to have her sign it.
Go right ahead.
Your Honor, if I may approach?
Yes.
She's
Thank you.
staying on supervision. We're modifying it so there is not a score sheet.
All right. Ma'am, if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. And if you'll state your name for me.
Samantha Frazier.
Thank you. You're hearing case 24 CF 2301 and 24 CF 2007. In both of those cases, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
And did you read and sign the agreement? You just speak up.
Yes, ma'am.
Thank you. There's a court reporter listening and taking down everything we say, so I want to make sure she can hear you. And is that your signature on the back page?
Yes, ma'am.
All right. Do you understand the rights you give up when you admit to violating your probation?
Yes, ma'am.
Is anybody forcing you or threatening you to make you admit?
No. No.
Has anybody promised you anything other than what's showing in your agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medication, or any substances?
No, ma'am.
All right. Ma'am, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. Are you admitting to violating your probation in both of your cases?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered in accordance with your agreement. You will maintain your withhold adjudication in both cases and be reinstated and you reinstated to probation, and we're modifying probation as follows. In each case, well, this would only be on the felony counts, right?
Yes, Your Honor. I apologize. I actually, I intended to include the credit for time served. I think that the misdemeanor, she was given credit for time served in the first place, so I incorrectly included it in the list of charges. There's not actually a misdemeanor on the VOP on the misdemeanor charge.
Okay.
She was given credit for time served in that initially. So it's only the 2 counts. Everything listed here is correct. That there's
Okay.
The 2 counts.
All right. So in both cases, reinstate and modify supervision as follows. And again, this is only on the felony counts, which I believe is
Yes.
all that Ms. Frazier's on probation for. 3 years of drug offender probation. Both cases will be concurrent. And I'm just checking the case number really quickly. There will be a 7 a.m. to 7 p.m. curfew or a 7 p.m. to 7 a.m.?
It's a 7 p.m. to 7 a.m.
Okay.
Though, as always, I'll remind Ms. Frazier that typically probation will work with her to modify that for a work schedule if need be.
If it could just be ordered that it can be modified by probation for employment purposes.
Yes, so ordered, yes.
Thank you, I apologize.
No problem. So to start out with, the curfew will be 7 p.m. to 7 a.m. unless modified by probation to fit with your work schedule. You must complete all original conditions, and this says on here, probation's waiving the cost of supervision. Is that accurate?
That would be accurate.
Okay.
No objection.
All right, thank you. And then there's a $100 cost of prosecution for each case, correct? Okay. And then on case 24 CF 2007, is that the one you want to put the application fee in? Okay. On 24 CF 2007, there's a $100 public defender fee plus a $50 application fee. And in 24 CF 2301, just a $100 public defender fee.
And I've provided a copy with the necessary edits to Ms. Frazier as well as probation.
Okay. And did I leave out any terms and conditions?
No, Your Honor.
All right, ma'am, you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Is this the only thing holding you in jail?
Yes, ma'am.
Okay, you should get out sometime today. You need to see probation before 9 o'clock in the morning,
All
okay?
right. Thank you, ma'am.
Thank you.
Next up is Christopher Cluster.
Your Honor, next is Christopher Cluster, 24 CF 2759.
Okay.
The state and the defense have reached an agreement that I'm just going to have Mr. Cluster sign.
I think there might be another case as well, 24 CF 2770. It just says, well, is that one?
Yes, I apologize. I actually didn't include that in the plea agreement.
I can make the announcement on the record, Your Honor. On 24 CF 2770, the state will be null proceeding in exchange for a plea to 24 CF 2759, and the victim is aware.
Okay, thank you.
Mr. Cluster is just signing the plea agreement.
No problem.
And I do have a score sheet.
Great.
Your Honor, Mr. Cluster does not score prison, so.
Thank you. All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do. Thank you. And if you'll state your name, please.
Christopher Cluster.
Thank you, sir.
Your Honor, I apologize, I didn't announce, but it is on the plea agreement. There's a, like I said, a misdemeanor violation of probation that we've included for the plea offer in the misdemeanor case, so that everything will be closed and he won't have anything holding him in jail anymore.
Okay, so the case numbers are 24 CF 2759 and That appears to be a new law. They're both new. Are they both new law?
Yes.
Okay.
Essentially, yes.
Okay,
They are.
and then the one that the state just announced a null process in exchange for this plea is 24 CF 2770. Then there's a misdemeanor for which Mr. Cluster is on probation.
Yes, correct. Your Honor.
That is 24 MM 3631.
Yes.
All right, so sir, in 24 CF 2759, you're charged with 1 count of criminal mischief, $1,000 or greater, that's a third-degree felony. 1 count of resisting an officer without violence, that's a first-degree misdemeanor. 1 count of threat of death or great bodily harm against law enforcement, that is a first-degree misdemeanor. And 1 count of trespass after warning, which is a second-degree misdemeanor. Have you had a chance to talk to your lawyer about all of those charges and any possible defenses?
Yes, ma'am.
All right, and in 24 MM 3631, it's alleged that you violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is this your signature on the back page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did she answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substances in the last 24 hours?
No, ma'am.
All right, I have a score sheet that shows 11.8 total sentence points. Any objections?
No, Your Honor.
All right. Any DNA?
Not that I'm aware of, Your Honor.
I do find a sufficient factual basis based on my review of the arrest report in 24 CF 2759. Sir, do you understand if you are not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right. In 24 CF 2759, how do you plead to counts 1 through 4?
No contest.
All right. Actually, it looks like is count 3 being dismissed as well?
Yes,
Okay.
Your Honor. I was gonna.
Let me back up. Sir, how do you plead to counts 1, 2, and 4?
No contest.
I accept your plea on those counts. I find it was freely and voluntarily entered. And are you admitting the violation of your probation in 24 MM 3631?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily made. And circling back to the felony case, 24 CF 2759, count 1 will be withhold adjudication, 36 months probation. You must successfully complete an anger management course. You must have a mental health evaluation within 30 days and start any recommended treatment within 60 days. You must pay restitution to the Niceville Police Department in Niceville, Florida, in the amount of $1,639. And you must make minimum monthly payments of $100 per month. No trespassing at the Walmart in Niceville. Let me figure out what the costs are. What are the court costs?
That one will be $515.
$515 in court costs. $150 cost of defense. That includes the application fee. It says in here waive cost of probation. So probation, are you okay with waiving that?
No objection.
Okay, thank you. Count 2, withhold adjudication, credit for time served. That's one of the misdemeanor counts. Count 4, same, withhold adjudication, credit for time served. Does the state have an announcement on count 3?
I would say it will be null processing count 3 in exchange for pleas to the other counts.
Thank you. And in the misdemeanor case for the violation of probation, that's 24 MM 3631. The probation is revoked and terminated, or, yeah, revoked and terminated, sentenced to credit for time served. There is a $100, well, let me check.
It would be a $50 cross fee, $50 VOP fee, and then $50 PD fee.
Okay. $50 PD fee, $50 cost of prosecution, and what was the other one?
$50 VOP fee.
Okay, and a $50 VOP fee. Okay.
Was just reminding Mr. Cluster that he has the 36-month period of probation to pay the costs in the felony.
Yes, so all of the costs on both cases need to be paid during the duration of probation in the felony case. And that includes any previously imposed costs in the misdemeanor case, because you would have had costs when you first pled and got placed on probation. So, anything else I need to cover?
That's it, Your Honor.
Okay.
And I've given a copy to Mr. Cluster.
You have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Did I announce the $150 public defender fee on the felony?
Yes, ma'am.
Okay, good. Thank you. And here are... All right.
Michael Daly is next.
That's 24 CF 878.
Your Honor, the state and the defense have reached an agreement in this case, which I've reviewed with Mr. Daly. I'm just going to have him sign it.
Okay.
And Your Honor, these are misdemeanor counts, so there is no need for a score sheet.
Okay. Thank you. Thank you so much. Sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. Just tell me your name.
It's Michael Daly.
Thank you. You're here on 24 CF 878 on allegations that you violated your probation. You're also here on a misdemeanor case, 25 MM 1014, and you're charged in that case with resisting an officer without violence, which is a first-degree misdemeanor. Have you had a chance to talk to your lawyer about the allegations you violated your probation and also that new charge in the misdemeanor case?
I have.
Have you discussed the plea agreement with your lawyer?
We did.
Did you read and sign the agreement?
Yes, ma'am.
And is that your signature on the last page?
It is.
Do you understand the rights that you give up when you enter a plea?
Yes, I do.
All right. Is anybody forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's in the agreement?
No.
Are you satisfied with the services of your lawyer?
Very much so.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
No, ma'am.
Is there any DNA in the new case?
No, ma'am.
Okay. I do find a sufficient factual basis. Actually, do y'all stipulate to a factual basis in the misdemeanor?
Yes, Your Honor.
Okay.
And we did review the offer from the misdemeanor so that we can resolve them together.
That's great. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
I do.
Okay. And are you admitting that you violated your probation in 24 CF 878?
I am.
I accept your admission. I find it was freely and voluntarily given. In 25 MM 1014, how do you plead to the one count of resisting an officer without violence?
No contest.
I accept your plea in that case. I find it was freely and voluntarily entered. In the felony case, your probation is revoked and terminated, and you're sentenced to 90 days in the county jail with credit for time served. And let me verify it's a $100 cost. $100 cost of prosecution and $150 cost of defense. That includes the application fee. You have 24 months to pay that after you are released, and that would include the other costs as well
Yes,
that
Your
were
Honor.
imposed when the plea was initially entered?
Yes.
Okay. Then, in the misdemeanor case, there will be an adjudication of guilt. The sentence is credit for time served, $270 in court costs, $100 public defender fee, $50 public defender fee. Okay, and 24 months to pay.
Okay.
So, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you.
Thank you, ma'am.
Thank you.
Preston Davis is next.
Your Honor, Preston Davis, 23 CF 199. Mr. Davis is approaching. Mr. Davis has another open case as well. I've spoken with the state attorney, and the offer from the state is incarceratory. So if we could have a continuance to the next miscellaneous date, May 20th, so I can meet with Mr. Davis and discuss the offer.
Yes. Let me make sure the state's okay with that.
State's fine, ma'am. I just wanted to be clear. I believe there's 2 open cases and the BOP. If we want them all to travel together, we have no objection, but he does have a suspended sentence at this point.
I was going to bring that up
Yes,
as
ma'am.
well. So let me get the case numbers. We have, the one we're here on right now is 23 CF 199. Then the new law is 25 CF 524. And then, is there another one?
I believe it's 522 as well, ma'am.
Oh, okay. 25 CF 522.
Is it 24? Yes, ma'am. 522 and 524. They're also all failure to registers.
Thank you. All right, so we will, do you want me to set all 3 of them for May 20th?
Yes, Your Honor, that works.
Sure. And I'll leave, I believe the new law cases are already set for pretrial on June 9th. I can just leave them set and then.
Yes, thank you.
Okay. That sounds good. All right, sir, we will see you back on May 20th at 9 o'clock on your cases. Thank you.
Your Honor, Mr. Davis is informing me he would like me to put in for a bond hearing. I've let him know that I need to speak with him at the jail this week before I do that. But Mr. Davis should know that Your Honor, of course, is very rarely agrees to a bond in violations of probation cases.
I'm
But
also
I will be there with him to discuss.
not prejudging anything, but I'm also going to point out, these are some things the court would consider
Yes,
if
ma'am.
such a motion were presented to me, that the fact that there is a suspended 5-year Department of Corrections sentence, and this is what appears to be the 3rd violation of probation. So, not prejudging, I will consider your motion and I'll grant you a hearing, but those would be some things that I'd be asking about if we had such a hearing.
Yes, Your Honor.
So, okay.
Thank
William
you.
Davis is next.
Your Honor, William Davis, there are 2 cases, 24 CF 614 and 23 CF 155.
Yes.
If I may have 1 second, Your Honor.
Of course.
client sign the plea agreement that we reviewed earlier.
All right. Do you need the noise back on?
No, Your Honor.
Okay.
Your Honor, I apologize. I was under the impression that we had reached an agreement with the state.
No problem.
Say it one more time.
I think that we need, if there's a short continuance possible, it doesn't need to be until the May 20th date. If there is space in the docket anytime before, then I know that we're at the trial cycle.
Yeah, I think May 20th is going to be my next day. I mean, because,
Okay, my client is informing me that he would like to sign the plea agreement.
oh, okay.
And if that doesn't happen, we'd be moving for a violation of probation, because these cases have been kind of tracking. The state has wanted to move for a violation of probation, but there were medical concerns, and then the state and the defense were negotiating this resolution, and if the buck stops here.
Gotcha. All right. Well, I came prepared with hearing dates I can offer as well in case I needed them for any case, so, sure.
Your Honor, I'm not sure that I feel comfortable.
Understood.
I would ask the state attorney to keep the offer open for a very short period of time if possible. I need to make sure that my client understands what he's signing.
Gotcha.
That's the issue.
I understand. That's between y'all. If I had an earlier court date, I would offer it to you, but the only one I have that I can find is May 20th, so.
Okay, thank you.
Yeah.
I understand, I'll sign it.
Okay, perhaps we can pass this case for now, and my colleagues
Yes.
can go, and I can speak with him in the back.
That sounds good.
Okay.
Okay, we'll recall the case.
Thank you, Your Honor.
Sure.
Next is Edwards.
Yes, Carl Edwards.
Next up is Carl Edwards, 2010 CF 871.
Yes.
Your Honor,
Thank you.
I've been speaking with the state attorney about this case. My
Okay.
investigator has been meeting with Mr. Edwards. I'm hopeful that we'll be able to get a resolution by the May 20th date.
Okay,
That's without objection, ma'am. We did discuss if there's some information she'd like to get for us.
wonderful. Okay, so May 20th at 9 o'clock.
Thank you, Your Honor.
Sure, thank you.
Right this way, sir. Charles Emerson.
Okay. That's 24 CF 453, 24 CF 2509, and then there's another case under a different name, Stone Walters, 24 CF 446. So all three of those cases are this gentleman.
The state and the defense have reached an agreement in all three cases, which I've gone over with my client and having him sign it now.
Great, thank you. Thank you.
I do also have a score sheet for Your Honor.
Wonderful, thank you.
No. Your Honor. Just making sure everyone's signed. Okay.
Thank you so much. All right, sir, if you will please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down. If you will please state your name, your legal name.
My legal name is Charles Bernard Emerson.
Okay, are you also known as Stone Walters?
Prior to my name change, yes, I was known as Stone Bernard Walters.
Perfect, thank you, sir. I just want to make sure that I've got the right person for the right cases and we get everything resolved.
You got me, Judge.
Okay, thank you. All right, in case 24 CF 453, you are charged with 1 count of aggravated assault with a deadly weapon. That's a second-degree felony. That carries up to a maximum of 15 years in prison. And count 2 is fleeing or eluding law enforcement, which is a third-degree felony. That could land you up to 5 years in prison. In 24 CF 446, 1 count of fleeing and eluding law enforcement with lights and sirens. Excuse me, I'm just making sure I'm looking at the right thing. Yes, with lights and sirens active. And this charge is a second-degree felony that could get you up to 15 years in prison. The case number 24 CF 2509, the charge is use of the personal ID of a deceased person. That's a third-degree felony that could get you up to 5 years in prison. Have you had a chance to talk to your lawyer about all of those charges?
I have.
Okay, have you discussed the plea agreement with your lawyer?
Yes, Judge.
All right, and did you read and sign the agreement?
I have read over the agreement and I have signed the agreement.
Is that your signature on the last page? It's right there.
You got a beautiful thing? Yeah, that's.
Yes, yes, right in the middle of the page. All right. Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
All right, you understand you're giving up your right to go to trial on all 3 of these cases?
Correct.
Is anybody forcing you or threatening you to make you enter the plea?
No.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
All right. Are you entering the plea freely and voluntarily?
I am.
All right. Are you satisfied with the services of your lawyer?
She is awesome.
That's great to hear. Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
Ibuprofen.
Sorry? Oh, okay. Does that affect your ability to understand what you're doing today?
No, ma'am.
All right, great.
I'm competent.
And I have a score sheet. It shows 18.4 total sentence points. Any objections or corrections?
No, Your Honor.
Okay. Let me just fill it out really quickly. Is there any DNA?
No, Your Honor.
All right, I do find a sufficient factual basis based on my review of the arrest report. Sir, if you're not a U.S. citizen, do you understand the plea could subject you to deportation?
Yes.
All right. And in case 24 CF 453, how do you plead to count 2, which is fleeing and eluding law enforcement with lights and sirens activated, which is a third-degree felony? Is that right?
Yes, Your Honor.
Okay, yes. I just wanted to make sure I was picking the right charge. Okay. How do you plead, sir?
This is the one charge I'm
Yep,
pleading
that's
to,
the one.
correct?
Yep.
Okay. I plead no contest.
I accept your plea. I find it was freely and voluntarily entered. On that count, there will be an adjudication of guilt, and in accordance with your agreement, you are going to be sentenced to 18 months in state prison with credit for all time served. And then let me check on your court costs. Is that $515?
So it's a plea only on count 2, correct?
Correct.
That's 453?
Yes.
That one is 548.
$548 in court costs, $150 cost of defense. That includes the application fee, and you'll have 24 months to pay after you are released. Does the state have an announcement on count 1 in 24 CF 453?
That's null pros for insufficient evidence.
Okay, and what about case number 24 CF 446?
That's no pros for plea to count 2 of the previous case.
And what about 24 CF 2509?
One of them is a duplicate charge because it has Stone Walters and then Charles Emerson.
Okay,
That's going to be dismissed for
I think it's the
jurisdictional
446.
That 446 is the Stone Walters count.
Yes, that's dismissed for jurisdictional purposes.
Gotcha, okay.
And then for the last case, that's for a plea to count 2 of the first case that we talked about.
2509, the most recent case.
Yes, that one's dismissed, okay, yes. All right, so, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you.
They have.
I think John Sinky is next.
All right, this is 22 CF 987.
Your Honor, the state and the defense have reached an agreement in this case, which I have reviewed with Mr. Sinky, and I'm just going to have him sign it.
Excellent, thank you.
And I also have a score sheet.
All right.
Sorry, just making sure I have all the data.
Thank you. Thank you so much. That's okay. Thanks.
I would like to point out that Mr. Sinky's family has been here all day waiting to see him.
Yes,
I always
they
like
have.
to point out if people have family members.
Yes, you have a strong support system. They literally have been here all day, sitting in those uncomfortable benches, waiting to see you, and it is 5 o'clock. They have been here all day long.
Thank you, ma'am.
You're lucky to have such supportive family members.
Yes, ma'am.
All right, sir, if you will just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down if you'll just state your name for me.
John Patrick Sinky.
All right, are you a junior?
Yes, ma'am.
All right, great. Just making sure I've got the right person. And in case 22 CF 987, you're alleged to have violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
And did you read and sign it?
Yes, ma'am.
Is that your signature on the back page?
Yes, it is, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what is on the agreement?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substances in the last 24 hours?
No, ma'am.
All right, and I do have a score sheet. The score sheet shows 78.1 total sentence points, and it does appear we're reinstating and modifying probation. Otherwise, you would have a lowest permissible prison sentence of 37.58 months.
Yes,
So,
ma'am.
all right, any corrections or objections to the score sheet? All right, let me sign that. Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. Are you admitting the violation of probation as alleged in the affidavit?
Yes, ma'am.
All right, I accept your admission. I find it was freely and voluntarily given. And there's a previous adjudication of guilt on the underlying charge. The court, in accordance with your agreement, is reinstating and modifying your probation as follows. You must complete a substance abuse evaluation within 30 days, and you must commence any recommended treatment within 60 days. You must attend outpatient counseling at Bridgeway or a similar type provider. You must maintain gainful employment. You must complete all of your original terms and conditions. The probation termination date is going to remain the same. It's not being extended. There will be additional costs. That's a $100 cost of prosecution fee and a $150 cost of defense fee. That includes the application fee. There's a sentence on here that says waive cost of supervision. Let me check with probation on that. All right, that is granted as well. And did I leave anything out?
No, Your Honor, just, I let Mr. Sinke know, he will have to be reattached to an ankle monitor, so he probably won't get out until tomorrow. And I've let his family know as well.
Okay.
Because that was one of the original terms.
Okay, yes. So that'll have to be attached before you're released, but you should get out. Unless there's something else holding you in jail, you should get out, I would think, tomorrow. But I mean, no promises. I can't vouch for how quickly they'll attach the GPS. How soon does he need to report?
Immediately upon release, so
Okay.
release tomorrow.
Okay. All right. So unless it's like right before 5 o'clock and you can't get there in time, you need to go straight when you get out and go report, okay?
Yes, ma'am.
All right, sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you.
Is there an amount of applications per week or just maintain employment?
We just said to maintain gainful, but he has a job, so just stay employed.
Thank you.
Samaj Warrior.
Can the rest of them go that fast? Can the rest go that fast? Yeah, just a little bit.
Your Honor, this is Samaj Warrior, 2018 CF, oh, sorry.
There you go. Go ahead.
2018 CF 1362 and 2018 CF 2257. I believe the state attorney, I don't know if it's easiest for the state attorney to.
Yes, ma'am. Ma'am, Mr. Warrior was before this court on March 18th to admit to a VOP, and he was reinstated with all original terms and conditions and then was given some additional terms. Subsequent to that, his supervision out of Georgia filed another VOP, but that violation had actually occurred prior to any of this. So we're just going to go ahead and dismiss that subsequent VOP and allow the sentence that was ordered on 3/18 of this year to stand. So there should not be anything else holding him for our VOPs as far as the state is aware.
That is great news. So, sir, the pending violation in your two cases that were just named out has all been resolved on March 18th, and the current violations are dismissed because they occurred prior to March 18th.
That's correct, ma'am. He has been incarcerated since the 18th, so they are not new.
Okay.
And Your Honor, Mr. Warrior did ask if he has to re-sign the waiver of extradition. I don't know if he does, if it's expired or something like that, but I just wanted to put on the record that he has been re-signing it, so I don't know if the jail would present him with that again or exactly how that works. I just want to make sure he doesn't get held here any longer.
I have no idea.
Because it's been more than 30 days since the 18th.
Well, I have no idea how that works. So.
I don't know that there's anything holding him here.
I mean, I don't think, once this is dismissed, then that would be the only thing holding you. So then, you know, is it Georgia?
Yes.
Georgia hasn't been able to come and get you if you've been held, so now hopefully they'll be notified to come and get you. If
And
he's
I can
still
make a
here.
note to follow up with the jail, Your Honor.
Okay.
In the next couple days, and if, you know, if there's an issue, then I will.
Then we will
figure it out.
he needs to come to first appearance or something, and then we'll get resolved that
Thank
way.
you, Your Honor.
Thank you. Good luck to you, sir.
Chloe German?
All right, this is cases 23 CF 1692 and 23 CF 2397. Good afternoon, ma'am. I'm Judge Clark.
Nice to meet you.
Nice to meet you, too.
Travis Case on behalf of Ms. German, Your Honor. If the court remembers, I actually continued Ms. German's case so that I could have Dr. McDonald see her again. I spoke with Dr. McDonald this morning, and at this point, we will be stipulating to the authenticity of the Florida State Hospital report finding Ms. German competent to proceed, but that kind of comes with a caveat. There is concern if there's any sort of real delay in her case that it could cause her to decompensate. So it's kind of one of those where we need to get a resolution soon. And I know I've talked to the state, they're going to reach out to the victim about trying to see if we can't work out something on maybe reduced charges and a reduced sentence if we can in her case.
Okay, so let me make sure that everybody's on the same page, literally. There was a report filed on February 13th, 2025 from the Florida State Hospital. It is signed by Dr. Kristen Harrison, PsyD, who is a licensed psychologist, and are both parties stipulating I can rely on that report?
Yes, Your Honor, I already stipulated it.
Okay, just making sure.
State stipulates.
Okay, and Dr. Harrison in that report is of the opinion that, is it German or German?
It's German.
German. Ms. German has been restored to competency and that she no longer meets the criteria for involuntary hospitalization and that she is competent to proceed. So the court, I did review the report. In fact, I have a copy in front of me. I am making a finding that Ms. Gorman is competent to proceed.
Yes,
And I have an order that I will hand to the clerk to that effect.
Yes, Your Honor.
Sure. And when would you like to set the next hearing?
Do June the 11th, Your Honor, but my hope is the state can maybe get something for us before then and move Ms. German up if possible.
Okay, well,
The issue is, Ms. German we got her to Florida State Hospital pretty quickly after the cases were open, so I have done almost no work on the case up to that point. My hope is that the state can get a little bit of legwork done for us so that we can get it done a little sooner than that if possible.
okay, so June 11th, did you
Yes,
say?
ma'am.
All right, June 11th at 9 o'clock, and of course, if you're able to work out something to bring the case in sooner, anytime I have a criminal court date, if you can give us enough notice, I'll be
Yes, Your
happy to take a plea.
Yes, Your Honor, I will make sure we get that done if we can get something worked out.
Wonderful, thank you.
Thank you so much.
Jessica Jones is next.
I love you. Get your phone.
All right, good afternoon, ma'am.
Your Honor, this is going to be Ms. Jessica Jones. Ms. Jones is before the court in 21 CF 3187. I have a plea agreement to be filed in her case. If I may approach, Your Honor.
Yes, thank you.
It'll be for the 14.1 months, which was, or 14.1 months DOC, which was a suspended sentence.
Okay.
However, her guidelines are actually 18 months. So I don't think that we would announce it's a downward departure because that was the agreement we had prior to, but if the court wants that announced that way, I'm sure the state can.
State, what?
I don't think it's a downward departure because it's a previously agreed upon sentence.
Okay. So, Do I need a score sheet or anything, or is there one already in the file from
I think
the original plea?
have one.
Let me see what we have in the file.
I assume the state had one ready, Your Honor. In reality, the 14-1 is based upon the prior score sheet. Clearly, the additional points
Thank you.
picked up a bit over where we were at prior to
Right.
that.
Let me just see if there's one already in the file with the 14.1 months.
Yes, Your Honor.
Thanks to Madam Clerk, she pointed it out to me. It's docket entry 178, and that is the score sheet. And that does reflect the correct amount of the previously imposed suspended sentence. So what should I do with this one? Just mark on there that it's...
You could hand it back. I'm not sure if we actually need a score sheet because it's the same sentence.
Okay, so then
If there is a JNS involved, we will need a score sheet.
a new one? Or that one, you know what, I better attach that one or print this one out and write on it.
We're gonna announce a downward departure on a previously, on an uncoerced legitimate plea bargain.
Okay. To conform with the previously imposed suspended sentence.
Yes, Your Honor. That was what I was suggesting is this downward departure based upon a previously negotiated sentence.
Okay, let me just write that on here if you'll just bear with me for a second. Now, is that when it's 14.1? So that's not 14 months in one day. It's actually
No, Your Honor. It's-
14 full months and 1/10 of another month, so.
Yes, Your Honor.
About 3 days. Okay. And that's what the old score sheet does say. So, and I wrote on there about the previously imposed suspended sentence. All right. So, ma'am, if you'll please raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, ma'am. You can put your hand down, and if you'll just tell me your name.
Jessica Jones.
Thank you. You are here on allegations that you violated your probation in 21 CF 3187. Have you had a chance to talk to your lawyer about the allegations that you violated?
Yes, ma'am.
All right. Did you discuss the plea agreement with your lawyer?
We have.
All right. Did you read and sign the agreement?
I have.
Okay. And is this your signature on the second page?
Yes, ma'am.
All right. Is anyone forcing you or threatening you to make you enter an agreement today?
No.
Has anybody promised you anything other than what's showing on the agreement?
No.
Are you satisfied with your lawyer?
Yes.
Do you understand the rights that you give up when you enter an admission to violating your probation?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
No, Your Honor.
All right. We already went over the score sheet. Again, this is based on a previously imposed suspended sentence that was imposed by Judge Ketchel. Sir, ma'am, do you understand that if you're not a U.S. citizen, the plea will subject you to deportation?
Yes.
All right. Are you admitting to violating your probation in 21 CF 3187?
Yes.
I accept your admission. I find it was freely and voluntarily given. And it looks like you were previously adjudicated guilty. I think you're only on probation on the felony count in this case, if I'm not mistaken.
Yes, Your Honor.
Okay, great. So the court is imposing the previously suspended prison sentence of 14.1 months with credit for all time served. And that also includes the time that you spent in the Alachua County Jail from October 9th, 2024 through March 10th, 2025. There will be a $100 cost of prosecution fee, $150 cost of defense fee. That includes the application fee. Also, cost of transportation reimbursement to Okaloosa County Sheriff's Office in the amount of $532.65. That will be imposed as well. And you will have 24 months to pay all of your outstanding costs, because you may still have some from when the original sentence was entered, from those costs. Anything that's still outstanding, if it's after 24 months after your release, it's going to go to collections. So if you come see the clerk, once you get released, they will get with you with a payment plan to help out. All right. Ma'am, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
Thank you.
Thank you.
Franklin Green.
Before that.
John, this is Franklin Green before the court in 23 CF 2851 and 23 CF 2852. I have a plea agreement to be filed in Mr. Green's case.
Great. Thank you. After Mr. Green's case, we're probably going to take a quick break since
Yes, Your Honor.
we've all been sitting up here for a couple of hours without moving. I know we're past 5 o'clock. It's been a long day. Mr. Green, I'll go ahead and swear you in, okay? If you'll just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down and just tell me your name, please.
Franklin Eugene Green.
All right. Are you a junior by any chance?
Yes, ma'am.
Great, thanks.
If I may approach, Your Honor?
Yes, thank you.
I do not have a score sheet because it's a modification of probation.
Okay, thank you. All right, sir, in case 23 CF 2851 and 23 CF 2852, it's alleged that you violated your probation in both of those cases. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
And is that your signature on the second page?
Yes, ma'am, it is.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
All right. Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
No, ma'am.
All right. And sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. Are you admitting to the allegations that you violated your probation in both of the cases that I just read out?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. In accordance with your agreement, it looks like you were previously adjudicated guilty on the underlying charges in 23 CF 2851. Actually, it looks like it's about the same sentence in both except for the costs, right?
Yes, Your Honor. The only difference is the $50 application fee.
Okay. So in both cases, modify and reinstate probation. The next 12 months of supervision will be on community control, followed by the balance of supervision on regular probation, correct?
Yes, Your Honor.
Okay, so we're not extending, we're just changing the type of supervision.
Yes, Your Honor.
Okay, great. So otherwise, same terms and conditions. In each case, there will be a $100 cost of prosecution fee. In each case, there will be a $100 public defender fee. In case 23 CF 2851, there will be a $50 application fee. And GPS will be set at $1 per day. And you only have to pay one GPS. You don't have to pay $1 in each case per day. It's just one. And then you must complete all of the original requirements. Did I get that right, Mr.
Yes,
Gates? Okay. All right, sir. Well, did I leave anything out for foster? Concurrent. I knew I left something out. Thank you. Concurrent, meaning running at the same time. Everything's concurrent. Sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank you. All right, we are going to take about a 5-minute break.
Serving the area since 1999.
And then we will
We're an
come back
alternative
and-
health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and...
I'm just going to start going delusional.
All right.
Trayvon Hutchins. This is going to be Mr. Trayvon Hutchins before the court at 22 CF 356. This has been noticed for a bond hearing.
Oh, yes. Okay. Thank you. And Mr. Hutchins is present.
Yes, ma'am.
I reviewed the motion. Whenever you're ready, Mr. Gates.
Yes, Your Honor, I'd like to call Mr. Hutchins if I could.
All right, sir, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down.
What do you want the court to know about granting bond today?
Well, Your Honor, I have 3 kids out there right now, and their mom, she been struggling, whatever, financially, and she needs my help right now, and I just that's my main reason for coming for a bond. My 3 kids and her, they need my help. And I have a couple jobs I know I can get if I'm able to make bond and support that. So I mean, that's really it, really.
No other questions, Your Honor.
All right, thank you. And does the state have any questions or anything?
The state has no questions, Your Honor.
Okay, thank you. All right.
Only argument, Your Honor.
Whenever you're ready, go ahead.
Yes, Your Honor. Mr. Hutchins, before the court, obviously, this is a violation of probation. He and I discussed it. It's not a situation like a violent felony offense of special concern, but he's not entitled to a bond legally. Here, it's a discretionary issue. He's hopeful the court would consider setting a bond. In this case, there is a bond on the other case that he's got. His family has stayed in touch with my office. His girlfriend, baby mommy, has also been in touch with us. You know, he does have ties to the community. He does have a job. He's got, you know, everything that you would normally look for. The issue, obviously, it's a violation of probation case before the court. However, most of the violations, not all, are based upon the new law violation, which would be 24 CF 2294. The court's well aware that I filed a pretty lengthy motion to suppress in that case. That is a dispositive motion, and frankly, I think the court is likely going to grant it based upon the arguments in the motion, meaning that case goes away, violation goes away. He's now back to where he was prior to the violation. He's simply asking the court to consider a bond to let him out. In the meantime, the hearing's been scheduled for, I think, July the 17th at 9 a.m.
Yeah, I know it's in July. Okay, thank you. And state?
Your Honor, the state is opposed to reinstating bond in the violation of probation. As we know, there is a new law violation under 24 CF 2294, where the defendant is charged with trafficking in fentanyl between 14 and 28 grams. The state is aware of the motion to suppress filed by the defense, but as it stands, the state intends to argue that motion. So for the time being, the state requests that the bonds or no bonds stay as is.
Thank you. Anything further?
Just as we said, Your Honor, obviously, this is a situation where it's completely discretionary on the court. We'd ask the court to consider the bond motion itself. Mr. Hutchins does have lengthy ties to the community. He's been in the community for many, many years. He does have employment. We'd ask the court to take that into consideration, along with the fact that I understand the state's position, but I feel the photographs that were attached to the motion are very clear in the basic premises that the stop should not have ever happened, meaning Mr. Hutchins would not have been arrested that day.
Okay, thank you very much. I did review the case. I'm aware that there is a motion to suppress that's going to be heard in July. However, I haven't heard that motion yet, and here's what I'm facing. I'm facing a defendant who was placed on community control in August of 2022 on the charges of attempting to traffic oxycodone, which is a second-degree felony, which was reduced from a trafficking charge with a 3-year mandatory minimum sentence. And then the other count is possession of a controlled substance, which is a 3rd-degree felony. So there was 12 months of community control, followed by 24 months of probation ordered in that case. And then the new law happens. That is alleged to have happened on September 30th, 2024, and those new charges are 1 count of trafficking in fentanyl, 14 grams or more, but less than 28 grams. Now, if your client were convicted on that count, is the mandatory minimum, is it 15 years? I cannot remember.
Based upon the arrest date, Your Honor, I actually think it is going to be the 15 years. I think it changed in October of that year to reflect the 7 and then I think 25, but don't hold me to that, Your Honor.
Okay, it's a lot.
The state's better at knowing what he's looking at on this one than I am right now.
Okay.
I believe it's 20.
Might be.
But I have-
It's a
I have
lot.
to go back and check the date so that I'm not misrepresenting the midman.
Okay, it's a long time, and it's a mandatory minimum sentence. So that means if, sir, if you were to be found guilty of the count 1 in your new case, I would be required to impose that sentence. I would not have any discretion. I would have to impose that sentence. It's 15, 20, I'm not quite sure off the top of my head right now. Then the other counts are possession of a controlled substance, more than 20 grams of cannabis, that's a third-degree felony, introducing contraband articles into the Okaloosa County booking facility, that's a third-degree felony, and then resisting an officer without violence, that's a misdemeanor. So these new charges come along while Mr. Hutchins is on probation, on some serious charges that actually got reduced from even worse charges. A person is not entitled to a bond on a violation of probation. And I am not inclined to grant one under these facts. I have, on occasion, granted bonds in violation of probation cases. I think we have seen a few of those today. They're very different facts than what I'm facing right here. So there will not be a bond on the violation of probation case.
Yes, Your Honor.
So, sorry, sir. We will see you for the motion to suppress, and we'll see how that plays out.
Your Honor, will this be on 6/11? Just to put it on the docket?
Yes, yes, let's do. If it's not already on 6/11, June 11th. June 11th for pretrial on both cases.
Carlos Johnson will be next.
Okay. All right, thank you.
Your Honor, this is going to be Mr. Carlos Johnson before the court. I have a plea agreement to be filed in his case. If I could let him sign, Your Honor.
Yes, of course.
This will be a modification, so there will not be a score sheet filed.
All right.
I want to email them today, as soon as we're done, and then I will follow up as soon as I'm Friday after work. So I'll be here for Friday. Yeah, but they're on community control, so we gotta modify that first. So you might go, you might not. Yeah, do that, and I'll take care of mine. Okay. Mayor Pro Tem?
Yes, thank you. Thank you so much. All right. Sir, if you'll please raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. You can put your hand down if you'll just tell me your name.
Carlos Antonio Johnson.
Thank you. In case 23 CF 1573, you are charged with, or it's alleged that you have violated your probation. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
All right. And did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
All right, great. Is that your signature on the second page?
Yes, ma'am.
Great. Do you understand the rights that you give up when you enter into an agreement?
Yes, ma'am.
Are you entering the agreement freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you to make you admit violating your probation?
No, ma'am.
Has anybody promised you anything other than what's on the plea agreement?
No, ma'am.
Are you happy with the services of your lawyer?
Yes, ma'am.
Great. And, sir, do you understand if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
And are you admitting the allegations that you violated your probation in 23 CF 1573?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. And is this only as to count one? Just checking, actually.
Yes, Your Honor. Count 2 is listed further down in the terms for time served.
I see it. It was Roman numeral that threw me off. Thank you. So is there a previous adjudication of guilt?
No, Your Honor, he'll be adjudicated guilty in
Okay.
exchange for the downward departure. That was kind of one of the key negotiation points.
Okay. So there will be an adjudication of guilt on both charges. Count 1 is possession of cocaine, which is a third-degree felony, and count 2 is possession of drug paraphernalia. Sir, do you understand that that adjudication of guilt will likely result in a driver's license suspension?
And Your Honor, he and I talked about that. His preference was obviously to try and keep the license. Unfortunately, the state wanted the adjudication. He was also adjudicated guilty on a felony, I think it was a possession of controlled substance in Walton County prior to, so his license already was suspended. I was explaining to him that he can do the chemical dependence awareness course, provide proof to the DMV, and that usually will help get that business purpose license.
Okay. And I would have no objection to you getting such a license. I can't order them to give you one, though.
Yes,
okay. And let's see. Adjudication of guilt on both counts. We are modifying and reinstating probation. In count 1, supervision will be modified to the next 12 months of drug offender probation, and the curfew will be 9 p.m. to 6 o'clock a.m. Let me make sure that's all right with probation. Is that time frame good? Okay. The curfew can be modified by probation for work purposes. So if they need to modify to accommodate your work schedule, then they have the authority to do so. Okay, and then followed by, so the 12 months of drug offender probation followed by 12 months of community control.
Yes, sir.
And supervision will be modified to a total of 24 months supervision. Is that starting now? Or?
I'm kicking in my head, Your Honor. I think it'd be better to start upon release to Haven House. That way we're not running into an issue with the community control. That was kind of the key. He can't do Haven House if he's on community control, so that's why we put it out after the drug offender probation.
Okay, so let me make sure I am getting it right.
Yes, sir.
So in count 2, the sentence is credit for time served, and then there's the $100 cost of prosecution fee and the $150 public defender fee, which includes the application fee. Then it says, as a condition of probation, defendant will be required to enroll and complete Haven House bars to bed.
Yes, sir.
Okay, and you'll be required to complete monthly UAs for the term of supervision. I think it's probably a standard term of probation or community control, and especially drug offender probation if you have random. Am I right?
Yes, Your Honor, it is depending on, but I do believe DOT requires monthly, but the state specifically wanted me to put that in there. The plea agreement was monthly UAs.
Okay, at least monthly. All right, and it says the sentence will be concurrent to any other sentence the defendant is currently serving. So how does this work? He goes to Haven House, and I don't mean to talk about you like you're not there. Does Mr. Johnson go from the jail to Haven House, and he's on drug offender probation?
Yes, Your Honor, that's the goal. And His probation was actually being monitored in Walton County. The probation officer in Walton County is the one that recommended Haven House. He also works with Haven House. So my expectation would be that he gets released from the jail, checks in with Haven House, and then goes to check in with probation once he does that. That's typically how it's done, and I'm sure the officer over there knows how to do that. Probation will probably do the check-in at the jail pending his release, so he won't have to check in here in Okaloosa.
Okay, and so then, 12 months of drug offender probation and then followed by the 12 months of community control.
Yes,
and
ma'am.
all of that starts upon release?
Yes, sir.
Okay, so did I leave out anything?
Not that I'm aware of, Your Honor.
Okay. No, you're wrong. All right, great. Sir, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you. Thank you.
Oh, what's your name? Oh, do you decide on the name? Yeah, but have you decided on the name? Have you decided on the name? Oh, yeah. Journey? Journey? That's pretty neat.
Thank you. We were sorting out the details.
Yes, Your Honor, we were just talking, Mr. Johnson, I don't know if the court remembers, his daughter was born, I do believe, yesterday.
Oh.
We were discussing that, and I think the name is Journey, and I was commenting that it's a good name and a good band.
Yes. Thank you. All right, sir, if you will please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. Could you please tell me your name?
Corey Martise Johnson.
Thank you. You're here in case 25 CF 231 and 25 CF 528, and there are allegations that you violated your probation in both of those cases. Have you had a chance to talk to your lawyer about the allegations that you violated your probation?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am, I do.
And is that your signature on page 2?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am, I do.
I think I have 2 score sheets here. I'm just making sure I'm supposed to have both of them.
That may be my fault, Your Honor. The state probably gave me one for the court and one for myself.
Oh, that's fine. I'm going to give you back one. And there you go.
Thank you, Your Honor.
Oh, sure. Thank you. I just want to make sure I didn't need to, do something to both of them. I have a score sheet that shows 30.5 total sentence points. Any objections or corrections?
No, Your Honor.
Sir, if I've already asked you these questions, please forgive me. Is anyone forcing you or threatening you to make you enter the plea?
No, ma'am.
Has anybody promised you anything other than what's on your agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, I am. Yes, ma'am.
Have you had any drugs, alcohol, medicine, or anything like that in the last 24 hours?
No, ma'am.
Are you admitting to the violation of probation allegations?
Yes, I am.
I accept your admission. I find it was freely and voluntarily given. In both cases, it appears you were already adjudicated guilty of the underlying charges. So in both cases, probation will be revoked and terminated, and you will be sentenced to 60 days, that's 60 days, in the county jail on each count, and all of those will run concurrent with each other, both cases and all counts, with credit for time served. In case 25 CF 231, in both of the cases, there have already been costs and fees imposed. These are additional ones because of the violation of probation. So $100, $100 cost of prosecution, that's in each case actually, and also $100 public defender fee, and there will be an additional $50 application fee that will be imposed in 25 CF 231. So let me make sure I didn't miss anything. Covered everything? Okay, great. Sir, you have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you.
All right. Thank you so much.
Thank you, and congratulations, sir.
Charles Jordan, registered.
All right, Mr.
Charles Edward Jordan before the court. It's actually junior. He's before the court in 23 CF 2359, 23 CF 2469, and then 25 CF 500. We have a plea agreement to be filed in his case. If I can get Mr. Edward Jordan to sign. Your Honor, the score sheet shows 44.8 points, so this would be a downward departure on 25 CF 500. It would not be on the VOP cases because we're reinstating and modifying.
Okay. All right. Thank you. Thank you so much. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, I do.
I do.
Thank you, sir. You can put your hand down if you'll just state your name.
Charles Jordan.
All right, are you Charles Jordan Jr.?
Yes, ma'am.
All right, thank you. You're here in case 23 CF 2359 and 23 CF 2469. In both of those cases, you're alleged to have violated your probation. And then in case 25 CF 500, You are charged with 1 count of burglary of an unoccupied conveyance, which is a third-degree felony, and 1 count of petty theft, $100 or more but less than $750, which is a first-degree misdemeanor. Have you had a chance to talk to your lawyer about the allegations that you violated your probation in your 2 2023 cases and also the new charges in the 2025 case?
Yes, ma'am.
Did you discuss the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is this your signature on the next to the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anybody forcing you or threatening you?
No, ma'am.
Has anybody promised you anything other than what's showing in the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
I have a score sheet. It shows 44.8 total sentence points. Any objections or corrections?
No, Your Honor.
All right. That would be a lowest permissible prison sentence of 12.6 months. And is this agreement is this a legitimate uncoerced plea bargain by the state? Okay. Is there any DNA in the new case?
No, Your Honor.
Sir, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
All right. And are you admitting the violation of your probation as alleged in 23 CF 2359 and 23 CF 2469?
Yes, ma'am.
I accept your admission in those cases. I find it was freely and voluntarily given. In case 25 CF 500, how do you plead to counts 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. And in case 23 CF 2359 and in, well, I'm just going to take them one by one. 23 CF 2359. We are going to modify and reinstate probation. This is in accordance with your plea agreement. There will be an adjudication of guilt on all counts in all cases. Modify and reinstate probation. The current termination date will be extended by 6 months. As a condition of probation, you are to enroll and successfully complete the Keaton probation bars to bed. That's a residential treatment program. You must still complete the original requirements, and there will be a $100 cost of prosecution fee and a $150 public defender fee. That includes the application fee. Those will be additional costs imposed in that first case. In 23 CF 2469, modify and reinstate probation. Again, the current termination date is extended by 6 months, and as a condition of probation, you must enroll and successfully complete the Keaton probation program bars to bed. You must still complete all the original requirements. The additional costs in this case are $100 cost of prosecution and $100 public defender fee, and you owe restitution in the amount of $416.30 to Mr. Gregory Thomas. In case 25 CF 500, you are sentenced in accordance with your agreement to 36 months of probation. All of these cases will run concurrently with each other, and all counts are concurrent. There is a $515 court costs. Okay, thank you. $100 public defender fee. As a condition of probation, you must enroll and successfully complete the Keaton program bars to bed. You must pay restitution in the amount of $850 to Miss Lisa Suzette Ellen Martinez. You must have no trespassing at 602 Carnathan, Carnathan Court, Fort Walton Beach, Florida, 32547. And you may have no contact whatsoever with Miss Lisa Suzette Ellen Martinez. And it says on here, waive cost of supervision. Let me make sure that's okay with probation. All right, thank you. And it says on successful completion of the Keaton program, restitution will be due at a minimum of $85 per month. Does that apply to both cases that he owes restitution in?
Yes, Your Honor, that is the total amount of both cases divided by 15. The state wanted him to get that paid within 15 months of completing the Keaton program.
Okay, and so how will it be applied, the $85? Because there's restitution in two different cases. So,
Madam Clerk, how?
That'll be to probation.
So when he pays the correct pay, the $85 will be dispersed evenly between the two days.
okay,
Now we all know, Your Honor.
thank you. Did I cover all of the terms and conditions?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, sir, good luck to you. You will remain in jail until Keaton, do they come and pick up? I mean, hopefully they do.
Yes, sir.
Okay, great. So you'll remain in jail until Keaton comes and gets you. Good luck to you, sir. Thank you.